Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Roaring buzz lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes, stand shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning. Wow, I am so sorry. I did not realize that court was gonna start so early. Feed is up. I'm like, good morning, Paula. I was just chilling, watching a video, and all of a sudden I got a notification from the channel saying, "Oh, we live." One sec. So so I was just like, oh no, I have to go live, because I was like, I thought I did hear yesterday, well, this morning, because I was watching the stream back up again, the last part. And I was like, I thought I heard that the judge said they're going to be in at 8 o'clock in the morning, but I was like, yeah, maybe I misheard it, or I did not see it correctly. But good morning, Paula. Good morning, Lois. I ain't even done my hair or anything, and I'm literally just wearing comfy clothes yet again. I guess it's going to be another comfy day. On stream again, like we don't have enough of those. Happy Thursday. Today is Friday for me, because I don't work Fridays, Saturdays, and Sundays at this job. So it is Friday for me. So very excited. I have had like 4 coffees today, which well. So sorry, I got a notification because Nightbot is taking the trash out today, right now, and I'm getting a notification. But oh yay! Yeah, I know we are very early. Sorry about that, Lois. It was my fault slash the court's fault. Because they just went live. I don't know if they are gonna come back and ask the jury the question that they have like every single day, and I hope they do, about the quality they find it now, like if they were exposed to something and everything, and then gonna go straight to deliberations, or they are just gonna get into court, go straight to the deliberation and start. So we'll see. That I do need as well to put a feed up on my phone for the main channel. So yeah. Oh wow, that's crazy. I hope your day goes quick, as well, and that it's you can enjoy the long the weekend as well. What I was gonna say is I am changing a little bit of plans. We're still gonna follow probably that Rose Padma unaliving trial, the Zachary use out of South Carolina, but oh, I can see. Oh, they are going in. The sound is not kicked in, so yeah, it is Valentine's Day tomorrow. I hope Lee has something arranged for you, Paula. I don't know if Nightbot has anything for me because he never did. No, I'm joking. I'm absolutely joking. What I was gonna say, I can see if I can see it now. I know. I think they're gonna come in now. Uh, I don't hear anything from court yet. The audio is not kicked in. Or does it have audio? Yeah.
At this time, I'm going to send you back out to resume your deliberation.
Here you go.
Thank y'all.
Everyone stand, please.
And we are starting deliberation again. I'm getting the clock ready, getting the clock up. I know I still have to remember that we are 3 hours in. And yep. Fair enough.
Seated. Thank you. All right. Court will be in.
Okay, court is in recess, and until we have a verdict, I need to, again, like I was saying, I need to put the feed up on my phone before we go carry on, and we can chit chat and talk about things. So let me. Oh, they're not even live yet. Good thing I noticed that this one is. So I completely agree, Paula. I because I was saying that you don't need one day in the year to really give gifts to your loved ones, like your partner or whatever. Uh, I don't really agree. It feels like it is a little bit commercial. All of this things just because of the fact of they make special buys and promotions and everything. But if I want to give uh, a gift to someone that I love, I can do that at any time of the year. I don't need to wait for one day of the year to think about the person. Do you know what I mean? So I just think it's like I prefer this the spontaneous side of it. I'm giving because I want to. I'm giving because I love the person and not because society in a way tells me that I have to do it. So like that those sorry, I just don't agree with them. But what I was going to say uh what I was gonna say. So all the games has been reset because of yesterday. So when we are overlapping jury deliberations on the new day, the game resets. So I need just to put um a tick as just saying that we are on verdict watch. Um, but give me 1 second because what I was gonna do is we can do a little bit of trial prep for the new trial, but I'm just need to create a ticker for it. Zachary use trial prep. Zachary use is the new trial that we're gonna be doing, but I have something to say. So today, if the verdict comes before lunchtime, and I hope it does, I am gonna take advantage of having a night off and spend with Nightbot. I've been working so much covering the trials, and I love it, and I'm gonna carry on. But I do want to spend a night with him, and we are hoping to go out for a dinner for a meal, me and Nightbot with some friends. So hopefully if trial the verdict does come before then, I'm gonna end shortly after the verdict. We can still chat about it, but gonna end it there. And tomorrow we are gonna pick up the new trial. And but the good thing is we can speed trial, so we can skip breaks, we can skip lunches, we can skip all sidebars if there has any on it, anything, and the boring parts, because today is only day 3, so we're not that far behind. And I was thinking maybe on Saturday do a short stream as well to catch up, and hopefully by Monday we are live, or we can catch up Monday live. Uh, but I do really need an evening with Nightbot because today he had a less of a good day, and I need to be there for him. So that's the plan. Hopefully the jury will come before lunch. Otherwise, we'll see what happens. But I will be here if the jury does not come back before lunch. But in a way, I certainly hope so. I was thinking that now between we're now waiting on the deliberation, so deliberations are ongoing. We can. I'm not gonna say doing try. We can. Yeah, thank you very much, Paul. I appreciate that. I appreciate the support, and uh, especially today, you need a little bit more support. So what I was gonna do now, we can do a bit of a trial prep. Oh no, no, wait, I lie. I am a big fat liar. You know what, guys? I am a big fat liar because the defense attorney spoke yesterday. So 14 hours ago, I think, while the jury was already deliberating, the defense attorney yet spoke with interview newscaster thing on, like we saw the other day. So I've got that, and I really want to watch, and I have saved it just for us to watch it together. So I'm gonna share the tab. This is an interview that the defense attorney did yesterday while the jury was already deliberating. So make me share that. put this on, and yeah, it is
Thank you,
me.
Alex. Jurors have began deliberation in the murder trial of Megan Boswell. Megan Boswell, the only person who faces any charges in the death of her baby daughter, Evelyn. Those charges include first-degree murder and felony murder. News Channel 11's Ansley Daniel joins us now live from Sullivan County with defense attorney Gene Scott. Ansley?
Yeah, Casey, I'm standing by here with Megan Boswell's attorney, Gene Scott. Thanks so much for taking the time to talk with us right now.
You're glad to.
Well, first off, this morning, a lot of folks were curious as to whether or not Megan Boswell was going to take the stand herself. Talk to me a little bit about why she did not.
We gave it a lot of thought and were at one point leaning toward doing it, but after the medical examiners testified yesterday, I don't feel the state's proved their case, at least it's the cause of death, and we don't feel it was necessary.
And I know that right now jurors are deliberating. So talk to me a little bit about what you hope they're really considering right now and really mulling over inside that jury room.
I hope they're considering all the evidence, but in particular, I hope they're considering the testimony from the both medical examiners and the fact of the latex gloves found in the trash can with the child that had male DNA on them.
And I know there's been obviously a lot of talk about Hunter Wood here in this. And this morning, prosecutors brought forth a piece of, paper from the state of Virginia that, talked about his involuntary, commitment to the mental institute there. But let's talk a little bit about why you want his name to, be said in this trial.
I don't think the only reason his name come up was because that's what Megan talked to Brian Fraley about in her interview. So that's why his name is in this trial. That's in evidence. And the thing about that interview is she was, they initially charged her with a false report in that count. They dismissed that count. And so it's our position that her interview with the TBI was truthful.
And let's talk a little bit about that. I know that you did raise a question in the beginning about why she said, that night she gave them that confession, if you will, but they didn't go to the property until a couple of days later.
I don't have an answer to that. I know they had searched the property on the 23rd with cadaver dogs, and maybe that's why they didn't think it was fruitful.
And I know that a lot of folks have been having their eyes on this trial. Talk to me a little bit about what you want people at home to know.
I just want people at home to know that maybe Megan has been painted with the wrong brush. The girl that's sitting in there beside me in the courtroom, she's not the girl that you're seeing on the videos from 5 years ago.
And what do you want people to know about who she is today?
I think she's a nice young woman. I hope she has a full life ahead of her.
All right. Well, Gene Scott, thank you so much. And again, we expect jurors to be deliberating for quite some time as they're mulling over these 19 charges here in Blountville. We're not sure exactly what time they'll call it tonight. If they do, we are expecting them, again, like I said, to continue to mull over this. And of course, we'll continue to keep you updated on air and online. Casey, back to you.
Ansley Daniel reporting live for us from.
That is interesting. So yet again, we're talking about Hunter Wood, but the thing is, the jury is not watching this, so I don't see really the point of why he's even doing this, because the jury's not gonna watch this until until after the case is over. So, what is he trying to do in case if there is a mistrial? The jury poll is tainted again, and then they can try to move on to another thing or just get the charges dropped. I just don't get it. Why is he doing this? Is he actually planning that? So just a rather interesting act, to be fair. It's it is dubious of why and the why he was doing that for, because behind that is just I don't get it. This defense attorney, it's a little bit, I don't know, maybe weird. It just seems off to me. Sorry, I'm just texting a friend. I am very quick text. So it's just weird of why he's doing this and why he's doing this now, while the jury is deliberating, because he can taint if there's a possible mistrial, which I hope it doesn't, because she deserves to get not get another trial, because can you guys imagine? So it's been 8 days, right, of jury deliberation. So we said it was $30,000 a day. So far was $240,000 spent on the jury because the jury is sequestered. So it's just, oh my days, it's just absolutely complete weird. And I hope it doesn't do that um to that, sorry. So yeah, it's just absolutely crazy that why is he doing this. Okay, now we can move on and talk about our new trial. I am gonna read, and I'm gonna try to do that here. I'm gonna read like a little bit about this trial, the new trial that we are gonna be following from tomorrow. Well, I'm saying from tomorrow. Hopefully, this one has a verdict, because you'll never know. We can be on verdict watching all day, and doing trial prep and carry on watching some parole hearings and see what else happens. But because I don't know how long this jury is going to take. Hopefully not much longer, because it's already been 3 hours from yesterday plus whatever time today. I don't know. Did they ask any questions? Because I wasn't. I did get up when Nightbot told me there was a verdict, and there wasn't a verdict. And then I just jumped, and then I just went literally back to sleep. And I didn't know. Did we had any questions? Does anybody else know? I don't think it did, because I did try to go back into like to watch the stream, and I don't think I seen any. Okay, all right, that's good. That's all right then. I did not miss anything big. So the new trial is from South Carolina, Greenville, and they are actually, this is very interesting. Very interesting that the judge has ordered a 30-minute delay on this trial. So there is being live streamed, but for some reason he has a 30-minute um behind lag thing that the judge has ordered. And I keep saying I need to the feed up so to see if there's anything up, and I keep not doing it. Um so I don't know why he did that. I don't know the reasons why, but because probably it's a big, well, it's not famous, but it's high profile person and a case. So Zachary Hughes is a concert pianist known for memorizing Beethoven's sonatas in a standing trial for the charges of brutally unaliving a woman whose body was found surrounded by rose petals. There you go. That's why it's called the rose petal unaliving trial. At the time of the arrest, police said that Hughes, a Juilliard trained pianist, had no criminal history. Investigators linked Hughes to Parcel, that's the victim, Parcel, through Hughes' friend John Mello. So it's a friend. Hughes is a friend of John Mello, the supposedly unalive Christine Parcel. So they don't have any relation. Did not know. I don't think they known each other prior to the unaliving. They had maybe no interaction with each other. So it's a completely random in a way. So at the time of Parcel's unaliving, she was in a custody battle with Mello over the shared daughter, and Mello was facing charges of custodial interference for taking the child out of the country. The charges against Mello were dropped back in April 2024, just last year. Prosecutors say that they found approximately 1,769 WhatsApp messages. Good morning, Toxic. Welcome, man. Jury is already deliberating. We watched a little bit of an interview with Megan's attorney that he did yesterday when the jury was deliberating, and now we are just doing a little bit of trial prep for a new trial starting tomorrow, hopefully. So, hello. So 1,769 WhatsApp messages sent between Hughes and Mello, including one where Mello asked the defendant to harass Parcel. Additional evidence against Hughes includes a ring video showing a person leaving Parcel's home and riding a bicycle out of the neighborhood. And a search warrant revealed that the bike matching that the one in the was found at Hughes' home. So Hughes' defense has maintained his innocence and had instead pointed at Parcells' fiancée Bradley Post as a potential suspect. Post, who called 911 after finding Parcells' body, is not charged in unaliving, but is facing charge of SA exploitation of a minor and buggery in a separate case. Wow. I did not know that part. I knew about the pedals situation and the case that they are not really connected in a way in terms of a relationship, or it was not like a boyfriend, girlfriend, fiance, husband, or anything. But I did not know that part of the victim's fiance. That is interesting. So they are actually on tape 3 today, but we're gonna probably catch up to that eventually. So that is just like an overview of the case. Now what we can do is watch. There is a couple of videos from our friends from Court TV. We can try to watch that, and then there's a pre-trial motions hearing that we can watch after that, and then that will probably keep us busy, hopefully until the verdict comes, because I'm hoping for a quick verdict today. So yeah, so I'm gonna do that. Oh, thank you very much for that, Toxic. I did reply to you. I am deeply sorry. I did see your message, but I was driving, and then I got home, started eating, and then my mind forgot about it. I'm so sorry, darling. Sorry about that. But thank you very much for the support and for that. I really, really appreciate it. So I'm just finding now the video. Okay. So is this one? I think it's just an overview, maybe, of the case.
Juilliard-trained concert pianist Zachary Hughes is accused of killing a woman who was in a child custody battle with Hughes's friend. Christina Parcell was found with rose petals. Yeah, that's right, rose petals scattered all around her body. She'd been stabbed 31 times. But the mystery doesn't stop there. Court TV's Michael Ayala has more.
That's Zachary Hughes of Greenville, South Carolina. The Juilliard-trained pianist regularly performed Beethoven sonatas and other classical works around town. Then, in 2021, he was charged with murder. Christina Parcell, 41, was found in her home on October 13th of 2021 with rose petals scattered around her.
She was brutally stabbed to death in her neck and head area, approximately 31 different stab wounds by a sharp object, most likely a knife.
Prosecutors say Ring doorbell videos show Hughes entering Parcell's home before the murder and leaving the neighborhood after.
Christina Parcell has a daughter who is around the age of 9, and she was engaged in an extremely contentious custody battle with the father of the child. The father of the child and Zach Hughes are very close friends.
The men aren't only friends, they're also co-defendants in another case. They're accused of sending nude or pornographic images of Parcell to individuals and businesses months before she was killed.
All right, that was Michael Ayala reporting there. So there's a lot to this case. Let's dig in together now. I'm going to welcome back in criminology expert, author, and professor at St. Thomas University, Dr. Debbie Goodman, and former SLED agent and solicitor, currently practicing in the private sector, and a state lawmaker as well, attorney Tommy Pope. So Dr. Debbie, let me go to you first, please, with whether there's any significance you may see with whomever did this murder scattering rose petals around the victim's body.
Absolutely, Julie. I think there's meaning and significance to everything a killer does. And looking at the rose petal and what potentially does it mean in this regard, we know that roses and flowers represent beauty, love, innocence, friendship. And the nature of this crime scene must have been so heinous and horrible with 31 stab wounds. So I think it's almost an intersection, Julie, of love and hate, that the killer absolutely hated this individual, Miss Parcell. And I think it may have potentially been driven by the daughter and her potential victimization and violation. And I think the rose petals actually represent the beauty, the innocence of the daughter amidst this horrific scene of this woman. Also, by the way, her body allegedly was posed and staged. And for me as a criminologist, that also speaks to a heightened level post-mortem of manipulation, humiliation, and degradation.
Wow, this is such great analysis, Dr. Debbie. Thank you for that. So there are some more players in all of this, if you will. So apparently we have, the victim in this case, her boyfriend found her, right? So her boyfriend finds her dead. Now he's facing child pornography charges. So this boyfriend, his name is Bradley Post. He's charged with possession of child porn. And guess what? Police also say that this victim, that she had the child porn as well. So they're saying that these pornographic materials linked Bradley Post with Christina Parcell. Okay, so he finds her dead and then picks up criminal charges. And then there's a little more here. So the daughter that this woman has, the child's father is a music producer, and apparently he has been linked to the defendant. And so they're both facing charges for disseminating nude photos of the homicide victim. So this is wow. We have so many defendants here. It's almost hard to keep track. So let's start with the child pornography. Should that have a place in this homicide trial? The victim said to have allegedly possessed it, her boyfriend as well. Tommy Pope, the boyfriend's a big witness, finding her there dead. Tell me, do you think as a prosecutor you would want this information coming in, or should it stay out?
I think the prosecutor has actually moved to keep it out, to keep it separated. But, when I first heard the rose petal thing, going back to Debbie, I thought, unrequited love, it's always the ex-boyfriend that won't let it go or whatever. But as you look at this, you almost need a dry erase board to write the players, like you said, because Mello, who you have up on the screen now, the father of the child, is good friends with the defendant. I'm wondering, let's leave out the child porn part now, but I'm wondering, is Hughes working as an agent of Mello, so to speak? Is he working as an adjunct to carry out his goals? So maybe Hughes didn't have a direct emotional connection, but he's carrying it out for Mello, who does. We've heard that the divorce was contentious. Now, if you add sexual abuse, I know if I was going through a divorce and my daughter was being sexually abused, I don't want to say what I might do. And so it sounds like he might have done it at his behest, Julie. And so, again, there's layers. And I think the defense, this is when we need Kirk back in. I guess the defense is going to want this in if this shows some type of motive. I mean, it doesn't erase the murder, but it may mitigate it, and it may hang a jury if that's truly what was going on.
Tommy, such sharp analysis. You hit the nail on the head many times there. Was Hughes an agent of Mello's, right? Because we understand that in addition to the homicide charge Hughes has, he also has charges for disseminating nude photos of Christina Parcell. And police say that it was Mello who gave Hughes her phone number, apparently said to harass her. And so there's a link, according to investigators. As you said, Tommy, there's a link. So it's, why did Hughes allegedly commit this homicide? If he did it, was it Mello who, as you said, asked him to? So that being said, and you were right also, Tommy, that prosecutors do want to keep out that child porn. So we'll see. Dr. Debbie, want to go back to you, please. When When we think about something like this, with so many layers and so many players involved, as a criminologist, tell me what you're most going to be looking for and paying attention to as we're getting ready. They're picking the jury today, so as we get ready for this to open up, possibly tomorrow.
Absolutely. And these 4 players, everybody has some level of contribution or question mark for sure. So we're looking at what did Bradley Post have on his cell phone data and his computer. There's allegedly 9 different devices with pictures and heinous imagery of children in sexually exploitive ways. And now we also may have the decedent herself as a participant in this horrendous conduct. And I think Tommy absolutely hit the nail on the head that Hughes acted on the behest of Mello, and Mello, the father of the 9-year-old daughter, probably thought his daughter was being abused and had Hughes take action.
Juilliard-trained concert pianist Zachary Hughes.
Sorry about that, guys. I'm trying to use a new mouse, and it's, yeah, I need to get used to it. So that was interesting. I did not know all those details. If I had known, probably I wouldn't have chosen. But hey, here we are. I just have to roll with the punches, I guess. But I don't think the trial is going to be focused on that anyway. It's going to be focused on the unaliving. So I was just gonna actually typing on the chat. That's like, working from home for me would be very, very hard because I am so very easily distracted. Even doing this, Nightbot is home, I would get so distracted. So I don't think I could do like a very specific job working from home. It would be very, very difficult. Yeah. Well, yeah, fair enough. It's like it's too cold to be outside. Just, yeah, but I think I would distract if I would work from home. I would still distract Nightbot and vice versa because it would be way too easy. So I don't think working from home, like in a very serious job that you have to pay attention 100% of the time, yeah, I don't think it would work for me. I'm distracted too easily. Sorry if I keep looking down. It's because I'm looking at the feed for the trial just to make sure that we don't miss a beat out for the thing. So now we're gonna look another video. It's also a short one, and then after this one, we're gonna do the motions hearing for. It was a pre-trial motions hearing for this case, and I absolutely have no clue what the motions hearing is about. Guess we'll find out together. So hang on, let me find there we go. Video.
A concert pianist is accused of what has been dubbed the Rose Petal murder, and he is soon going to face a jury of his peers. This trial is going to be taking place in Greenville, South Carolina. Now, Zachary Hughes, he's the defendant. He's facing several charges in connection to the killing of 41-year-old Christina Parcell. She was found dead at her home back in 2021 with over 30 stab wounds, and reports say rose petals were surrounding her body. So as we gear up for the trial to begin next week, let's send it over to Court TV anchor Michael Ayala. He's going to have more on this case against Zachary Hughes.
That's Zachary Hughes of Greenville, South Carolina. The Juilliard-trained pianist regularly performed Beethoven sonatas and other classical works around town. Then, in 2021, he was charged with murder. Christina Parcell, 41, was found in her home on October 13th of 2021 with rose petals scattered around her.
She was brutally stabbed to death in her neck and head area, approximately 31 different stab wounds by a sharp object, most likely a knife.
Prosecutors say Ring doorbell videos show Hughes entering Parcell's home before the murder and leaving the neighborhood after.
Christina Parcell has a daughter who is around the age of 9, and she was engaged in an extremely contentious custody battle with the father of the child. The father of the child and Zach Hughes are very close friends.
The men aren't only friends, they're also co-defendants in another case. They're accused of sending nude or pornographic images of Parcell to individuals and businesses months before she was killed.
Oh, this is going to be one of those cases which I understand has a lot of layers. Kelly, you are going to be heading out to South Carolina to cover this for us.
I am, Julia, and it has so many layers. It's complicated because there are so many different players. We're going to have to see what all comes out in this trial. But in South Carolina, they are calling this the case of the century. So we're really looking forward to bringing this story to our viewers. And as you mentioned, a lot of layers to it.
I guess apparently YouTube wants me to play another one, but I think this one is from the Crime Fix one, and I really like their videos, so we're just gonna watch. We have time, so we can devote on this new trial as much as we need and can.
That's Zachary Hughes. He's a classically trained pianist, and now he's accused of murdering a woman in South Carolina. I'm laying out everything that you need to know about the case dubbed the Rose Petal Murder and the death of Christina Parcell as Hughes's trial is set to begin. Welcome to Crime Fix. I'm Anjanette Levy. I want to start by telling you this case has tons of twists and turns. It's sad and really disturbing. So I'm going to do my best to kind of weave you through all of this. The victim in this case is Christina Parcell. She had a 9-year-old daughter. On October 13th, 2021, Parcell was found murdered in her home in Greenville County, South Carolina.
Investigators rushed to the scene and discovered the victim had been brutally stabbed multiple times, resulting in her death.
The solicitor, that's the prosecutor, would later say that Christina Parcell was stabbed 31 times in the head and neck, and there was something about Parcell's murder that seemed ritualistic. Investigators said they found Parcell's body surrounded by rose petals. It's something that seems oddly personal. Why would someone commit a murder and then drop rose petals around the body? Parcell worked as a veterinary technician, and by all accounts, she was well liked, and the crime shocked the community. The Carolina Hound Rescue posted on Facebook a day after the murder. Christina was not only one of the most epic vet techs to our dogs, but she was a friend with a personality the size of a high-rise and always trying to make everyone else feel better. I can't tell you how many times she walked me to my car after an appointment and had me crying from laughing so hard. The dogs loved her, and she did such an incredible job with them. When you are at the clinic, as much as we are, you form friendships with some of the people that work on your dogs. It is hard not to. Christina was one of them. She always had an ear and always tried to make you smile, even in the worst of situations. Now, days after Parcell's murder, detectives took her fiancé into custody. But he was not charged with murdering Christina Parcell. Bradley Post was charged with several counts of sexual exploitation of a minor. The charges stemmed from evidence detectives said they found at the crime scene. After Parcell's murder, investigators said they found thousands of images of child sex abuse materials on Post's electronic devices. A couple of days after that, another man was charged with a crime, but again, the charge was not for Parcell's murder. John Mello is the father of Christina Parcell's daughter. He was charged with custodial interference for taking the girl to Italy in the fall of 2020. Then less than 2 weeks later, Greenville County Sheriff said they made an arrest in Parcell's murder. This man, Zachary Hughes, was charged with murdering Christina Parcell. But why? Hughes was a former Marine and a classically trained pianist who studied at the Juilliard School in New York. He'd later moved to South Carolina. The solicitor said that neighbors' ring cameras captured Hughes entering and leaving Parcell's home, and he also said during a hearing that Hughes's DNA was found under Parcell's fingernails. But what was the connection, if any, between Hughes and Parcell? Well, it's John Mello. Investigators have said that Hughes cleaned Mello's home, and when Mello was arrested for custodial interference, he listed Hughes as someone he could communicate with in the jail. And detectives have said the two talked on WhatsApp a lot, and one of those conversations took place on the day of Christina Parcell's murder. Both men have been accused of harassing Parcell prior to her murder. Hughes has pleaded not guilty, and jury selection in his trial will begin on January 13th. I want to take just a moment to tell you about Upside, the sponsor of today's Law and Crime YouTube takeover. Do pretty Exxon, Chipotle, Taco Takeover for extra cash back. So as I told you earlier, this case is really convoluted with a lot of players in it. So I want to bring in somebody who can clear up the confusion and really boil this down to what it is. And he is Will Folks. He is the founder and executive editor of Fitz News in South Carolina, and he knows everything that goes on in the news in South Carolina. And he's been covering this case from the very beginning. So Will, what exactly is the connection between Zachary Hughes and Christina Parcell? We know that he's accused of murdering her.
Well, that's right. And prior to Zach Hughes' arrest in early November of 2021, there was no known connection between him and the victim in this case, Christina Parcell. So it came as a huge shock to folks when his arrest was announced, because up until that point, there was absolutely no connection between the two of them. Now, as this story has unfolded over the past few years, we have learned that Hughes has a friendship with an individual named John Mello. And Mello is a self-styled music producer who is a former boyfriend of the victim who had a child with the victim, Christina Parcell. And so apparently those two have been connected. In fact, they've been charged together actually with harassment. This took place in September of 2023. Prosecutors in Greenville County charged the two of them with harassment related to some obscene pictures that were mailed to neighbors of Christina Parcell as part of an effort to harass her. But again, this arrest came out of the blue because when this incident took place in mid-October of 2021, for several weeks, everyone just assumed that the person who would be arrested would be the individual who found her body, her boyfriend at the time, who's a gentleman by the name of Bradley Post. However, again, that didn't happen. It went in a completely different direction. And what's even crazier about this story is that the individual arrested, Zach Hughes, not only was there no known connection, but this is like the least likely profile of a ritualistic killer. I mean, this is a guy, classically trained pianist, someone whose background would seem to lend itself to playing recitals, not stabbing someone 31 times in the head and neck area with a knife.
Mm-hmm. And the solicitor down there in Greenville County has said that in previous hearings or in court documents that this is their guy, Zachary Hughes. And the musical connection, that makes sense. But why this guy, Zachary Hughes, would actually carry out a homicide and then put rose petals around Christina Parcell's body, that's just confounding to me. But the solicitor said that Zachary Hughes's DNA was under Christina Parcell's nails. There's apparently video of him with a hoodie on entering the house. So they seem to think they have a really strong case.
Yeah, the forensic case here is very strong. In addition to the DNA evidence that you referenced and the camera evidence, they found the bike that he was allegedly traveling on as he left that neighborhood in Greer, South Carolina, which is a suburb of Greenville, South Carolina, the big population center in the upstate. But yeah, the case against him is very strong. Now, what's also interesting, Anjanette, police are pouring through WhatsApp messages that were allegedly exchanged between Zach Hughes and this John Mello individual, where they go back and forth trading cryptic messages. And there's one really interesting exchange that took place the day of the murder. In that exchange, Hughes is asked how the music lessons went. He responds to Mello, good, I'll tell you. And so police and prosecutors believe that this may have been code for carrying out this, just, again, as you mentioned, graphically ritualistic execution, in addition to the multiple sharp force injuries that the victim sustained. As you mentioned, her body dragged across this home, was posed with deadhead roses or rose petals, depending on who you talk to, sprinkled around her body. So again, whoever, again, was behind this wanted to send a clear message, and folks are still scratching their heads at how that could be Zach Hughes. It just doesn't seem to fit the profile.
So if prosecutors think they were speaking in code, they must not have enough evidence then to charge John Mello. unless John Mello might be cooperating. I mean, I just don't know. I mean, he's out walking the streets as far as I know. And he had been charged with, there was some kind of custodial interference case because he was the father of Christina Parcells' child. He had taken the child overseas. And then there's this whole other aspect of this case involving Bradley Post, Christina Parcells' boyfriend, and there was apparently some sexual exploitation of a minor material found on his phone. So he was taken into custody. And now Zachary Hughes's attorneys, they want to access that because they believe that could somehow help them with their defense, right?
Well, I think it absolutely would help. I mean, here's the thing we've got to remember about this case. We've got just this horrific crime, but the victim was accused of doing some pretty horrific things as well.
Right. There's some bestiality allegations. She worked at a vet's office, right?
Yeah, there are some bad allegations. And in fact, Bradley Post, her boyfriend at the time of her murder, the individual who found her body, he's been criminally charged by the Office of South Carolina Attorney General Alan Wilson with numerous charges, including bestiality, including criminal exploitation of a minor, first-degree charges. And these are charges that carry lengthy prison sentences. So it's serious. Apparently more than 50,000 images and videos of child porn or child sex abuse material, as it's termed now, were located at the scene during the search. And so it's just a mess all around. And so the argument by Zach Hughes' attorneys is, the victim had it coming, I guess is the basic argument.
Wow. The victim had it coming, though. I mean, that's not a defense to murder. I mean,
not in my mind,
I just
no.
I mean, I can't see it. I mean, if there were some allegations that she was engaging in activities with a minor that she shouldn't have been, involving sex, I mean, you call law enforcement. That isn't, you do a murder. So I don't know.
You need only one juror, Anjanette, and that's the problem.
That's true.
You get one of the 12 to buy into that theory that this was a somehow justifiable slaying, then that's all you need. And I'm 100% with you. This United Healthcare thing, as I've seen the reaction to that play out, it's kind of horrible to think we live in a culture that people believe they have the right to take matters in their own hands like that. Hopefully this case won't come down to that. But again, if I'm his attorneys, I want that discussion front and center. I want that jury thinking along the lines of what a terrible, terrible situation was befalling this poor young girl that was in the custody of Christina Parcell. And I want them transferring that to try to think of Zach Hughes as someone who, again, in this horrific way, delivered her from that. That's what I want if I'm a defense attorney.
Yeah, maybe they're looking for one juror or possibly jury nullification. We don't know. Is there any way that Zachary Hughes takes the stand in this trial?
That's an interesting question. We have seen very little out of the defense as far as strategy or what they might attempt to do. All we've seen so far is efforts by the prosecution, which is led by an incredibly capable solicitor, Walt Wilkins, up in the 13th Circuit. He's a very good attorney. He's been up there for a while, knows the courtroom inside and out. He's going to be a very formidable prosecutor, him and his team. But the attorneys representing Zach Hughes, also very adept. So I fully expect this to be maybe not Murdoch level in terms of the back and forth between the attorneys, but very close to that, because these are some incredibly skilled lawyers. And again, the prosecutors want to keep this child porn stuff out. They want to keep it away from the jury. They don't want that to be any part of their thinking. But the problem is Bradley Post, the guy who's been charged with all these horrific child porn charges, he's their witness establishing the discovery of the body. I mean, they literally have to call him. So I don't know how you get out of that. It's a real double-edged sword for the state as they try to prosecute this case.
Yeah. That would be difficult. I don't know how they do that either. It would take a lot of tiptoeing, some very talented lawyering. Well, we will be keeping an eye on it, and we appreciate you coming on to talk to us about it and to try to untangle some of this. We will be watching. Well, folks, thank you so much.
Thank you, Anjanette.
And that's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much.
All right, so that was a bit more like in depth and explanatory about this case that we are gonna be following next. I just hope that we have a verdict on time. I'm scouring the internet just to see if there is any movement or anything, but so far nothing. We are been 45 minutes into today's deliberation, 3 hours and 45 altogether around that time over 2 days. But so far nothing. There hasn't been no questions, no nothing. What my suspicions is that they have made their decision, but they're just going through the paperwork, and because it's just, they are not used to this kind of paperwork, they are just going through with it fine tooth comb kind of stuff like that. So it's just like finalizing and writing things down. I don't think it's going to be much longer, because if like 3 hours and with no questions, that would be a little bit thing, because by this time I think a little bit longer on the Colin Griffith case we would already had the question that they did. So that's just my thinking. My thinking is they have decided the verdict and they just filling out paperwork. I think the paperwork would be taking longer than actually anything else. So yeah, so now we're gonna listen to some pre-trial motions in this analyzing trial. It is a good length one, so we're gonna watch that. And I am gonna take a little break to go to the facilities, and I'll be right back. But I'll leave this playing for you all, and I'll be listening on my phone too.
Okay, I want to make sure that we go through a couple things before we get into the motions. First, I know that we are going to have, obviously, a media presence, and we welcome you. Our courts are open to the media. I do want to make sure that everyone in the media has received a copy of my order. When we were initially going to trial, I had an order, then I did an amended order, and then, of course, I just did an order for this trial that we're in now. But please make sure that you have that. And again, I welcome you to our courtroom. I do want to just say a couple things though, and I think that you all are probably fully aware of this, and this is really for your protection, but you are not to use the name of a minor in any reporting. And also I have gotten a couple questions, recurring questions about my order. There is going to be a 30-minute delay, and again, I just ask that you abide by that order. I also ask that there not be any reporting on anything for a 30-minute delay consistent with my order. And if anyone does not understand that, just please contact my office or the clerk. Okay? All right. Solicitor?
Your Honor, just one housekeeping matter or matter that we wanted to raise. From the defense perspective, Your Honor, we have no objections to the manner of selection and the composition of the jury, Your Honor. Wanted to raise that with you, but we have no objections.
Yeah, and I appreciate you doing that. That was on my checklist of whether or not y'all had any objections to the selection of the jury. Thank you, Mr. Mormon.
And the state does not have any objection either.
Okay.
To the selection of the jury.
So no motions pertaining to the selection of the jury in this matter. Thank y'all. All right. Let me double check. The state had initially filed a motion in limine. Later, the state filed an amended motion in limine. And I think that we will hear that one first.
Yes, Your Honor. The state filed a motion for a gag order specifically regarding the accusations that were alleged by the defense counsel against the victim in this case, Christina Parcell. And it was in conjunction with our motion to exclude evidence relating to the case against Brad Post, who is going to be a witness in this case. Your Honor's familiar with. He's been charged by the state of South Carolina as being prosecuted by the Attorney General's office for sexual exploitation of a minor. That case occurred about 2 weeks. Those charges were brought against Brad Post about 2 weeks after the murder of Christina Parcell, and about the same time that the defendant in this case was charged. And so we filed a motion for a gag order for the purpose of keeping those statements out of the record and out of the press and from reporting on it, because the state felt that it was prejudicial. And it was in conjunction with our motion to exclude evidence of child pornography that is allegedly found on Brad Post. And I say allegedly because Brad Post has not been convicted. He's been charged with sexploitation of a minor first and third, and I believe buggery, based on lots of videos and photographs that were located on his phone and thumb drives and computers. He just happened to be the fiance of Christina Parcell. And so we've asked this judge, your Investor's Honor, one, to keep the defense from putting those in their motions. Put those things in their motions so that that information, which has been unsubstantiated at this point in the trial, and this point in our procedure, and if it was necessary for a filing, to redact it so we could keep it out of the hands of the press and a potential jury. In addition, the state was attempting to comply with the Victims' Rights Act as well, which a victim, in this case Christina Parcell, has a right not to be shamed and ridiculed in the case against the defendant who's allegedly committed this murder. So that's sort of gone on, and that we filed that back in October, Your Honor. And at this point, the state withdraws that motion for a gag order as we've now picked a jury, and so it's basically moot at this particular time. And then we'd like to move on to hear the exclusion of the child pornography evidence or anything related to the Brad Post case in there for the purposes of this trial. I'd like Your Honor to hear that. I know we've done the motions, and I know you have something to say about the gag order.
Yeah, and just for the record, I am, I mean, you've withdrawn it now, but I would be denying that. And just for the record, I have reviewed Nebraska Press Association versus Stewart, N. Ray Murphy Brown, LLC, State, Rec Co. versus State, State versus Price. And again, I would be denying that motion if it was not withdrawn. I also would note the case of Ex parte capital U Drive It, in which it stated, quote, judicial proceedings and court records are presumptively open to the public under the law. And First Amendment of the U.S. Constitution and the state constitution, Article 1, Section 9. I do want to note for the record that at no time has there been any order by any circuit court, any judge here that has ever sealed any of the filings that have been made. It's my understanding, for the record, that the state specifically asked the clerk's office to hold certain filings. And so I just want to make sure that the record's clear, and that the clerk will be instructed to make public any filings other than, I mean, I guess the gag order does not need to be filed. Okay. All right. We will move on with your motion, which is your motion in limine, amended motion in limine.
Yes, Your Honor. Yes.
When you're ready to proceed.
Okay. Thank you, Your Honor. Yes. So the state filed an amended motion in limine to exclude any reference to any evidence of the child pornography. Now, say the alleged child pornography, again, has not been substantiated in any court, as Brad Post has pled not guilty to those cases, to his particular case. All of the items were found on devices in his possession or under his control. And so our first argument, Your Honor, was that in this particular case, in the case of who killed Christina Parcell, Zach Hughes has been charged with that crime. That particular crime that may or may not have been committed by Brad Post has absolutely no relevance to this particular case. And so that's of course our first argument of that. And we highlighted in our motion, Your Honor, the highly prejudicial effect of putting in the fact that child pornography may have been on some of his devices there. And I cite State v. Cooper as well. Evidence we can have no other effect to cast a bare suspicion upon another or raise a conjectural inference that the crime was committed by another is not admissible. But not only is there conjecture, Your Honor, there is absolutely zero relevance to any and all child pornography to this murder case, and there's no nexus, and the defense cannot provide a nexus at this stage in the process. And so, Your Honor, we would ask you to exclude any and all reference to child pornography, which goes to also Brad Post's testimony as well. We've also asked this court to limit the testimony of Brad Post. And for the record, Your Honor, his attorneys asserted a blanket Fifth Amendment protection on his behalf in relation to that. It's my understanding
State v. Lawrence.
State v. Lawrence is the main case on that as well. And the key to that is that he's not an inculpatory witness. He's at the bottom of the chain when it comes to evidence against Zach Hughes. His testimony will be, I've never even met Zach Hughes. I don't know Zach Hughes or anybody that from in the public. And so Zach Hughes, the name of Zach Hughes will not come out of his mouth other than I don't know who he is. So by allowing impeachment evidence, pursuant to Rule 608 and 609, diving into his current charges, because they're not convictions yet, of a non-inculpatory witness is what State v. Lawrence and others stand for. And so when you have a non-inculpatory witness, your ability to go into their potential impeachment sort of diminishes and it lessens as you go forward. All the other cases that we cited, Your Honor, are folks who were eyewitnesses to crime or they were in the car before a murder happened. In this case, Brad Post is merely just going to talk about how he arrived at her house at around 11 o'clock on the 13th and found her deceased body inside his house, her house, and the house where she lived with her sister and her daughter. So we would ask this court to restrict that any mention of that evidence on those grounds in relation to Brad Post, as well as the impeachment. We would ask this court to limit the impeachment or the conversation about his pending charges to, have you been charged with a crime? Would be the extent you can go into his pending crime now that he's defending against. Otherwise, Your Honor, at the end of the day, going into his particular crime would serve this jury absolutely no purpose as to whether Zach Hughes committed this crime or not. Again, at this stage in the proceedings. So we would ask, Your Honor, that. And we would also ask you to restrict the defense's ability to cross-examine him on that particular area. As, again, it's not relevant and it's extremely prejudicial. And I remind Your Honor, if this jury hears about any child pornography related to the victim in this particular case, you cannot unring that bell. You cannot unring that bell. And it is highly prejudicial to the victim in this case. It is a violation of the Victims' Rights Act unless there is a mechanism and relevance and a path to that evidence at some point in time. And Your Honor, the state believes there is no path to that evidence. There's certainly no path to that evidence at this stage in the game, and before the state has even permitted any or presented any evidence to this jury. And so we certainly would ask, Your Honor, to restrict that. And if you do restrict all of those things, we would ask that we don't need an in-camera proffer of Brad Post. As far as the state's questions, we have gone over those. I've submitted those to the court. I've submitted those to defense. Brad Post has responded to those. He did not assert his Fifth Amendment right on any of the questions that the state begins to ask. And so by allowing the defense counsel to get up here and ask him questions they know he's going to take the fifth on, or in that square box of child pornography related questions, it would really just allow them gratuitous information into the world that has no bearing on this particular case. And so we would ask Your Honor there's no reason to have an in-camera hearing and restrict their cross-examination and of course our direct examination to non-child pornography related testimony regarding the defendant and the victim in this case.
Anything else from the state?
Not at this moment.
Mr. Moore?
Your Honor, may it please the court. First, a timeline I think would be useful. The state moved to exclude this evidence in September of 2024. In November, we had a bond hearing for our client. After the bond hearing, the state instituted the motion for gag order, and sometime around there amended the motion in limine. So, Your Honor, I would argue that timeline, I don't think necessarily they were in conjunction with each other. Your Honor, this I just have to deal with this from the get-go. The state has told Your Honor once again that these allegations related to the child pornography are, quote, wholly unsubstantiated. This is a refrain that we've seen repeatedly in the pleadings from the state. We have made it very clear in our pleadings in response to theirs that we in no way want to discuss this topic irresponsibly, discuss it gratuitously, but over and over again, when the state alleges that it's wholly unsubstantiated, we just have to address that, Your Honor. It is highly substantiated. We have evidence to show that. And as an officer of the court, I've represented that in pleadings. Mr. Moyer has represented that in pleadings. And that evidence exists, and we're prepared to introduce that evidence. But I want to set that straight. That evidence exists. We're prepared to show it and prove it. As it relates to what the ask is in the motion, extraordinary relief they are seeking. 16,000 or more images of child pornography. We have photographs. We have videos. They want Your Honor, without having seen any of it, without having it introduced at trial.
Sorry for the interruption, guys. So I just got a notification on X and everything. So, and this is from the Megan Boswell trial, just to give an insight. We're talking about Megan Boswell trial, the trial that we are currently watching the clock going for the deliberation. We are verdict watch. So it says this is from the law and crime lady, Kathy Rousson, that says, on a ridiculous note, the judge of the Megan Boswell trial has restricted media when the verdict is read. No audio when the verdict is read. The judge doesn't want the juror's voice heard. He will then let the camera operations know to turn the audio back on, and the verdict will be repeated. So, I mean, he says the names of the jury in court when he knows that there's cameras around. So we've listened from yesterday names of juries, and even today, because they were waiting on the jury for someone to come, or even last night or whatever when it was. So we know the names of the jury, but now we cannot listen to the verdict live because he doesn't want the voice heard. I'm sorry, but I find that a little bit stupid. Because this is like, I don't understand. How can you identify someone by their voice? It is easier by the name that we've been listening to than rather the voice. It's just like, I don't get it. Like, what is he scared of? That we're gonna duplicate the jury voice? I'm sorry. Rant's over, but this really annoyed me. So Zachary Hughes is accused of unaliving Christine Parcell. He did not have a relationship with, but his friend John Mellows, I think it was John Mellows, had a relationship with her, and then she got unalived, and there was she was stabbed pokey 31 times, and then rose petals were left around her body and around. So that's basically the synopsis. Yeah, basically. Pickles put it very, very, very nicely. Yeah, very nice. Thank you, Pickles. That is amazing. Fantastic. Thank you. So yeah. So when the verdict will come for our trial of Megan Boswell, we can't hear the voice of the jury, because somehow we're gonna find them, and somehow media is gonna find who the jury is. The jury can literally go and talk to the media, and it's their voice. We know their names, some of their names. I can go back on my stream, right, or anyone else's stream, and listen to the jury's names and probably find them even easier. It's like, this is I'm sorry, but this is absolutely ridiculous. If he was so worried about, right, about like anything, he could have put half an hour. Exactly. It did, but now he's worried that we're gonna hear his voice, the voices of the jury. I was like, absolutely. Are you serious, sir? If you were so worried, why did you not impose a 30-minute delay on the case? He couldn't have done that. He has the power to do that. There was motions about it. So I don't understand why now. Oh, like we only gonna put we're gonna. I judge honestly. If you don't want to do something, don't do something. Now no audio when the verdict is read, because you don't want the jury's voice to be heard. Okay, fair enough, judge. I really like this judge. Right, we had fun. Like, he was fine with all this orange stuff and this space shuttle and everything. It was awesome. But now this is, it's a little bit, I don't like it. It's ridiculous. I'm sorry, but it is. Runs over. Let's carry on listening.
Any exhibits whatsoever to categorically exclude 16,000 or more pieces of evidence that we may or may not seek to introduce. So they want, Your Honor, again, to, from the bench, without any evidence introduced of any kind, without opening statements, with nothing, they want, Your Honor, to exclude that evidence.
Mr. Mormon, assuming that that is the case, their point still is, I don't care if you have 45,000 videos, it's still not relevant, is what they're saying, if I understand correctly. So relevant being makes a fact and issue more probable than not. It is highly relevant. There are cases that discuss relevance in the context of Rule 402. Relevance relates to evidence that helps the jury get at the truth. All right, and I would actually cite State versus Sweat for that proposition, and I can give you a cite on that. But relevance is evidence that assists the trier of fact, in this case, the jury, to get at the heart of the matter, to get at the truth of the case. Right? And the truth of the case, the bases for the relevance in this case are enormous and will become much more clear after the trial starts. And that's one of the reasons why, Your Honor, should at a minimum decline to rule on this issue until the trial starts and Your Honor can see some of the evidence and what the cross-examinations are. But Your Honor, to again, in a vacuum, to exclude this evidence before Your Honor's had a chance to review it, before it's even offered as evidence, I'm not even sure how you do the 403 analysis, right? Because it's such a fact-intensive analysis. The other thing is, when the state argues that it talks about prejudicial evidence, absolutely. Every piece of evidence the state seeks to offer against Mr. Hughes, they believe is prejudicial to Mr. Hughes. Every piece of evidence, should we decide to do that, we offer is going to be prejudicial to the state. But it's not unfairly prejudicial. This evidence is not unfairly prejudicial, Your Honor, because this evidence came to pass based on, in no small part, the actions instituted by Brad Post, who was engaged in this illegal conduct with Christina Parcell. So, Your Honor, it's highly relevant. Your Honor, at this time, there was a discussion about the impeachment and the nature of the charges. Oh, I also want to clean up one fact, and then I'm going to turn it over to Mr. Moyer. The state indicated that in the timeline that Ms. Parcell passed, and then a couple weeks later, Mr. Post was charged with violations of South Carolina law. The timeline is this, that Ms. Parcell passed on October the 13th, that there was one warrant for for sexual exploitation of a minor, 3rd degree, obtained by the Greenville County Sheriff's Office on October the 19th. So 6 days. 6 days after law enforcement obtained an arrest warrant for Mr. Post. And they continually obtained warrants after October the 19th, culminating, I believe, on November the 23rd, wherein they obtained an arrest warrant for Mr. Post for criminal sexual conduct with a minor in the 3rd degree. But I just wanted Your Honor to be aware of the fact that 6 days afterwards, the Greenville County Sheriff's Office obtained a warrant for Brad Post. Now I would defer to Mr. Moyer to talk about cross-examination related to Mr. Post's pending charges and applicable sentences or potential sentences.
May it please the court, Your Honor. So there are really two issues that are associated with this. Is one, should we have an in-camera hearing for Mr. Post? And the second is, what can we ask Mr. Post about his pending charges? So beginning with that first issue, I think we clearly need to have the hearing, Your Honor. The state expressed concern that we don't want Mr. Post just being asked a lot of questions that he's going to plead fifth to. Well, that's exactly why we need to do this outside the presence of the jury, so we know what he's going to plead to fifth to and what he's not. So we're not just stopping every few questions, having to send the jury out and then hash it over. So, we're prepared to ask him the questions. We're prepared to hear what his answers are, and if he's pleading the fifth, and if he's doing so properly, then we can let that lie. But Your Honor needs to be able to vet him, to make sure that he's not pleading the fifth irresponsibly. That is a question that he should answer, then he needs to answer it. So we would ask that we have that hearing tomorrow morning. We think the hearing should last 30 minutes or so. So I think that would be a wise use of the court's time and would save a lot of problems throughout the trial. The second issue, Your Honor, is whether or not the the defense is allowed to cross-examine Mr. Post about his pending charges and about the penalties. And if it pleases the court, I did prepare a brief, we did prepare a brief memorandum that talks about some of the cases that I'm going to mention now. And Your Honor, just to give you a little background, Bradley Post faces 9 different charges. So he has one charge of criminal sexual conduct with a minor 3rd degree. That charge is violent. It carries up to 15 years in prison, and it carries an automatic sex offender registry. He has 5 counts of sexual exploitation of a minor 1st degree. Those charges are violent. They carry sentences that range from minimum of 3 years with no parole to 20 years, and sex offender registry is discretionary. He has 2 counts of sexual exploitation of a minor 3rd degree. Those carry up to 10 years in prison and discretionary sex offender registry. And then he has a charge of buggery that carries prison for up to, that carries a 5-year straight prison sentence with mandatory sex offender registry. Now, Your Honor, the law in South Carolina is crystal clear that the defendant's Sixth Amendment rights are violated if he is not allowed to question a state's witness about pending charges and the penalties. I'm not aware of a single case in South Carolina where the defense was prohibited from cross-examining a state's witness, and on appellate review, it was not ruled to be error. And that goes not only to naming the charges, but to bringing out the penalties. And I'll go over 4 cases very quickly in a minute. But before I do, I think what is especially telling on this point is the fact that the case that the state uses, State v. Smith, is a case in which the Supreme Court ruled that it was error for the defendant not to be able to cross-examine a witness about the charge that was pending against him. In that case, they just mentioned that he had pending charges. The defense was not allowed to go into what the exact charges were, and the Supreme Court said that was error. Now, in that particular case, they found it harmless error, but it was error nonetheless. And there are multiple.
Mr. Moore.
Yes, sir.
And I know I'm interrupting you.
That's quite all right.
As we go along to ask questions. In that case, the witness, was it someone who was a co-defendant?
Your Honor, in that case, no, it was not. It was someone who testified. He was a victim in the robbery case. He testified about identification of the robber who was the defendant in that case. That person had pending carjacking charges. And actually, in that case, what happened is the state actually dismissed that charge that morning in an attempt to try to keep the defendant from being able to ask about it. This was actually a PCR case, and Supreme Court ruled that it was deficient of the defense attorney for not pressing that issue and striving to have that charge named. Again, in that particular case, it was found to be harmless. There are a few cases where the courts have found it harmless error. There are many where the courts have overturned convictions, murder convictions. And so basically what you're being asked, it appears, Your Honor, is to just go along with the erroneous ruling, and let's just hope that the Court of Appeals finds it harmless. So so that's State v. Smith. Now there are other cases, Smalls v. State. That is a case where the Supreme Court overturned the conviction because the defense attorney was found deficient for not attempting to impeach the witness with the charge and potential penalty. There's a State v. Gilliam. There, it's a burglary case. There was a co-defendant in that case, and the defendant was prohibited from questioning the co-defendant about the penalty for burglary first degree, which was 15 years to life. And the Court of Appeals found that to be error and overturned that conviction. State v. Mizell. In that case, the defendant was denied permission to question a witness about pending charges and was denied being allowed to ask about potential sentences, and the court overturned that conviction as a violation of the Sixth Amendment. And then State v. Sims, Your Honor. In that case, there was a state's witness testified, had numerous pending charges unrelated to the murder case that was before the court. He had drug charges, grand larceny, robbery charges, and the court ruled that the specific charges could, the trial court said that the specific charges could not be mentioned, only that he had pending charges, and that was found to be error. So, Your Honor, in this case, I think the law in South Carolina is crystal clear that when a state's witness is cross-examined and he has pending charges, he can be asked about what those charges are and what the penalties are. And so, Your Honor, we would seek to do that.
Does it matter to you that it's the AG's office as opposed to the solicitor?
It's the same party, Your Honor. It's all the state. So that does not make a distinction. It's in the 13th Circuit. It just happens that and I don't think it matters. I think the charges could be in Richland County. It could be in North Carolina. What matters is there are pending charges. And the implication is that somebody testifying with pending charges, even if they don't have a deal, in fact, it's even more relevant when they don't have a deal, because the courts have ruled that that person is going to be going out of his or her way to try to ingratiate himself to the prosecution so that down the road, when he or she comes before a court for sentencing, that person can say, Judge, I cooperated with the state. You need to take that into consideration. I testified. And so whether there's a deal or not, whether it's in 13th Circuit or not, whether it's being prosecuted by Mr. Wilkins' office or not, they're pending charges and they need to be asked about.
So that's your argument for 608 see bias.
Yes, sir.
Anything else, Mr. Moore?
Not this time. Thank you.
Anything from the staff?
Yes, Your Honor. Briefly, now I'm going to have Mr. Hoforth respond to the Smith case, but Your Honor, this is a simple issue. The defense cannot establish any relevance whatsoever to the case against Brad Post. That, number one, I can't give Brad Post any deals because I'm not prosecuting him. So it is very relevant, that issue. But what is on Brad Post's phone has nothing to do with this case, and they still can't establish a nexus to it. They can't establish any relevance to any of that. And until they can do that, there's no reason this jury needs to hear anything about what's going on with Brad Post and his separate crime. Because, Your Honor, whether they like it or not, Brad Post is not on trial here. Zach Hughes is on trial here. And so the fact that Brad Post may have child pornography on his phone really has no place in this courtroom here today. Mr. Hoforth is going to respond to the State v. Smith, and I think it's related to the fact that Mr. Post is not an inculpatory witness, and that's what they keep not wanting to talk about. All the cases that Mr. Moyer is talking about have an eyewitness to a crime, somebody that's very inculpatory to the defendant. Mr. Post is not going to inculpate Mr. Hughes one iota, and therefore your ability to go down a rabbit hole into some pending charges that he's not pled guilty to is limited in that respect.
Thank you, Your Honor, and I'll be as brief as possible, but it's important to start with the foundation here where we're talking about the testimony of Brad Post specifically and the nuance with this case with the backdrop of South Carolina law. I cited Smith and Mitchell in the state's brief because they are the most pointed to the circumstances related to this case, but really the circumstances related to Brad Post's testimony go a step further to warrant the exclusion of such cross-examination as to the sentencing he might potentially be facing, or even the naming of the specific charges. I'll note that the two cases that Mr. Moorman went into great detail on, Gilliam and Mizell, both of those instances are where the witness is charged with the same crimes that the defendant is facing. So obviously that would be probative upon cross-examination to even if there's not a deal in place to pry as to the potential bias of that specific witness. But starting with your ability to tailor this to the specifics of the case, and that comes from the United States versus, I'm going to mispronounce it, but Frederick, F-R-E-I, right? Frederick. It really needs to be a case-by-case analysis. And in Smith and Mitchell, those two witnesses were eyewitnesses, inculpatory witnesses to the crime itself, and then charged with collateral, offenses. In both of those cases, the Supreme Court or the court held that the only essential information that was excluded from cross-examination was defense counsel's latitude in being able to name the specific charges with which that witness was charged with. Not to get into sentencing, not to get into what they were potentially facing, only what the specific charges were. Now, this does also go in conjunction, like most all things in this case, going back to the state's motion and why we filed it with such advance to exclude such mention of child pornography in this case, because we are necessarily eliciting on direct examination that Mr. Post is charged with a crime. Yes, that he is currently in jail. Yes. But as soon as the cross-examination comes out and the question is asked, well, you're charged with criminal sexual exploitation of a minor, that opens Pandora's box in the present case. And of course, looking back to exactly what he's testifying to, he doesn't know who the defendant is. He did not know at the time of the crime, on October 13th, 2021, who the defendant is. He is testifying necessarily because he found the body of Christina Parcell, because he received envelopes going toward the harassment charge of Zachary Hughes. And mind you, he didn't even know who sent those harassment envelopes. And he's testifying to the blanket to the bare minimum that he was in a relationship with Christina Parcell to explain why he would show up at the house on the morning of the 13th. This is not an individual who says this is Zachary Hughes who committed the murder, who provides any evidence towards attributing Zachary Hughes to committing this murder. So it is completely within your discretion to curtail the cross-examination, to not elicit the charges, but certainly not the sentencing that he faces and opening that door.
And Your Honor, I'm referring to 610B. It says cross-examined on any matter relevant to the issue in the case, including credibility. So even the rule contemplates relevancy.
And may it please the court. And the relevancy, Your Honor, is bias. And that is a hugely relevant point in any cross-examination. I'd like to read just a little bit from State v. Gilliam. It says, the fact the witness has yet to reach a plea bargain or been found guilty should not prevent the admission of such evidence. The lack of a negotiated plea, if anything, creates a situation where the witness is more likely to engage in biased testimony in order to obtain a future recommendation for leniency. Accordingly, we conclude the Court of Appeals erred in holding the trial judge properly excluded testimony concerning Steele's potential sentence if convicted of the same crime as defendant. Included in the confrontation clause protection is the right to cross-examine any state's witness as the possible sentence faced when there exists a substantial possibility the witness would give biased testimony in an effort to have the solicitor highlight a future court how the witness cooperated. So there's no distinction about whether the person is testifying about something that's inculpatory or not, about what the nature of what the person is testifying is about. And if the state can find any case where it makes that distinction, we would love to see it because it's not there. And because oftentimes we don't know when a person testifies, sometimes it does not become clear how significant that testimony is or what implications there are to that testimony until down the road we start hearing from other witnesses. It just comes down to the fact that if it's a bright line rule, if he is pending charges and he testifies for the state, then it can be asked about. And just one other point, Your Honor.
On that case, the witness, it was Page in State versus Gilliam?
Let me look at my notes, Your Honor.
Was it a co-defendant? Was it somehow tied in with the crime?
I think Page was a co-defendant in that case.
So what you're, and just with I think with the Gillian case you had, it was a murder case. He was tried for murder. The murder burglaries. Well, the murder weapon was obtained in a burglary previously that Page, the cooperating witness, participated in. But I would just reiterate what the import of their argument is, Judge. If the witness is really testifying about something that hurts the defendant, then he can be cross-examined on this. But if it's really not that big of a deal, if it's not too inculpatory, then his credibility is not a big deal. There's just not distinctions out there on that. If they put this witness on the stand, this witness has a motivation to curry favor, to get help on his pending charges, then that's open season. That's what the confrontation clause allows. And what Mr. Moyer has said is so true, that case after case after case, trial courts have been reversed when they've sought to limit cross-examination on pending charges and on possible sentences. There's no distinction that we've been able to find in that, period.
You're going to have a witness up here just asserting the fifth over and over and over. And of course, that gets to why you feel like you need to have the in-camera hearing.
And
when the Fifth Amendment and the Sixth Amendment
But Your Honor, there's no conflict here because by saying what he's charged with, that's a matter of public record. By talking about what the possible penalties are, in doing that, he in no way, that's not inculpatory. He says, I know I've been charged with this. I mean, it's like when he's arraigned and they ask him, do you know the nature of your charges and the possible penalties? He says, yes, that's not incriminating. So I would argue there's no conflict here between the Fifth and Sixth Amendment as it relates.
The Fifth trumps
right.
The confrontation clause.
If there's a conflict, but if he's
all right, guys, there is breaking news. Apparently, a court watcher that is known in the community of LawTube has said that there is a verdict. We are investigating if there is actually is or not. So give me just a moment. I'm gonna swap to the feed anyway, even though we're not gonna be live. We're not gonna hear until the jury said. So yep, it is confirmed. So guys, here we go. Hang on, where's the music? Where's the music? There we go. All right, so after 4 hours and 30 minutes of deliberation, the jury has reached a verdict in the Megan Boswell trial. So they took about 4 hours to 4 hours and a half to deliberate. So altogether will be 4 hours and a half. I needed to make the calculations to see who won, and I will announce the winner shortly. I mean, we're gonna have a bit of time because, as I said previously, sadly, there is no audio when the jury is reading the verdict. It's gonna be read by possibly the judge after the jury is gone or even present. We don't know. We're just gonna go along for the ride. So, looking at the thing, so was 1 hour and a half. So witness, I need to have a look. Give me a moment. I need to look at my thing and then mark down people. Wow. I am in a bit of a predicament because it was at 1 hour and a half 1 hour and a half today. And yeah, she's not there yet. I think they are gonna haven't brought her back. Looking at my spreadsheet that I did with everyone's guesses. Oh, let me text Toxic. So is Pickles in chat? I'll text Pickles to bear with me 1 second. It's just letting Pickles know there's verdict in case he was in chat. Everybody else, Marie is here, Daniela is here. So I have already texted Toxic to say there's a verdict, so to give her time to arrive for it. So Pickles, yay, welcome, yay, Toxic, you here. Pickles, I have texted Pickles. So hopefully they will be Pickles will be here soon. Nightbot is here, everybody's here, everyone is excited. In terms of the verdict game, because I've restarted the clock today after yesterday, like we normally do in our game. Why is there someone in the witness stand? Who's that? Sorry, I get distracted very easily. So, oh, hey, Willow, you made just in time. Oh, good morning. You made it just in time, Willow. Wow, that was perfect timing. So the person that was closest to was Pickles. Pickles has won the game. So, so congratulations, Pickles. When Pickles, I noticed Pickles is in chat. I will announce it again. So don't worry, Nightbot. It's absolutely fine. I did went back and I did some research. It's absolutely fine. So Pickles won. Oh, congratulations! I will talk to Pickles. I will sort it out. The prices are being done as we speak. I need to text somebody else to say that the verdict is in. make sure everyone knows, and if possible, they are near the near a computer, near a browser to have. I know Pickles, I think, is gonna be upset because I think Pickles is working, and he might get it because the thing is, we're gonna be on a slightly delay, guys, because the judge has decided that they don't want us to hear the jury's voice, even though we've already heard some of the names of the jury. But okay, we need to be patient, and um we are gonna yeah, be on the delay. Sorry again, I did burn myself early in my tea because I drank it when it was too hot, and now it's getting cold, so borrow me a moment. Not borrow, but allow me. But anyway, you guys understood. Oh, but my days, that was like, I'm so happy. Pickles won. Who knows, maybe next time is your turn. um Oh yeah, sorry Danielle, the Nightbot got you. I need to turn that off. Not Nightbot 95, the proper Nightbot got you. My apologies for that. Maybe just, yeah, no. Don't worry, Pickles in the beginning got Nightbotted a lot with the cap situation. Sorry about that, telling. Oh no. Sorry, you were got him down for 5 seconds. I'm so sorry. I need to turn that off. So that's perfect, Danielle. So yes, Paula, but that was because altogether. So from yesterday and today, I do with the verdict game is I when it goes over a new day, it resets the clock. So altogether was 4 hours and five, but because it was over 2 days, on the second day, on the day there's the verdict, I reset the clock. That's how we've been doing so far. But I really appreciate that. You are amazing, and thank you for that. Sorry, I'm just putting the 4 hours and that the all together on our spreadsheet. So because we have a spreadsheet, I need to show you guys. Our spreadsheet is getting fuller and with a lot of information, and maybe soon I need to do um it's okay. It's absolutely fine. You are excited the Pickles won. I am very excited too. I just want to hopefully Pickles doesn't miss this because we've all been through this case together, and I don't want it to for Pickles to miss it. I think I've texted everyone. I think everyone else is here and present and then accounted for. Make sure just you press the like button. It does help the channel out. Share the channel if you don't mind, and everything. We're trying to grow a little bit more the the channel, be a good community for people to come and enjoy court cases. And so the thing is, there is another possibility, right? So if Megan gets charged with the first degree and unaliving, there might be a sentencing phase. But I really want to start a new case tomorrow. So what we might have to end up, it's getting a day, maybe over on Saturday or something, to do the penalty phase, because I don't think it's going to be that long. So yeah. Oh yeah, thank you. Oh wow. Sorry, 1 second. They haven't. So it's just a friend that wants to. Oh wow, she just literally landed. I don't think she. But yeah, thank you, Toxic. I did see the ODM. I really appreciate that. But yeah, so the judge is not allowing audio read by the jury because he doesn't want media to have his voice, even though we already know some of the names, but it's not here or there. That's fine. But we are going to find out, because after that is read, and I think maybe they're dismissing it or something, the judge is gonna be reading the verdict. I hope that's what was said on social media. There was someone that is very trusted that tweeted that information, and I do believe 100% in that. So it is very weird. I got very upset earlier and ranted over it. And I need to take the headphones off because it's already annoying me. So I don't know why, because the thing is, right, yesterday we heard some names of the jury. So I don't understand why why we can't hear it live. And absolutely so I was like oh, hang on. The verdict is going to be read in 10 minutes, about 15 minutes at 10 a.m. Eastern. So we have about 15 minutes to go to it, because Megan is still not even there anyway. So Pickles, you made it. Yes. Okay, there is a verdict. Verdict is going to be read in about 15 minutes, and guess what? You won. Congratulations. You won the verdict game. So I think I yes, you can see in here. Yes, yes. No, you did not miss it. You won. You definitely won. I'm not even joking. You won this game. You definitely did. Please, please, please. I'm gonna put my email down below. And then please feel free to reach out, so then we can make a way to to give you your prize. It's not something amazing, but it's still something. So yay, congratulations, Pickles, you won the prize of the verdict game out of the Megan Boswell case. And Lois, that is amazing. Lois, how do you do that? Oh my days, you did it. Oh my days, that is amazing. Pickles, go ahead. Bye. I think definitely, Pickles, play the lottery if you play, because that is oh my days, guys, I'm gonna cry again. Oh my days, what else is new? That is, you got Pickles, I know. It's and Lois, thank you so much. Girl, thank you again. You guys are fantastic. You make this totally worth it. There's days that I am absolutely tired, and all I want to do is go to bed and sleep it off, the tiredness. But I continue doing it. You guys continue amazing by showing up every day, and I really appreciate that from the bottom of my heart. And I think Pickles should definitely go and play the lottery, because two wins on the same day. Sorry, it's tea time. The throat gets dry and I need to speak. But yeah, so Pickles, feel free to reach out. Nightbot needs to order the price today, because I need to get that done, please. Thank you, Nightbot. So I'm getting on it, and yeah, all my days. So next trial, it's starting tomorrow. Make sure if you, I'm gonna do the Google form maybe even this afternoon. So I know it's absolutely fine. I know you're working. It's absolutely fine. I hope you got the I hope you got the email. If not, just ask me for it again, and I'll send you, if you want to reach out for your prize, and then we can arrange that. And Denise, yours will be on the way very soon as well. Don't worry, I did not forget. It's just Nightbot needs to order that. I know, Maria, it is very weird, isn't it, that like they are together. And no, so yeah, case one, good morning, hello. No, you did not miss the verdict, you came in just right on time. And yeah, so they are gonna read the verdict in about 10 minutes. And well, you get 10, Daddy, you get winning, you get the gift from Lois. It's absolutely the ones is on the same side. So oh, okay. Denise, I was like, Seaboard and all, like, okay, like Seattle does has the ferry thing. So I never so yeah, so it's a great day for Pickles today, because it's an amazing day for everybody, and I hope everyone has an amazing day. But yes, Oh no, case one, you haven't missed it. We're still very much on time. The thing is, I don't know if you heard that when the verdict is being read by the jury, it's not gonna be read. We're not gonna hear the jury read it. We're gonna hear the judge reading afterwards, because of the judge. The judge is the judge. I don't know what else to say. He's just said that they did not want the media to have the jury's voice for some reason or other. So it's it's ridiculous in my opinion, but I don't speak English. And yeah, so we are just a few minutes away to listen to the verdict. And tomorrow I'm hoping, the thing is, sentencing phase. I mean, if they go on sentencing phase today, I can leave it. That would be good, Paula. That is actually a very good idea. That is, because if they show her face, we should be able to tell. But the thing is, there's no camera in front of her. We've never seen, I don't think, a camera of, have we? I don't know. So then Daddy says he's guilty. I'll believe you because you are on a roll today. So I'll definitely no, I'll believe you anyway. What was I even saying? I don't even know. Oh, I was talking about the sentencing phase. If they do go on sentencing phase, I can be listening to it and I can leave you listen if you want and chat, and we can chat about it, and then I can go out for dinner with Nightbot and just do it like that. But if they decide to do it tomorrow, I really want to have a head start tomorrow on the new case, but then we can rewatch Megan Boswell on Saturday, because then we can speed it up, and and because it's going to be very emotional, the sentencing and everything, if they do the sentencing today. But I don't know how they're gonna do, because I was just thinking, if the judge is gonna it's gonna like let the jury read the verdict, and then what he's gonna do, let the jury out, he reads the verdict, the jury comes back in, and they start the sentencing phase. I'm not saying this judge probably, no, he has to. I think it's a legal requirement in Tennessee, if it is the first and a living, I think so. I'm not 100% sure, but yeah. So it's just a very interesting thing that now we are gonna see the reactions. I think maybe by the face of the attorney, because we can see his face better. Probably there we can see Megan's, because she can like hide her face or something, unless, oh my god, we need. No, there she comes. There she comes, guys. Sorry, I'm so excited. That's a nice bow. Oh, she's okay. She has a bow now. So yeah, we'll see what happens. And yeah. Oh, are you guys confident that he's guilty? Are you? Well, I said the pickles won, but we haven't. That was the choice. I'm assuming it is guilty, right? Because I already announced the pickles won, and I'm sure it is going to be guilty anyway. But I forgot that we still need the verdict. But I'm sure he's going to be guilty. Oh my god, it's going to be. Can you imagine if she actually now gets not guilty, and I have to say sorry, Pickles, you did not win? I think I would still sit in anything anyway to Pickles. Yeah, Paul, I think might be the last time that she is gonna be wearing a bow. Oh, she's laughing with the attorneys. Oh no, I thought um like I don't care. Like at this point, I don't think I mind her being guilty of anything. I just want her to be guilty of something, so I don't have to retract the gift to Pickles. That would be very embarrassing. Yeah, that's the thing on the state level. So, oh, Danielle, if you could look into that, that would be awesome. Because I can take the banner out. Hang on, there we go. That would be awesome. Let me know if you find anything. I thought that she was, Paula, Paula Lois. I'm confusing names already. Sorry, guys. So it's just yeah, that's the view. Oh, she has to. Well, she has to stand first of all. Every defendant has to stand. So, she's hopefully will. Yeah, that is for sure, Maria, and that's probably why they took a little bit longer. Because, but 4 hours and a half, that is not a lot for the 20 charges that she's facing. So, yeah, maybe they just needed more time to go through the paperwork. Because 4 hours and a half, 4 hours 30, 4 hours 5, it's definitely not that long time for the 20 charges that she's facing. So for sure, it's yeah. Hmm. I'm almost sure that is guilty, but then again, I was sure that was going to be guilty for our last case, but it wasn't. And then I still have to live with the fact that Denise was right. No, I'm joking. Oh, jury is. Oh no, I was gonna say jury's in the courtroom, but they're not. They just like to tease me. There's just the sidebar. Why are they doing sidebar if we don't have any audio? Anyway, like, what's the point? Like, we can't read lips from, I can't from here sidebar or anything. So I don't understand. Sorry, my tea's getting cold. I really want to sip. I think if Megan Price, I think she's doing that right about now. But no matter what, she's gonna go to prison. There's no way, because I think it would be even a security risk that if she got found not guilty to carry on living, because yeah, it's like, no, not me. I'm not a criminal. I'm not a criminal. Hunter is. Hunter did it. Ethan did it. Everybody else did it besides me. Because I'm the innocent girl that lies through my teeth. And oh my days. Oh, I was gonna say, can we see some? No, we cannot see. I don't know what's happening. I think we're still waiting for the jury to come back in, and the judge. I was gonna say the judge had enough, and I was like, bye. But no, I'm gonna miss his orange laptop. Oh, another sidebar. It's just, I don't understand why so many sidebars. Okay. So Danielle says, so it depends on the charges, but more than likely there won't be a sentencing today. It will go to a sentencing phase where there is separate hearing happens not too long after the guilty verdict. Okay. So yeah, I know, same. Okay, sorry. Oh. The who showed a text message to who? To the judge? Interesting. Got to know. Yeah, because I remember in the other case, the more recent case out of Tennessee, the Jason Chen case, there was a sentencing phase straight after the case. So that's why I'm asking. But no matter what, if they do the sentencing phase today, what I can do is I'll leave you guys and watch it and everything, and me and Nightbot will go out for dinner, and then we'll probably be back. But I'll be also on stream anyway. The girl that went to the. Ooh, interesting. That's right. Maybe it's the verdict from the jury's like, listen, Megan, you're gonna be found guilty, so prepare yourself to live for the rest of your life behind bars at 24 years old, because that's what's gonna happen. She's facing, no matter what, life with. Ooh, I'm very. One second. So I was like, case one, I don't know if I'm intrigued or impressed with that, because don't zoom in on me. Ooh, jury is coming in. Okay, jury is coming in. We're not gonna hear the thing, so I know, Maria. I was like, jury's coming in. We can be telling. No, you did not miss it. Jury's coming in. We are going to be looking so intently to everything on the screen to see if we can tell the time. So yeah. So 1 second. Yes, they did. They did took the unaliving penalty off the table because of her age. Because um, at the time that she was arrested and everything, and the crime it happened, she was 18. So that is out of the question. So it is definitely, I'm sure, a packed courtroom. Please don't zoom on me. No, I'm joking. Lol. um. So yeah, the jury, I think, just got in. I think now we're zooming in into Megan to see when they stand. I think they might be asking, have you reached a verdict? And they are saying yes or no. And they soon might say to the defendant to rise to listen to the verdict, and then we'll see the reaction. It is open court, but I don't know. It's judge rules. I mean, they're following just what the judge is saying. So I know, good that they are zooming in. It's okay, Pickles. I did not notice anything. Um, I know, I know. I'm so sorry. But you okay? You can vent in a nice way here. It's a safe place. In a nice way, you can vent. It's absolutely fine. And no caps. You know that already. um. So, uh, um. Yeah. So they are zooming into her. So hopefully we're gonna be reading. I don't know. I don't know. I don't want to be quiet. I think. Hang on. Can anyone hear Rita? Okay, I think it was guilty. She's crying, or she's faking crying. But she's not standing, so I don't understand. I'm trying to read. No, I think she's crying actually. Yeah, there's tears. So I think she got guilty. She's crying. The verdict is being read, Nightbot. So I think this can be proper tears that she got. Yeah, I think this is crying for herself. Yes, could be nerves as well. True, crying for yourself. But yeah, yeah. So, I don't know. I cannot make much. Can you guys make anything? I think I can see the. Yeah, it's. I hope what we today definitely gets justice for Evelyn, because this is what it's all about. It's justice for Evelyn. So Evelyn needs to have some justice and some people to stand up for her, because her mom did not stand up for her. The one person that should stand up for her. So just waiting now for that. That's what I thought so too, Lois, that to stand up, but I don't know. I don't, because with no audio I can't. So yeah, oh yeah, definitely she will be partying in jail or in prison for the rest of her life. For sure. That is absolutely true. Oh, I'm sorry, Pickles. We saw one shiny little tear. I forgot about that one. She had the first one out. Plus the one on the interview, probably another one. So definitely do this in chat, everybody. Say Evelyn's name. She deserves to be heard. Her name deserves to be said. She should be remembered for all eternity, because it's, yeah, true, every court is different, but yeah, I hope she's getting guilty all around. And yeah, okay. So it's yeah. Yeah, the infamous tear. So we're just waiting now for them to get the verdict. I know the verdict already. Do you guys want to hear? We can listen to the judge afterwards, but I know the verdict. I've started getting notifications about the verdict. I can tell the verdict if you guys want to. If not, I can wait and wait for the judge to read. It's up to you. If you guys want, let me know in chat quickly if you want me to read the verdict, because I do know. I don't know the charges, but we all know. So let me know. Unless we are now waiting for them to count the thing. So we are known that count 6 through 17 are the false statements to the police. That I do know and I remember. I can open the indictment that I have. Hang on, there you go. Give me a second. I have it here. So if you guys I can go through the counts because I've got the counts of that she's being charged with, and I can go through that on the verdict, and you listen to the verdict from me. So I'm gonna start. Count 1. Sorry, felony unaliving, guilty. Count 2, felony murder, guilty. Count 3, aggravated child abuse, guilty. Aggravated child neglect, guilty. Count 5, tampering with evidence, guilty. Count 6 through 17, guilty. So I am waiting on the report from the rest of the counts. It's just coming in. So because counts 6 through 17 is guilty, because they all false report. So all the guilties goes through that. She is now learning her faith. So guilty so far on 17 counts. Count 6 to 17, it's all false reports. So they're all guilty. And finally, there's some justice for little Evelyn. Finally, she gets the guilty verdict and read. So I'm just waiting. We are just waiting on count 18, 19, and count 20. No, 18 and 19 on the counts. So at the moment, and then we're going to listen from the judge. So yeah, the indictment, you can find it in Discord, Willow. The indictment that I have, this that of the charges is on the Discord on her case, Megan Boswell, if you on a charge, so you can find it there. That's so far counts 1 through 17, she has been found guilty. So Evelyn was 15 months old when she got unalived. So Evelyn was 15 months old when she was unalived by her mom, Megan Boswell. Now that she has been found guilty in 17 counts so far and counting. We still have count 18, there is abuse of corpse, and 19, failure to report unaliving under suspicious, unusual, and unnatural circumstances. So that is the 2 count that we are waiting on a verdict for. And just waiting and reading, and she is hearing every single guilty one. And guess what, guys? She's gonna have to listen all over again when the judge reads it again. So guilty across the board. She is facing life without the possibility of parole. So now next is the sentencing phase that she's gonna face to see if she gets, basically like Natalie Cochran, mercy or no mercy, life with the possibility of parole, or life without the possibility parole. So now we are getting to count 18 and count 19. Pickles guilty from counts 1 to 17. So 1 to 6 is guilty, and then 6 to 17 is the false reporting. She got guilty across the board, basically. And basically so yeah, so we're just waiting on the confirmation of count 18 and count 19, and then we can listen to the judge reading all over again. The jury, I think, is being dismissed. I don't think they are going to pull the jury. I don't know. We'll see. Good morning, Ivamos. We got in just in time. Buenos dias. There's still more information coming in. Just bear with me a moment. If they start to read it, we'll go for it because the audio is ready for the court. So we're just waiting on the confirmation. One moment. Guilty on count 19, guilty on count 20. So she was found guilty all across the board. Every single charge. 20 charges, 20 guilty verdicts. So absolutely guilty across the board. So justice has been served for little Evelyn Boswell. So it's absolutely great to finally see justice. Nice one, jury. Very, very nice. I am cheering inside and I'm tearing up.
Murder. To judgment of this court, you are guilty. In count 2, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court, you are guilty. In count 3, a jury of your peers having found you guilty of first-degree murder and the perpetration of a felony, it's a judgment of this court, you are guilty. In count 4, a judgment of your peers having found you guilty of aggravated child abuse, it's a judgment of the court, you are guilty. In count 5, a jury of your peers having found you guilty of aggravated child neglect, it's a judgment of the court, you are guilty. In count 6, a jury of your peers having found you guilty of tampering with evidence, it's a judgment of the court, you are guilty. In count 7, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 8, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 9, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 10, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 11, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 12, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. Count 13, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. Count 14, a jury of your peers having found you guilty of false report, is a judgment of the court, you are guilty. In count 15, a jury of your peers having found you guilty of false report, is a judgment of the court, you are guilty. In count 16, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 17, a jury of your peers having found you guilty of false report, it's a judgment of the court, you are guilty. In count 19, a jury of your peers having found you guilty of abuse of a corpse, it's a judgment of the court, you are guilty. And in count 20, a jury of your peers having found you guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, it's a judgment of the court, you are guilty. In counts 4 through 20, the jury did not assess a fine, so there'll be no fine assessed in those counts. Now we'll be in recess about 15 minutes. Thank you. Court stands in recess.
All right, Megan, you can go and change your clothes to your prison garment because now you don't need to wear civil clothes anymore because now you have been found guilty of the hopefully sentencing today. Yes, because now I think the jury it's going to be deliberating for the sentencing and everything, but I will be in chat but from the 5 p.m 5 p.m my time, but it will be 12 p.m Eastern. I will be turning off the camera because me and I but are going for dinner tonight, but I can leave the stream up and I'll be in chat and I have access to my phone anyway remotely, and I can keep an eye on the feed and make sure that everything is okay and everything. But since we have already have a verdict, then they're probably going to take the afternoon off. But yeah, so but the stream will be up for you guys to watch it. But guilty on so probably she will. So now we are probably waiting for the sentencing. We have a 15-minute break, and again, now officially, more official, I want to congratulate Pickles, the winner of our verdict game. Get in contact if you want your prize. Nightbot is actually ordering it right now, and let me know on my email if you need the email again. Let me know, Pickles, and we will be in touch. So now verdict is done. We are gonna see her now in her prison garment after the break because she is not now presumed innocent of anything. She's absolutely found guilty on every single charge, and I am not. So that it was a very good trial. It was very seamlessly. It was actually quite quicker than I think they were expecting. Because they initially they were saying there was going to be about 4 weeks, but I think the judge was like, "Nah, hurry up," because the state is costing way too much money to have the jury sequestered and everything. Because I did the math, and up until today, it has cost the county of Sullivan in Tennessee $240,000 to have this jury because they are sequestered, so they have to pay for everything: meals, rooms, their times on there, security, everything for the courtroom. So 240K has been spent in this case. So I don't think the judge was going to let anything to cause a mistrial or to do anything. So yeah, I know, because I saw and I still have the math of a dear friend on a really great content creator, and she did the math. Because now we can go over it. So the daily charge is per juror. So it was $2,000 and 500. So I think we had and I'm only doing for 12 jurors, right? We have 12 jurors on the case. I'm not counting because I think we had three. Right, I think it was three alternates, right? So 15 times $2,500. That's $37 and 500 $37,500 a day per jurors times 8 days, because we are on day 8th altogether of the case. That'll be at nearly $300,000 for the cost of this trial, just for the jury, no matter what, apart from the overtime from the bailiffs and everything. Well, day 8, day 9th, because we had the day off on the Sunday. So the money is that the county spent on the jury, so on hotels or motels, food, security, expenses, that's how much just for that. Don't forget, it is probably more because there was a Sunday that we did not have trial, we did not have court. So there's that day that they basically earned and spent money, and they were not even having court. That's why we had court on Saturdays with this case, to maximize the time. And don't forget about the overtime that they had to pay to all the court staff in court, like Bayer, Ursula, Clark, security, and then pay the prosecutors, pay the defense attorneys, because they were the public defense attorneys, they were not private, and then the defendant's advocate, paying all those people the overtime that probably they would not probably be working on a Saturday, paying that. The judge pay as well. So roughly this trial alone costs around what, $315,000 for her, for a baby analyzer, for a liar that lied through her teeth to everything and everyone that had a pulse. That's absolutely ridiculous. So so prices have been ordered. I had the confirmation from the jury, from Nightbot. So absolutely crazy. But I am glad that she got found guilty across the board. Not even a single one. So absolutely. Absolutely awesome, and the jury got it right, and I can update our spreadsheet with now the guilty Megan guilty. Because do you guys want to see the spreadsheet, how it is at the moment? I don't think many people, the newer people to our case, to our community, haven't seen our spreadsheet, have they? Let me know, because I want to show, because I am I'm a nerd. I like spreadsheets. So the only thing I cannot update is how long she's gonna take, because I think she's gonna get life without the possibility of parole. I'm not seeing the jury get anything else. So, uh, oh yeah, it doesn't. I mean, how can it be, for example, and I know that for a fact because I was listening to some jail phone calls on my spare time, and for example, Leilani Simon, the one from Georgia, they knew that she was a baby and alive, and like it. The girl that because what happened was Leilani Simon after the guilty verdict um Leilani, after the guilty verdict, she got put into safe cell. So because they were afraid that she would unalive herself, so she couldn't get out or do any phone calls or anything. So she got someone in the jail to call her mom and talk about it. That and that she knew obviously about the case and everything. So um, I don't think she's gonna be in general Gen Pop, but um yeah, good, but still, she's gonna be behind bars for the rest of her life. So, case one, I think maybe the grandma, because she's delusional, and Megan's grandma, she's delusional, or maybe nobody. So, it's just oh. Maria, I cannot wait to hear the judge's remarks about this case. I know some like they don't go for it, but some do. Um Dog's like, that's hilarious. She's gonna be doing people's laundry for Honey Barnes. Probably she will. Um, Megan's grandma. So Angela Boswell's mum, I think is Wanda Jones or something like that. So, uh, oh yeah, she burned all the bridges and everything, and even if she doesn't say, it will come out in prison, because people talk with people outside, and you can just ask, oh, can you Google so and so, and they Google and they'll tell, and then that's it. So um yes, the one that came out with the news with her. I think that was Megan's grandma or Christy, but someone sadly they will be on her side. Maybe so. We'll see, because now on the sentencing we might have we're gonna have impact victim impact statements for sure, and maybe someone will speak on her behalf. Um, yeah, I love a good jail call. So I said that in jail calls, other inmates can ask their relatives to Google someone. You give them the name, and then they can Google, and then they find what your charges are. So hiding the charges is never easy, or it's impossible to hide the charges in prison. So, and I don't know. I don't think no one was happy, but there was some delusional people. But to be fair, we haven't heard from the family, from Wanda or from whoever was next to Megan in that TV interview at all, anyways, because they did not get called during trial. So, but it's just wild, and I am very, very glad that the jury got it right, got her guilty on all accounts. Only took 4 hours and 5 minutes around that. Oh, is it? Oh, okay. Well, then she's not gonna have any food then in prison or on the commissary. She's gonna be having to do laundry for honey buns. Or maybe like I was gonna say, if she has in the same prison as Sarah Boone, they could share, but I don't think Sarah Boone will share her knuckles. Oh, but talking about Sarah Boone, it doesn't have to do anything with Sarah particularly, but is from Florida. So on this channel, one of the first cases we covered was Rhonda Jewell. I don't know if you know about that case. It was a very sad case that a babysitter, she was babysitting a baby, and she forgot the baby in the car for hours and hours. And even though she was talking to the mom and to the aunt of the baby, she only remembered that the baby was in the car 5 hours or 6 hours after, and the baby was not alive anymore, sadly. And she went to trial back in November, and she got convicted of unaliving the baby. Of it was not unaliving one, but I think it was manslaughter, so it's a less charge. Um, so then she got convicted. Um, she got convicted to 17 years in prison, this Rhonda Jewell. And yeah, she got convicted of that. She got 17 years. But guess what? So now, who's that, Willow? Oh, Tracy Nix. Oh, this one is another one. This is Rhonda Jewell from also Florida. That she got convicted already. She got 17 years. But guess what? She's appealing, right? Obviously, they all always do. And she applied for bond while oh, it's all right. Don't worry. It's fine. It's too many to keep track of. It's too many to keep track, honey. It's absolutely fine. So I was saying that she applied for bond while appealing her case. And guess what? It got accepted. So she now is out on bond. I think, how much was it? Let me grab my phone and get the information, because I do have the information on my phone. One second. So it's absolutely ridiculous knowing that now she's out of bond. Let me so she's on a bond of 100, I don't know, it's had so many, $100,000 bond with the GPS monitor and with a curfew. So that's justice. So she literally was in the same prison as Sarah Boone, but now she is on bond while receiving for appeal. She was literally in jail or prison for a month. Well, 2 months. 2 months, 2 months, around 2 months. And now she's out again while waiting for appeal, because they say that she's a low danger for the community, and that she is not a threat for society, even though she forgot a baby in the car. The baby is not alive anymore, and she didn't even accept her mistake. She said she's sorry that she did it, but she was blaming, obviously blaming, I think it was medicines as well. It's just yeah. So hopefully that doesn't happen with Megan, to be out on bond. Well, she was not even on bond in the first place while she was waiting trial, so I don't think she can go. She will go on bond while, well, it's not sentenced after while appealing the case, because this girl Rhonda Jewell, she was on bond while waiting trial and everything, because she could afford the bail, but I don't think Megan can. Because I don't think Dad is gonna give her money for bond. I think he needs it for themselves, because this family, Boswell family, gets in trouble a lot. So yeah, that's probably not gonna happen. So the possibilities. What do you guys think? Do you think that she's gonna get life with the possibility of parole, or life without the possibility of parole? LWP or LWOP? Let me know. I think and I hope it's life without the possibility of parole. I'm sorry, but you commit the crime, you do the time. Yes, definitely. Hoping for no parole whatsoever. Yes. Because the thing is, I understand, yes, that life with the possibility of parole is not guaranteed. But in the eventual case that Megan does accept any guilt, because I don't think she will ever say that she's guilty and accept that, there's still that thing that the family is going to have to do every so often, having to go to court, face this whole ordeal again. And it's not like the case is closed and it's done and dusted and they will never think again. They will, but they will think about Evelyn and not, hopefully not about Megan, but because if she gets parole, it's all going to be about her again. And this is not, this is about Evelyn. So, and Denise, you are more often than not right. So when you have a different opinion than I do now, I get scared. I'm joking. So, um, yeah. So I'm scared. Very scared that when Denise says something different than I do. Because normally, often that she's not. Like, that's the thing. I don't want the Nightbot. Um, I don't want the family to have to go through this ordeal again. So, I absolutely don't want the family going through. Uh, but that's the thing, possibility of parole. I know he doesn't get the guarantee that she's gonna get out. But for example, I don't remember. Did I can check the where is she? Oh, I just put yeah, because the other one that we had, the Chloe driver out of Georgia, that she is the same age as Megan. They're literally both 24. She got life with the possibility of parole, but then that's again, uh, it's not the guaranteed. So it's I understand, but I don't know. I hope for no parole, but Denise says something different than I do, and she always gets it right. So Denise is right for sure. Now I'm joking. Maybe it is what it is in terms of like parole or no parole. All that matters is that she's gonna take consequences and serve consequences for her actions. And yeah, and she's gonna go away for a very long time. So, oh yeah, exactly. It's gonna be 30 years, I think, at least to serve. So she's gonna be 54, if my maths are right, 54, 55 to when she goes to the possibility of parole. And I think she'll get denied, because one thing of elements of parole, and we hear that quite often while we're doing verdict watch and everything on parole hearings, is that to get parole on a first try, it's almost impossible, and you have to have um a completely different demeanor than you did when you committed the crime. You have to accept consequences and the guilt, and that you are found guilty, and take it in and actually show by your ways that you accept what you did, and you try to make corrections to what you did on a crime. And very rarely they are given at the first time. Even if you do everything right, it is very, very rare that you get parole on a first try. So I don't think she's gonna get it, even if she gets parole. But it doesn't matter. She's gonna go away for life. So yeah. Oh yeah. That is very, very true, Nightbot. She definitely thought that she was smart and she was gonna fool everybody, and now she was gonna fool 12 people that could not see past her manipulative ways or anything. Well, not really, because the defense didn't even not put a case. So I think that's where she lost the case. Not that saying that if she didn't put if she would have put a case, that was a possibility she would have lost anyway, but at least tried a little bit. So oh, someone just brought everyone in my office. Oh no, that is no cool. I'm so sorry, Pickles. I'll bring you some breakfast if I could. Oh, sorry about that, Pickles. That sucks. Then, I'm sorry. There's courtroom noise now. Oh,
Mr. Scott, are you ready?
Yes, sir.
We need to bring a defendant in.
If we're prepared for 2 witnesses right now, we have a witness still on the way. She's not far away, hopefully.
Right. Well, the state will go first, and then.
I don't think it's gonna help much.
We're gonna draw it out.
I hope she comes in jail clothes now, because she has no right of wearing civil clothes anymore. Ooh, Lois, here comes Bear.
All right. If the jury is ready, we'll bring him in.
Everyone stand, please.
I gave it to you yesterday.
You may be seated. Thank you.
All right, General.
Judge, stay with introduce. I'm sorry.
You can do an opening statement if you'd like to.
Okay, no, state doesn't need to do the opening statement.
Do you have an opening?
I do.
Okay.
Ladies and gentlemen, although I may not agree with your verdict, I respect your verdict. I respect you. I thank you for your time. And I have one more thing to ask you. You have to make a decision now, and that decision is it's going to mean the difference. If you sentence Megan Boswell to life in prison, she'll be released when she is probably 69 years old. It'll be 8. She's been in jail. You probably realize she has been in jail since she was 18 years old. She went to jail February the 25th of 2020, and she hasn't been released. So with that said, if you give her a life sentence, it would be 51 years. That's what I'm asking you to do. If you give her a life without sentence, she will never be released from prison. That's the difference. So it'd be the difference between her being released at what I believe would be 69 to 70 years old or never being released. In doing this process, and Judge Goodwin will read you some very short jury instructions comparative to what you heard yesterday. You look at statutory aggravating factors and mitigating factors. In this case, the state will submit the age of the child as the aggravating factor. Our mitigating factors, we've listed several of those. They include no significant criminal history, her youth and age at the time the offense was committed. She was 17 when she had Evelyn. She was 18 when Evelyn died. You'll hear more about her unstable and chaotic home life. You'll hear from her mother, Angela Boswell. She's here today. You'll hear from Angela about domestic violence that Megan witnessed between her parents. You'll hear from Angela about drug use that Megan witnessed her parents engage in. You also hear about her schooling. It wasn't seamless, and how one of her primary role models was her grandfather, Tommy Boswell's father. He died when I think she was 11 or 12 years old. You'll hear that. And finally, you'll hear a little bit about her younger siblings, Elijah and Charlotte. Elijah has a disability that Megan has looked after him and tried to help take care of him. And then you're also feel free to look at any other thing you've heard in the proof and making that decision as far as mitigating factor. Anything else you've heard in all the proof from any of the witnesses, and also you'll probably hear from Gail Kite. You've heard from her once before, but you'll hear a little bit more from her about the shape Megan was in when she came into her home, and you'll hear from we expect to call Mary Boswell. She is Megan's grandmother. I think most of you recognize the name Old Mommy at this point. You'll hear from her and what she witnessed and her participation in raising Megan. So it's a hard decision. It's not a light decision. You've made a hard decision already. And it's my hope that after you see this, you will come to the conclusion that maybe at 69 years old, it would be fair for her to be released from prison.
All right. General, proof.
Yes, Judge. This time the state will produce a copy of birth certificate of Evelyn Boswell.
All right. That'll be exhibit 262. I'm going to keep the exhibits in sequential numbers, but I've started a new sheet for the sentencing part. It'll be exhibit 262. Any other proof, General?
No, Judge. At the state address.
All right. Mr. Scott.
Here's we call Angel Boswell. Angel Boswell.
Just very quickly before Mom gets here, remember, Mom is on probation because she tried to smuggle drugs, and Angela Boswell is here, guys.
Raise your right hand, man. State your name for me.
Angela Boswell.
You solemnly swear, affirm, testimony you're about to give be the truth, the whole truth, and but the truth, man. Have a seat. If you'll pull the microphone down and talk straight into that microphone. Actually, you know what? I need to switch these.
Ready to go, Judge? Right. Ma'am, state your name for the record.
Angela Boswell.
You are Megan Boswell's mother.
I am.
Ms. Boswell, you know the purpose of being here today.
I do.
I want to ask you some about Megan's home life and growing up, but I guess I want to ask you first a little bit about yourself.
Okay.
And I'm asking you these questions, Ms. Boswell. I'm not trying to embarrass you or cast any aspersions.
No.
You married Tommy Boswell when you were how old?
First time 15.
You speak into that microphone just a little more, please.
The first time 15.
And when did you become pregnant with your first child with him?
I had my first in April and turned 16 in July. So,
Okay, and who is that child?
Tommy Jr.
Okay, and then you had Megan at some point. How old were you when you had Megan?
There's 8 years difference. I was almost 24.
It's okay. So, let's talk about Megan's life growing up. Would it be fair to say that during her lifetime, she's witnessed drug use between you and her father?
Yes.
What type of drugs?
Opiates, mainly.
Scoot up and speak into that so the jury can hear you.
Opiates, mainly.
Did that drug use lead to other problems?
Yeah. Arguments, fighting, yes.
Okay. You say there
Strife.
Strife.
Is what it brings, yes. Nonstop.
Is that something that went on pretty much her entire childhood growing up?
Yeah, from the time she was pretty little, yeah.
Okay.
Mm.
Good. Now, did she witness fights between you and her father?
Yes.
Okay. I think at some point her father was convicted of aggravated assault and kidnapping.
Yes.
Were you the victim in that?
Yes. Mm.
Do you remember ever taking Megan to any NAAA meetings with you?
Yes, I did.
How old was she when you did that?
She was probably about 7 or 8. First ones I started taking her to. 7 or 8, 8 or 9, somewhere around in there.
Now due to the strife in your home, was she raised by her grandparents to some degree?
Yes.
Okay. And what were their names?
Mary and Danny Boswell.
Okay. Mary Boswell, would that be who's known as a mommy?
Yes. Mm.
These problems, do you feel that it's partly your fault, the problems Megan's experienced?
No, absolutely. Yes. Yes, absolutely.
Now, unfortunately, your problems, that they went on up into, we saw a video in here, you being brought down from the jail to talk with her in 2020.
Yeah. Mm-hmm.
So even up until the time she went to jail, you were in and out of jail.
Yeah.
Okay.
Yes. I've been.
Have you been convicted of numerous crimes?
Yes.
Now, have you managed to straighten up at this point?
I have, yes.
You hoping to?
Yes. I pray every day and just, to do my best and try. I've learned the importance of a mother's role, but not for Megan, I didn't.
All right.
I failed her on that miserably.
And you're here asking the jury to give her a sentence of life as opposed to life without.
It's Maggie is at her core. She is a generous, kind person. And through all Maggie's went through, Maggie still has potential. She was trying so hard. She didn't repeat my mistakes. Maggie learned from my mistakes. And she was trying to do better with Eve. She wasn't repeating.
I think she got saddled with, you know, and just because of my mistakes that she did. That was not it. That was not the case with Ellen.
Would it be fair to say she didn't have a good role model for the mother should
No,
be?
no, she did not.
Answer any of Ms. Massimiliano or Mr. Harper's questions.
I don't have any questions, Judge.
Judge, at this time, I have some judgments of conviction on Tommy Boswell. I'd like to put in by agreement with Mr. Harper.
No objection, Judge.
Okay. I'd ask these to be made the next 4 exhibits.
Mr. Scott, you want to enter in the case number 61078 as exhibit 263. And the other 3 pages are 3 counts of the same case. So I'll make that a collective 263.
What is that case number you're on?
62497.
This is what we're here for. Justice for this little girl and not for Megan. Megan doesn't deserve it. It can be kind snark in chat. Obviously, no bad words or anything like that, but this is the little girl we are fighting justice for.
263, case 61078, and case 62497. Those 3 pages, 264.
Your Honor, defense would call Gail Kite. Kite.
KYTE.
I believe so, Your Honor. I'll have her spell it. I think she was a witness in the trial, but I'll go back to that.
Raise your right hand. State your name, please.
Gail Kite.
Ms. Kite, you solemnly swear from testimony you're about to give to be the truth, the whole truth, and nothing but the truth.
I do.
Speak into that microphone.
Ms. Kite, good morning.
Good morning.
Just so I make sure here, spelling your last name, is it Kyte?
It is.
And Ms. Kite, you've previously testified in this hearing as a state's witness. Is that correct?
That's correct.
Well, thank you for coming back for this part of it. I know Ms. Boswell appreciates that. How long have you been working in foster care?
15 years.
Do you remember when Megan Boswell came to you?
I do.
Do you recall what kind of shape she was in or state?
She was in bad shape. She was one of the worst children that I'd brought in as far as neglect.
What do you mean by that?
She was very malnourished. She's very skinny. Her hair was matted to her head with lice. Impossible to even get a comb through.
Okay. Well, when she came to you, were you given any background? I imagine in foster care, you're given background or information of where this child is coming from. Were you giving any of that?
I was.
And what were you preparing for?
In the intake papers, it mentioned trauma. It mentioned rape.
Did it give you any background or any information about her family background or makeup?
Not really.
Now, you said she came to you with lice. What did you do to try to help Megan?
Well, I took her to a beauty shop because there was no way to even begin to get a comb through. It was horrible. The beauty shop wouldn't touch it. They told me I offered to pay him $100 to go out back to cut her hair. And they said that they couldn't do it. Finally, the agency that we were with found a beautician that met me at a church that was willing to come in and give Megan a haircut. They gave her a bob, which looked really cute on her. But even after that we could get a comb through, it took close to 3 weeks, maybe a month, to get rid of the lice. Were just so bad. I had to get prescription medicine from the doctor. We got 2 bottles of that. I bought the comb that you run through that's supposed to kill the lice. And I know I practically traumatized the poor child because we'd go out on the porch and I'd run that comb through trying to make sure we got all the lice, and she'd sit there and tears would run down her hair. She got tired of me. It wasn't a pleasant situation. And then even when you do that, you still got to go through, you've got to thoroughly clean the bedding. Everything in the room has to be taken down, washed in hot water. But it was a rough time for her, very rough.
And you may have said, but she came to you how old?
She was 17 years old.
She was pregnant.
17, pregnant, scared, didn't have a place to go.
And you believe that she had been raped or violently sexually assaulted. Were you given any background or information about her family, her mom and her dad?
I knew Mom was in and out of jail, and I knew her daddy owned a business.
Okay. Were you able to come to the opinion that she essentially came from a dysfunctional family?
I did.
Okay. And how long did she stay with you?
She stayed 4 months. When she came in, we got to work, got rid of the lice, got her registered for school. Where she was pregnant, she chose to do online schooling. She worked really hard getting her diploma. If a test didn't go right, she was on the phone the next day with the counselor getting it reset. I never had any problems trying to get her to do her schoolwork or anything. She hung with it.
She ever caused you any problems, disciplinary wise or anything like that?
No.
Never?
No.
And did she seem to be thriving in a structured environment?
She did. She did.
Was she making friends?
She did.
Did she seem to be progressing and coming out of the state she was in when she came to you?
She very much so.
And she was with you for 4 months. Did you form a bond with her?
Oh, I did. We took up together immediately. It was during the winter. She learned me how to play card games. Winter days, we'd sit there and we'd play. Baby'd sleep. We'd play cards. But we formed a bond.
Did you take her to doctor's appointments?
I did.
How did she seem to feel about becoming a mother?
She was very excited.
Did you have conversations with her about that?
I did.
Did she seem to fully understand her roles and responsibilities of what was going to be required of her?
She did. Megan practically raised her younger sister Charlotte and her brother Elijah. She had plenty of experience with younger children.
How did you know that?
Well, mostly from conversations with Megan, and just I could tell by the way she took care of Evelyn at the house. You know, she knew how to heat a bottle. She knew how to change the diapers. She got up when the baby cried.
Did you ever have to tell her to do those things?
No, me and my husband never once woke up those 4 months when Evelyn woke up in the middle of the night. Megan would take care of her very well.
And I asked you, and I want to clarify that if you ever took her to doctor's appointments, she was with you when she was with you. She came to you pregnant. Did you go to the prenatal appointments?
I did.
And did you go to follow-up appointments with Evelyn's pediatrician?
I did.
Okay. So you were involved through the whole process, really?
Those 4 months, yes.
Okay. At some point in time, was Megan taken from your home and placed back somewhere else?
She done trial visits to go back to Tommy's.
Okay.
There was a process in the foster care system.
I understand.
She done weekend visits, or at first it was just visits, and then it led to weekend visits.
How did she feel about that?
She seemed okay with it.
Eventually, was Megan placed back in the custody and care of her family?
She was. She went back to Tommy's house.
Tommy, you mean her father?
Yes,
Okay. And did you maintain contact with her?
I did.
How often?
We texted back and forth over it wasn't a daily time, but I want to say once a month, couple times, sometimes couple times a week. It's just according to what was going on and what pictures she had took of Evelyn.
When you were talking to her, did you eventually learn that maybe things were kind of getting back off the tracks again?
I did. In April, I received a call from her foster care worker saying that Megan had been needed some help and would, even though she had was out of the foster care system, would I be willing to go and help her out? And I said, no problem. So I called Megan. She told me that her mother had dropped her off at a church. She had drove off and left her and Evelyn there. She had took Evelyn's diaper bag, the baby's supplies. So I told her I'd be right there. I went and picked her up. We went to Walmart, bought baby bottles, formula, diapers, the stuff that a baby would need.
Where did you take her?
We went back to my home. She spent the night. Her and Evelyn they took showers, a good night's sleep. But then the next morning, she wanted to go back to her mother's family's home.
Where's that at?
Now, I'm not sure. The place that I took, her grandfather was in the hospital, and she wanted to go there to meet up with her family. So when she left my home, I drove her to the hospital in Kingsport, and she assured me that she would be perfectly fine, and her and Evelyn got out.
It'd be fair to say that Megan wasn't getting maybe the familial support from her parents that she was needing at that time.
Yes.
Okay. I imagine over this time, Ms. Kite, that did you ever meet Tommy Boswell Sr. or her mother, Angela?
I had never met Angela, but I'd met Tommy several times.
You said you agreed that she probably come from a dysfunctional family. Let me ask you this. She lived with you for 4 months and you stayed in contact with her after she moved out. It's your opinion, you know her, you talked to her. You think Megan ever knew what a normal family looked like?
No.
Did she crave that?
I think so.
Was she wanting that for Evelyn?
I think so.
Well, it's obvious why we're here today. You know why you're testifying. Are you asking this jury to just give her life?
I am, with the possibility of parole. This child has been traumatized. She's made bad mistakes that has to be paid for. But I think she deserves a chance to come back out to the real world. I don't think she's irredeemable. I think she can become a functioning citizen.
Ms. Scott, I thank you again. If you would answer any questions that the state has for you.
Nothing from the state judge.
Should we call Mary Boswell?
Raise your right hand and state your name for me.
Mary Boswell.
Ms. Boswell, do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
If you have to record and speak your name,
Okay.
Ms. Boswell,
Mhm.
I'm Gene Scott. How are you?
Pretty good.
We're here today because the jury's trying to decide how long Megan will have to stay in prison. I want you to, I guess, your name is Mary Boswell.
Not Mary Boswell.
Okay. How do you know Megan?
Sir,
How do you know Megan?
she's my granddaughter.
Okay. Are you Tommy Boswell's mother?
Yes, sir.
And obviously you've known Megan her whole life.
All of her life, I started keeping her from the time she was 2 months old till she was grown, off and on, not all the time, but off and on.
Why was that in part because of problems between your son and her mother, Angela?
Sir?
Was that because her parents were having
No,
problems?
she just loved me and her papa, and she stayed with us, and we loved her, and so we keep her a lot.
Were you aware of the violence issues between Tommy and Angela?
No, I didn't live in their home or nothing. I don't know nothing about what went on in their home, sir.
Okay.
We'd pick her up and keep her until she want to go back and like that, off and on.
And have you always lived down there on the same property Tommy lives on? Or?
I've never lived there for maybe 20 years, 21 or 2 or something like that.
She lived there almost all Megan's life.
Yeah, yes, sir. Oh, yes, sir.
And you're aware, you told me, I think one of Megan's role models was your husband, your late husband?
Sir?
Your late husband, he was one of Megan's role models?
Yes, we loved her like she belonged to us.
Okay. When did he pass, ma'am?
11 and a half years ago. Soon be 12 this summer.
So that would have been when Megan was, I guess, what?
Yeah, maybe 12 years old or
12
something.
years old?
Mm-hmm.
Did you see that take an impact on her?
Yes, it did.
And are you here asking this jury for leniency today?
Yes, sir, I am.
Asking them not to give her a sentence of life without parole?
I hope they don't, sir. I love her like I hope they don't give her the sentence like that. I'd love to give her my home if I could take her home today. That's how much I love her.
I understand. Thank you, Ms. Boswell. Is there any Mr. Harper or Ms. Massacre?
No questions, sir.
Ms. Boswell, thank you so much.
Okay, I'm leaving. Thank you. Can I sit out here now?
It's not subject to recall. They're welcome to stay in court.
Okay.
We approach.
Ladies and gentlemen, I'll have you go with the officer for just a minute. It won't take long.
Everyone stand, please. You may be seated. Thank you. Now approach.
All right. Go ahead, Mr. Scott.
Megan, we've talked about this before. You understand you have a right not to testify.
Yes.
No one can force you to testify.
Yes.
We'll start this over since we didn't have the microphone up. Megan, you understand you have a right not to testify, and if you don't testify, the jury may not draw any inferences from that failure to testify. Do you understand that?
Yes.
Likewise, you have a right to testify. No one could keep you from testifying if you wanted to.
Yes.
After consulting with me and Mr. Horn and talking about your case and hearing what's happened here in court and all the evidence, do you wish to testify or not?
No.
You do not wish to testify?
I do not wish to testify.
And Ms. Boswell, you're still under oath from yesterday or the day before. You understand that?
Yes, sir.
Do you have any other proof? And before we bring the jury in, one thing that I forgot to do yesterday, was when we excused the alternates, I took the contents of one of their books and the cover page, and I gave that to the court reporter, and that would be designated as Exhibit A, the letter A, for identification only, so that it's part of the record as to what those notebooks were that they took there. All right.
Gotta love that hot mic moment, talking about something a live stream or I don't know if they're going to do closings, and I hope they do, because the state literally has been silenced throughout this whole sentencing thing. But hey, it's going quick, so we might actually finish Megan off today. So I was like, I have my opinions about this whole statement that we listen. I don't believe in one single one of them. I think it was literally, oh, okay. See you very soon, Maria. And we went off. I don't know why. See you guys. See you later, hun. Have a good day. And like, yeah, I have my own opinions
Judge,
about
stay
this.
with introduce it.
Oh, I don't know what's happening. I don't. Oh, they are fast forwarding. So this is. Oh, and I think we're back on live. The cameraman messed up. What are you doing, cameraman? Stop it. Sorry. Cameraman is having fun with the camera. This camera person, it's absolute. Oh my days! Now we're watching the camera. Well, she's speed walking at least. No, I'm joking. Oh my days, that's so cruel. Why are we going back again? Oh, they are going in reverse. What is the cameraman doing? Is having fun with the camera. I'm sorry. Oh my days, the camera. I know Pickles is having a lot of shots of Tandari, so I think Pickles is very happy about that. But I don't know what the cameraman is doing. The thing is, all the other feeds is going to be exactly the same because everyone has the same feed. So, oh, did you make enough for the class, Toxic? I thought of that, Lois, but I did not want to say that bluntly on
It's ready, Mr.
on stream, but you say it, so Pickles, you. Oh, sorry, someone is at the door. Sorry about that. No, but we'll get it. Just don't worry. We fine. But yeah, so I don't know what is he doing. Just 1 second to tell person. Sorry about that. It's just someone at the door. So yeah, it is your price today. I don't know what is he doing. Oh, sorry about that, lovers. I'm so sorry. What is he doing? I don't know. Absolutely crazy. This cameraman. Like, I'm so sorry. I'm sorry, Lois. I feel bad. Let me see if the other. Oh no, the other ones have gone away. So let me. This cameraman is playing. So. Oh, it is. Oh my days. That is the jury. Yeah. Oh my days. That is definitely the jury. That's crazy. Well, it still is because it's still on the screen. Because, well, oh no, oh no, oh no! Like, cameraman, move the feed. Like, get it out of the way. Let me see if I can. Like, 1 second. Let me. Oh. The thing is, technically, the trial is over now, right? So there is no problem on that happening, is there? Let me try to see if I can find another feed or anything, because if someone can check if like everybody else as having the same problem, yeah, I think everyone is having the same problem. But let me just do something. Give me one moment. Put this cover just in case. We will behave. I hope you. Yeah, I moved it. I moved it, guys. Even though we want a sneak peek, I moved it because I don't want to be in trouble. I don't want to have to go. I don't think he technically can anymore, but this is bad. This is very, very bad. I've tried to refresh and nothing is happening. My days. Please no. Please no. Please no, cause a mistrial. Oh my days. Please no. Please no. She cannot get out on this technicality. Are you serious? This would not be fair at all. So I'm just putting our overlay on just not to show the jury because it's still kind of frozen on the jury. I keep refreshing. It's not my internet, so yeah, yeah. I think everyone is having the same issue. I scouted a few things. Even Court TV has put their overlay on. So it's literally, yeah, everyone is frozen. Okay, all right. So soon. Probably they couldn't have been there, but literally everyone has gone out. They don't have, like, they're stuck on it. They are frozen. So every single feed it's having the same issue. So we're just waiting to see if it unfreezes, what is happening, or yeah, we are just putting the overlay at the moment just because obviously we don't want to be showing the jury. I don't want to be going to yeah, they probably is getting yelled at, and I don't think either. It's just deciding the sentence. It might just go directly to the judge and not the jury instead, and just him decide the fate of Megan. I don't think it can cause a mistrial because it's already done in terms like signed, read in record, in open record. So I have the same feeling a little bit. Is it better not cause a mistrial. Sorry if you hear voices in the background. It's just Nightbot has a friend over, and this decided to go freeze on the wrong time. I hope probably there with this possibilities that they are getting yelled at. And now let me have a look. 1 second. Give me let me check on something, because the thing is it can there might be a news station, the news station we were watching earlier. They were already saying something. Let me see if they
communicating with us regularly, letting us know. So we're not the latest is. Liam's not able to see anything in the media room right now. It's from what the control room is.
Okay, hang on, there's updates. Let me show you guys. Where is it?
We will make sure you see this and make sure that we get this to you as soon as we know, once they work out what's happening.
This is some news coverage from it.
So our feed is completely down from the courtroom. They have pulled that, so we're not able to show you that at the moment. We're trying to work out if that's going to be able to come back at the moment. So.
Okay, so Preston and I will stay right here. We have people working on this upstairs in the newsroom as we speak, so we'll figure out exactly what's going on and why it's down.
And also, it is not just our camera. Well, this is not going out anywhere. You're not by watching us thinking, oh, somebody else has that. This is a one feed coming out of that courtroom. Every place that you could possibly see this is seeing that same video. There is no video coming out of the courtroom right now. They're dealing with this legal issue of whatever has come up in that courtroom, separate from that hearing. So no hearing is progressing right now. We don't have a feed coming out. We're working through that and to see what happens with that. So,
all right, let's send it back to programming right now. But what you can do is you can keep it tuned here on News 5. We will pop up as soon as we get more information, and
we'll be back on with it.
And of course, on our YouTube page for WCYB, and also our Facebook page and our website when it becomes available again.
Well, we may not be leaving just as quick as we thought we were at a control room. So again, all 19 counts that she has been convicted on. We're waiting on the sentencing hearing in that first-degree murder conviction there of whether or not she will receive life with parole or life without parole. That's the big question that will come from that. And the jury gets to weigh in on that. But none of that is happening right now because this issue has come up in this hearing. So we're waiting on that to sort through and to see what happens with that, and to see when we're able to get that live video feed coming back out.
All right, what are you hearing right now? Because I'm on the orange IFB, guys, if you want to bring me up to speed as well.
We're being told Megan has now left the courtroom. Okay, so at this point, it sounds like that Megan has left the courtroom. Her defense team has left the courtroom as well. Brandon, if you're able to send that over to me as well. I think we may just want to step aside for a moment. It seems like where we are, and we'll come back once we get a little bit better, once we know when we're able to put that on.
We're not sure if
Yes.
we're able to reveal
And when we'll be
anything
able
about
to do
what's
that.
going on in the courtroom
So
right
no,
now.
no proceedings. So we're going to step aside so you guys not seeing this, was make this decision. We'll be back as soon as there's more of a hearing to happen and we're able to show that. We'll have that for you here. For right now, we're going to go back to regular programming. Pep and I are not going to move. When we're back in that courtroom, you'll be back on the air with us. For now, we're back with the regular programming here on the air, and we'll see you back here hopefully in just a few minutes.
This is a
Well, I think they are gonna stay on, and we'll stay on here because that's still going. If they're still living, I think they were like both live on the TV and both live on YouTube, and they're gonna carry on. I have the feed on my phone. That's the feed that's frozen out of the courtroom. But I don't know what's happening because he was just saying that Megan left the courtroom. The defense attorneys left the courtroom. Yes. So this is wild. I don't know what's happening. I was like, this is because nothing really bad happened, right? I was because they were literally about to either do closings for the sentencing phase or either oh, this is absolutely a wild case. Um this is crazy because the feed is still down. There is no news. No one is reporting anything. Let me see. The famous place X or Twitter, however you want to call it. So hang on 1 second. See if there's anything on here. Let me see 1 second. I'm just scouring the internet very quickly, the feed very quickly, and an hour ago. Yes, nothing as yet for people that are in a courtroom. Let me check Discord to see if anyone knows. Let me see if where would I find any information. 1 second. Because I saw someone was texting earlier about this. Oh, 1 second. Because there is a courtroom watcher, and I need to know what he's saying about this. So I need to do, I need more phones. Honestly, that's what I need. I need more phones. It's definitely, I probably could be case one, but it's just very odd that all of a sudden this happened. And hang on, let me have a look. 1 second, I'll be right back. Yeah, okay. So media might be thrown out of the courtroom. Our Megan coverage of this case might end up here because the camera accidentally shown the jury. They are in trouble. So in the beginning of this case, the judge was very adamant that they needed to be extra careful not to show jury, not to do zooms on feeds, on laptops and everything. Even a photographer on the first day got in trouble because she was using flash during courtroom, and literally got in trouble and got told that if she would do that again, she would spend 10 days in jail. The judge threatened several times the media to be careful, and if they're not, they could face legal actions and problems. So right now, they are in sidebars. They are dealing with this. Like I said, Megan is not in a courtroom. Defense attorneys are not in a courtroom, and I don't know if this can cause a mistrial or not. This is absolutely wild. The cameraman, it's probably gonna get fired, and is gonna get in very, very big legal trouble, definitely. So we are. I know. Oh boy, it's not good. It's absolutely not good. It's not good news for no one. Now we are just waiting of any news. We're gonna carry on in this news station. I still have the feed. Okay, hang on. Something is happening. The feed has gone black. You know, when we used to go for breaks, the feed would absolutely go black in and the live view one. And now don't know what's happening. Now we literally have a black screen on screen. So it's yeah, I think the camera person might be going to jail. Yeah, this what is on screen. Pickles is a local news station. They had received any information. The deliver the information. They had some information they needed to digest before they actually said something. Probably that's what it is. We are just waiting on. Yeah, there's the word on the street that the judge has ordered camera off for the rest remaining of the. I don't know if they are gonna bring back for the verdict, for the second verdict of the penalty phase. We don't know. We might just get a media statement. And what was that, Mark? I can well I can't see on my I don't know. Oh, sorry, 1 second. So, yeah. So there's the possibility that we're not gonna get. So, do you know the Mark pickles that happened? Because I'm trying to go down. Yeah. So, well, you couldn't give a sound. That is true. Let me see if I can go back and see. The court report is the one on the stand, isn't it? So let me see if I can see anywhere. Because if you know where it was, we can probably see, but try not to show the jury again. Because don't want to get in trouble for that. I literally read that with the Taylor Swift. Yeah, so grandma walked down, we saw the jury, but then when was that that the court reporter told the judge? Because that's when the camera started messing up. So I wonder. Hang on. Because I'm looking through the feed now. See, I know I did that too, pickles. I did read that. Reading that in it. I'm trying to see if I can see when did the like I think hang on. You know what? She might be monitoring the feeds, like making sure that the nothing is happening, because I'm sure the judge is not doing that. She might be watching the feed that is going out. Oh yes, I think it was here. Let me see. Let me play 1 second. I think it was Bear. Yeah, I think I found it. Did you guys remember when they were whispering something about live stream and everything? And that I think that's where, because I did heard the voice live stream. Bear was talking to the judge, and yeah. After us 8 days of watching this trial, we're not gonna know the end, because cameraman than a boo-boo. Because now, like, I mean, in terms of like of finishing, we know that she got found guilty, and I don't think that can be overturned. I think that will stick, and it will stay there. It's not going anywhere. It's just now that they can they appeal because the jury got shown? I don't think so, because it's not really related. It was after the guilty verdict, so not really. Oh, okay, sorry, I was paused on the other one. So pickles, no spoilers, please. But I take your word, we'll catch that up eventually. But it's just weird. I mean, it's. Thank you. I appreciate that of your kindness of letting me know. That I very 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 much appreciated the kindness. I mean, I don't know what we should do, because I don't know if the feed is gonna come back or not. I don't know. I don't know. You guys, because this is just wild. I don't think the judge is gonna allow media to come back. Um, I think that this is it. We are gonna find out the sentencing through the normal media outlets back in the day when we couldn't stream live trials, and that might be a, a very bad thing, for trials going forward, because of one cameraman. Because of one cameraman, we might Tennessee, well, at least probably Tennessee or judges might be a little bit more hard on cameraman and cameras, and this is not good for trial watching and live court. I know you weren't spoiling. It's fine. It's okay. I was just joking, pickles. It's all good, all good. Um, so now we are just waiting to see if there's any more information, and because the thing is, it's not technically the channels that we're watching is the cameraman. So, but I think maybe judges are trying to find someone to blame, and yeah. Oh yeah, definitely need experience, because I think they just outsource that, and they don't know what they're doing. They say that, like, it's my first day doing this, and yeah. Yeah. I think that's gonna be in posts, I think, in most courts now going forward, sadly, because of that. So if there's anything, yeah, 1 second, give me 1 second. All right. So sorry about this. Was trying to gather more information about what exactly is happening. I had to turn on my VPN to try to figure it out. Things. I really appreciate. Thank you, Lois. I had the VPN on because obviously to get access to the Greenfield County. So what the news is apparently is on Zoom only now for now until we find out some information about the resolution of the case. Is either going to be by tweet or by normal media. The case is not going to be live streamed anymore. Cameraman is in big trouble. It is gonna is have as has a hearing on the 7th of March about this. The judge was not happy, and he said that they should be back any minute. Now I'm still keeping an eye out on several feeds and several information to try to gather some, but this might be it. I mean, for the case, this might be it for the Megan. um yeah. So I don't know what you guys want to do. Do you want to start our new trial while we are waiting on this, or you guys want to just yeah. So the 7th of March 2025 is when the cameraman is going to go before the judge to about the competition of court to see if he's going to go to jail or not. So yeah, this is wild. I think this judge is going to think twice very much about the next time he's going to have a feed. So um yeah. So I don't know what's going on. There is a Zoom thing available, but I don't think no one is. A lot of people are trying to get in. I don't think they are gonna get in. I don't think they are gonna allow people in. So I think we're just gonna have to wait for the traditional media to yeah, to find it. So this is wild. So what we can do one of two things. We can carry on waiting and talking, or we can start on now a new trial. And I'm saying starting, or maybe you know what? I think I'm gonna do something wild. Listen to me. I mean, it can be a while. We can carry on listening to the hearing that we were doing, the motions for the trial that we are gonna watch, but only had a few minutes. I can put the day one start playing for the new trial while we're waiting on any news about this, if there is anything new. And oh, hang on, I'm lying.
Now, we're back. Is the state ready to proceed?
Yes, Judge.
Defense ready to proceed?
Yes, sir.
Let's bring jury in.
Everyone stand, please. You may be seated. Thank you.
All right. Mr. Scott, do you have any other proof?
Defendant rest.
All right. General, closing.
Yes, Your Honor.
Ladies and gentlemen, I'll be pretty brief. This is obviously the second part of our trial, and the state only has to prove one additional element, the aggravating factor. And in your instructions, you will hear that the factor is if the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. We submitted a copy of Evelyn's birth certificate, which will show that she was under the age of 12 at the time that this murder was committed. And it also gives Megan Boswell's birth date, which also proves that Megan was over the age of 18 at the time this was committed. You get to consider not just what was in this hearing today, but anything that you heard in the trial itself. You heard from a few witnesses today, talk about Megan's childhood. You're going to get jury instructions on mitigating factors that the defense would like for you to consider. Things like how old Megan Boswell was at the time, Megan Boswell's childhood, the things that she witnessed, role models in her life, etc. But I submit to you that there are a lot of people who have hard childhoods. There are a lot of people who have babies when they're young, and those people do not kill their children. Those people do not wrap their children in blankets, in foil, and put them in a trash can upside down. When you look at these mitigating factors, and it looks like they have submitted 11 mitigating factors, I submit to you that lots of people have childhoods like the defendant had. But you heard from her own grandmother that her grandmother and grandfather were stability for her. And I submit to you that just because you have the childhood that you have, and of course we all, you included, have different life experiences, that does not make an excuse for what she did to Evelyn. The defense is telling you that Megan Boswell deserves life with the possibility of parole, which is essentially roughly 51 years in this state, which would mean that Megan Boswell could get out in her late 60s, I believe. I submit to you that Megan Boswell she doesn't deserve that chance. Does Evelyn get the chance when she's 69 years old to start her life again? She doesn't. Neither does Megan. We are going to ask that you continue to hold her accountable. The state has proven the aggravating factor that Evelyn was under the age of 12 years old and that the defendant was over the age of 18. We have proven that. And that is all the state has to prove. And if you believe that the state has proven that beyond a reasonable doubt, we're going to ask that you return a verdict of life without the possibility of parole.
Thank you, General. Mr. Horn.
Ladies and gentlemen, I know the last few days have been emotional for you. It's been emotional for everyone. That emotion really began 5 years ago. Not just for this case, but for our community. And it has had some dividing and rippling effects. You've been sequestered, you haven't seen those things, but we have. We've seen how divided this community is over this case. Perhaps that could last and go on for a long time. You spoke very loud today when you found Megan Boswell guilty. And I think it's time that we end all of this on the right note. You have a chance to do that. I don't, state doesn't, judge doesn't, you do. You can put the defining moment, the period of what people will remember about this case, and perhaps you as jurors, because you did find her guilty. And now you have a chance to do and show the one thing that's been missing for the last 5 years. That's grace and love. We have all, everybody in this room has failed in some way in their life. It may not have resulted in a criminal charge. It may not have resulted in going to prison. But we've done something. We've wanted compassion. We've wanted grace. We've wanted love. That's how you can end this. And that's how we can start to move on as a community. And you can show her what love looks like. Because you've heard how fractured and dysfunctional her family is. Mr. Scott told you in the trial, he didn't go through a lot of things in her life. I didn't either. But I knew my mom and dad loved me. They loved me to the end. My family now loves me to the end. I don't think she's seen what that looks like in her life. You're going to get a chance. Go back there and show her. You can tell her that she's redeemable. You can end it with grace and love. General Boswell told you about those mitigating factors. You'll get them in your jury instructions. Spare her life and give her life without parole. If there's anything good can come from this, is that we can all move forward, knowing that you got the verdict that you wanted, and you ended it with the emotion of love and compassion. That's what will be remembered. I hope that's what you did. Don't be remembered for just compounding the tragedy and the tragedy and the tragedy. So easy to do that. The lasting impression that you give Evelyn, that you give Megan, that you give this community, is that love and grace can still be found with all of us. And we ask you to give her life. Let her have a chance to come out one day. That's justice as well. Justice for everybody. Thank you.
Thank you. Jennifer.
Thank you, Judge. Ladies and gentlemen, your job at this point is to determine whether or not the state has proven the aggravating aggravating factor that we alleged. And as General Massengill told you, that was simply related to the age of the child as well as the age of Miss Boswell. And clearly through her birth certificate, we have proven that aggravating factor. So then your job will be to weigh the mitigating factors that the defense has put on for you against that aggravating factor, which we have met our burden of proving. Mr. Horns asked you to end this case on the right note. And they would agree. You should end this case on the right note. And you should show Megan Boswell the same compassion and grace that she showed Evelyn. Evelyn wasn't shown any compassion. She wasn't shown any grace. You know, the one person that Evelyn should have been able to rely on to protect her, keep her safe, abandoned her, discarded her. She doesn't deserve your passion, your grace. State asks that you weigh the aggravating factor that we've proven in this case. The fact that Evelyn Boswell, at the time she was dumped in a trash can, wasn't even 13 months old, never had a chance. We ask that you return a verdict we've requested of life without parole.
Thank you, General. Okay, ladies and gentlemen, I've got another set of instructions I've got to read to you. In the criminal court for Sullivan County, Tennessee at Blumville, State of Tennessee versus Megan Boswell, defendant. Case S72869. Jury instructions, fixing punishment of life imprisonment or life imprisonment without the possibility of parole. Members of the jury, you have now found the defendant guilty beyond a reasonable doubt of first-degree murder in the perpetration of first-degree murder as charged in the first count, and first-degree murder in the perpetration of a felony as charged in the second and third counts of presentment number S72869. It is now your duty to determine, within the limits prescribed by law, the penalty which shall be imposed as punishment for these offenses. Tennessee law provides that a person convicted of first-degree murder and first-degree murder in the perpetration of a felony shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been risen by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the evidence. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you shall place no significance on this fact. The burden is on the state to prove any aggravating circumstance or circumstances beyond a reasonable doubt. She is not required to take the stand in her own behalf, and her election not to do so cannot be considered for any purpose against her, nor can any inference be drawn from such fact. Statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. TCA 39-13-204I. 1. Members of the jury, the court has read to you the aggravating circumstance which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole.
Well, I think the news station got in trouble. Well, we know that they are on. Yeah, they took it out. The The news station got struck down. I hope we don't get struck down too. So the live stream went bye-bye of that we were watching. The judge is very cranky. He is not happy. I am sure that there is no other life whatsoever. I need to scour, but we know that they are going into deliberations. I mean, there's some, yeah, that person is behind. Yeah, the feed is gone bye. So today has been a great day, hasn't it, guys? Because this is absolutely crazy. Let me take this the headline. So yeah, definitely. I don't think he's ever gonna allow a camera again, because yeah, all the channels are being put it off. Only listening, and even listening you can't listen because there's no feed anymore. So yeah, that happened. It's just well, hang on. There is another one. 1 second. Hang on, there's another one. There's another
or to imprisonment for life. In choosing between the
This
sentences
one,
of imprisonment
Zio,
for
there's on
life
the
without
screen now.
possibility of parole and imprisonment for life, you shall
Yeah, it is. Got it. Thank you, Zio. I found it too. Thanks, Zio. Thanks, girl. Appreciate you.
weigh and consider as so found, and you shall return your verdict upon the enclosed form attached hereto and made part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. Here lists the statutory aggravating circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. I've got verdict forms for you. Okay. I have verdict forms for you, and I will read those. Verdict form, count 1. Punishment of imprisonment for life. We, the jury, unanimously determine that no statutory aggravating circumstance has been proven by the state beyond a reasonable doubt. We, the jury, therefore find that the sentence shall be imprisonment for life. Signature line, jury foreperson, signature line for each juror to sign. A date with a line. Verdict form, count 1, continue. Punishment of imprisonment for life without the possibility of parole or imprisonment for life. We, the jury, unanimously find the state has proven the following statutory aggravating circumstance or circumstances beyond a reasonable doubt. Check the box of any statutory aggravating circumstance or circumstances you find beyond a reasonable doubt. Check box. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. Below, check one box only. Check box. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or check box. We, the jury, unanimously agree that the defendant shall be sentenced to life to imprisonment for life. Signature line, jury foreperson, signature line for each juror. Date, signature, blank. And the same exact form verbatim for counts 2 and count 3. Take the case, consider all the evidence fairly and impartially. Complete one of the 2 forms for each count. And report your verdict to the court.
Go with the officers. Everyone stand, please. You may be seated. Thank you.
All right, jury's out at 12:09 p.m. to consider sentencing. This court will be in recess, waiting the verdict of the jury.
Court stands in recess.
All right, so we are on verdict watch again. We are gonna keep an eye on this feed or whatever feed is playing. I don't know anymore. Because this is wild. Let me just do something. I'm gonna share this one because I need to keep tabs on this one now to see whatever happens or whenever we have words. So they have no lunch. I think they are going to straight up to this yeah, yay, we are on recess, we can go to the playground. Yes. This has been wild morning, guys. So like, first of all, like 1 hour and 30 minutes into the day, we got the verdict. We were very happy, ongoing and kicking. And it's like, okay, this is gonna be nice. We have a verdict. We're going to sentencing phase. We might finish early. Yeah, no. So the cameraman, while Megan's Boswell grandma was walking to the stage, he decided it would be a good thing to pan out, and he showed the jury. So all the cameras got kicked off. All the cameras got gone by, all the feeds, because it was only one anyway. And the cameraman now is facing 10 days in jail and maybe losing his job. That is not a good thing. So his life has gone downhill today. So that is not good. The judge, I'm sure he wasn't happy at all. So he was never happy anyway to begin with in the case. But yeah, so now we are waiting again on verdict watch for the sentence. I do feel kind of bad for him, but in a way, like, why did you try to get a shot of that? I mean, you know, the jury was right there. It's not like, so crazy. And I don't blame the judge. He did warn, he gave opportunities to everybody and everything. So yeah, so that happened. That's fun. I need to I don't, the thing is, I don't know if this station is gonna go live when they have the verdict. If not, what is happening? If you guys know anything, please let me know on there. But because the first one yeah, this is the judge in the new trial. I just put it there because yeah, hang on. Oh no, I pressed the wrong button. Because now we don't know what's happening, if they are gonna come live again, if they're not. Yeah, so it is definitely Rosie Cheeky judge. Well, this one, Zio. So this is the judge of our next case. We were doing some trial prep while on verdict watch. I mean, I don't know what you guys want to do to now. So what we can do is, while I'm waiting, because this one is basically over, what we can do is the parole hearings are live. We could go back to the beginning anyway. Oh, good. They are live as well, so that's good. I need to keep that tab open there. And yeah. So it's just yeah, parole hearings are always fun. We watch them a lot, and we can start from the beginning and try to catch up. I have literally 2 feeds ongoing. I am keeping my eye out for them, any words that are in or not for this for this judgment, for this, yeah, it's a judgment in a way. I don't think they're gonna take long anyway. I think they're gonna take about, like, what, an hour maybe not even that. So I don't think they are literally gonna take that long to deliberate on her sentencing. Is literally decide life with the possibility of parole or not, and then that'll be it. So um so what we're gonna do is, because also as well, when I was yeah, I'll be singing everything for sure. So what I was gonna say is my plans actually got cancelled for tonight. Our plans, mine and Nightbot. Not because of this, because of other circumstances in the background. So what we're gonna do is watching this until the end, no matter what. And I will be here. I will be following live and hang out with you guys. I was excited, but it's okay. The thing is, what we're gonna do is still gonna do this until the end, but then afterwards I am gonna come off. We could have maybe start the the new trial today, but I do need a bit of rest, and I need to do some investigations and set up the new trial and everything, and I want a little bit of free time as well by me, myself, and I. Sometimes it's good to spend time with yourself. Don't get any dirty ideas. But yeah, so that's gonna be the plan. So I know I need to rest. What for? I don't know, Zio. Someone keeps saying for me to go to sleep and to rest. So no, I'm still gonna be online. I'm like gonna be on Discord probably. I'm gonna be on the YouTube's world, but I just need a bit of time. I just want to do some research, some setting up for the new trial. But tomorrow morning we gonna start our new trial, and then I want to be prepared for it. And I'm still probably gonna work because I am doing research for a video that I'm planning on doing. So I still have plenty of stuff to do. Don't think that I'm gonna be lazing. So yeah, so it's just that happening. So before you guys unlike me, I'm gonna play the parole hearings. I'm joking. So let me put the headphones back on and go back to it. Oh, we're gonna start from the beginning since we have that possibility of rewind. It only started 2 hours ago, so not too bad.
Today in this hearing.
I'm so excited about possibility of a night off that I forgot to share the correct tab, didn't I? My apologies. I was like, I'm very good at this. I'm a professional.
Deputy Warden Nikki Shinbear. Raven Heath classification.
Trey Maria, Records Department. Jeremy.
Okay, nice to see y'all, and thank you for being accommodating us today in this hearing. Let's see, Mr. Jeremy Irvin, is that you seated there?
Yes, sir.
Okay, Mr. Irvin, today is all about you. We're gonna give you an opportunity to tell us what you expected of us, what you'd like us to do, and why we should do that. We're gonna give you a chance to convince us of that, and then one of us in particular is gonna lead the question of you. And then we're going to hear, before that, we're going to hear from one of your supporters that's here, Mr. Sean Shepard. He's here to support you. We'll hear what he's got to say. And then we'll ask you some questions, and then we'll make our decision. You got all that straight?
Yes, sir.
Okay. Okay. And what is your DOC number?
389956.
Okay. All right. All right, well, we'll go ahead then and get started. Since it's about you, let's hear what you got to say.
In 2012, I was charged with 7 counts of felony criminal knowledge of a juvenile. In 2016, I was found guilty and sentenced to 10 years for my charge, for my actions. I'm very sorry. I judged myself. I looked real deep within myself to find peace for what I've done, because what I've done was very horrible. And it hurt me every day to live, to know that I hurt somebody. I hurt a family as bad as I hurt them. And in that time period, I lost my mom, and it seemed like my world just fell completely apart. And I hated myself even more because I lost everything that I've ever wanted in life in such a small period of my life. And one day I awoke and said, man, this is not what my life should be. I should have took better control of my thoughts, my actions that led me to this. And as my mom would always say, that you were better than this. So every day I took something that my mom would tell me, and I would remember it, and I would hold on to it, and I would take a step forward to better understand why I was here, what I could do for myself while I'm here, and be a more mature person with my actions. And in that process, I've woken in myself a desire to want to live, to want to be a happy person, to want to help and not hurt. And I've applied myself to the best of my ability here to learn tools that I could use on a daily basis to help myself, to go forth, to look at high risk situations and be able to know who I can talk to, know what I should do, and knowing how to keep a cool head in situations that I have no control over. And for my actions, I would like to say that I'm sorry to my victim. I'm sorry for what I did. Words can't take back my actions. And I hope that what I've done has not taken that light from her, but has given her peace to know that I'm trying to better myself. I'm trying to do everything I can to be a better person. And every day I try. To my family, I'm sorry for letting them down. I was trusted and I failed them. The community, I was offered a very generous plea bargain, and I turned it down, and I forced everybody to deal with what I was going through instead of stepping up, just taking my charge, taking what I've done and the responsibility for what I've done. And I'm sorry. I thank y'all for this opportunity. I stand truly a changed person today. A lot has happened in these years that has passed, and I stand deeply saddened and happy that I am a better person. I'm sad for where I come from, and I'm happy that I can use it to better myself every day. I thank y'all for this opportunity.
Okay. All right. Thank you, sir. We appreciate those words. And somebody, Mr. Tillis, will be asking some questions in a few minutes when we turn it over to him. Warden, what kind of record are we dealing with here?
Well, Mr. Prater, Jeremy, he's done well since he's been here with us. He hasn't had a write-up. He's only had one write-up, which is, commendable. That was back in 2018. So many years ago, and he received just a verbal reprimand for that. Since his last hearing, we recommended at his last hearing he needed more programming. because he did. And I'm happy to report that he has completed many things since his last hearing in February of 21. He's completed all phases of the risk management. He's completed victim impact, which I think is very important, was very important. And he's completed that. He's completed living in balance, our substance abuse program, both phases of that, inside out dads, thinking for a change. He's worked hard in these last couple of years. So, I have to commend him for that. And he hasn't been a problem here. My only concern that I would note to the board, we talked about this yesterday in my meeting with him. He does not have a residency plan right now approved, which we know is a requirement and he will need. And he really has, right now, no job opportunities. He hasn't been able to secure anything of that nature. So, naturally, I would recommend, no matter the board's decision today, we need those things, especially the residency plan. Considering this change.
Thank you, Mr. Warden. We appreciate that. Sean Shepherd, would you go to the podium, please, sir, and talk to us and tell us in 3 minutes or less what you, we don't mean to rush you, but we have to keep these hearings as they're going, and tell us why you think that Jeremy is qualified to be out.
Okay, well, I know Jeremy. I married his mom in 2006, but I've known him for 30 years. He's a good-hearted person. The main reason that I came here to speak to this residency plan and all of that, I'm a chemical engineer. We were in South Africa. I married his mom. We lived in South Africa when he got out, and all this stuff started. I really regret that I wasn't here to help him get on track for that. But like I said, I'm a chemical engineer. So for over 35 years with the company, I had the resources to make it happen. I owned some properties. That was the previous residence plan, was to get him out on one of those. Since he didn't get out the last time, we would kind of go back to that plan. He has, as well as a support network in Lake Charles, 3 brothers. One of them owns an environmental services company, so he will be able to get employment through that. He also has an aunt who cares for him very much. I think this time he's gone as far as he can inside of the system. He's taken as much of these classes as he can. I speak to him every Sunday. He works out. He very much cares about his physical health. He's working in the garment factory. He's gone as far as he can inside of the system. I will give you my word that we will get him a plan. He can stay with me for a little while until we get him set up. I got a vehicle, get him a job. I came here to give you the other chance.
We thank you for that. Thank you for being the kind of friend you are and whatever to him. Okay, that's all. We don't have any other questions, I don't think of. Okay, Mr. Tillis, this is assigned to you, I believe, and would you lead the interview?
Good morning, Mr. Jeremy.
Good morning.
How are you? Tell me, I saw where you took about 26 classes. Which class impressed you the most?
The victim impact. I would say the victim impact because I was struggling to get in that class, and I actually wrote several letters asking for influence to be able to get into the class, because I wanted the class because something inside of me changed, and I wanted to hold myself more accountable, and I needed to find out how. And that's what I expected out of that class, to hold myself accountable for my actions. And in the class, I learned how that what I did not only affected me, but affected so many other people. And there's a bigger part of me that wants to bring awareness to. It happens so much that I didn't even realize it, that crimes are in every minute to every second to every hour. There's so many crimes happening, and the ripple effect from the crimes are horrible. And Miss Morgan that put it on, she was the perfect facilitator. And she helped us understand our actions and how it hurt many people and how we could use it to go forth and help others. And then I would say the positive one would be, thank you for a change, Mr. Staley. He taught us how to pause for a second and to think about what we're gonna do in reaction to whatever situation, and to think about it and make a logical answer in our own mind, and to know that whatever we're thinking about is what's gonna play out in our life. And those two classes, and many other classes, the parenting classes, because I've always wanted to be a father. I've always desired to be a father. And knowing that I'm the head of the house, so what I do determines what the family does. And I really hold that high in my heart. And hold myself more responsible because I was the head. I crossed the line. And I'm
I
sorry.
see. Yeah, I see. At the time, were you doing drugs?
I was using, I hurt my back and I was using medicated, opioids. I guess you would say that. I don't remember the name of them, but they were high drugs, prescription pills from the doctor.
I see. I have no more questions.
Yeah, I'm looking at your past criminal history. And I see that you were arrested 7 times, but 23 charges and 10 of them were against a person, and you actually have been convicted of 9 felonies. Most of them being simple burglary of an inhabited dwelling, but you got one that stands out, attempted first-degree murder and false imprisonment that you were convicted of. Can you tell me a little bit about that charge? What happened there?
Yes, sir. Me and my little brother, we were young at the time, and we both ran away from our family, from our mom and our dad, being very independent. And we wanted to go live with our dad in Indiana. And we stole a truck, got in a high-speed chase, and jumped out the truck and fired a gun into the air. And I tell this story a lot because this story has helped me grow up. Because when I was younger, when cops started coming on the TV, my mom used to make us sit down and watch it to steer us away from crime. And the pattern that I seen was every time a gun was fired in the air, a person was able to get away. And I don't know how I made that split-second decision to fire a gun in the air. I don't even know why I had a gun on me, period, other than I was just scared to death, and it gave me some type of comfort. And I jumped out the truck and fired a gun in the air. And we fled the scene, and we thought we were running into an abandoned house, and the house was occupied. We stayed there a while. The occupants prayed with us, fed us, doctored us up, and we left. And we got into another altercation, and I was maced, and my little brother grabbed the gun and fired the gun in the air. And we got away again, and then sometime later we were apprehended.
So the false imprisonment comes in with going into the house that the people were in?
Yes, sir.
All right. And what was the point of all the burglaries? Y'all was on drugs then, or just for the fun of?
At that time, I was a runaway juvenile, hanging with the wrong crowd, and we were hotheads. We vandalized, stole anything to get high with.
So tell us why you think with that kind of criminal record that you would be a good case to release back to the streets. Why would you be a good case now? What's changed in
inside of you?
I judged myself, I found myself guilty, and I applied myself to learn, to correct, and to grow in maturity and in spirit every day. I've taken a lot of class. I've taken my incarceration serious. I didn't do anything to enjoy myself here. Every day I apply myself some way to understand why I'm here. I didn't have fun. My first incarceration, I had fun. I did everything that I wanted to do. Here, I didn't. I applied myself. I went to classes. I took part in speaking with people, helping people, and to grow. That was the only thing that would help me be more successful if I took this time and this opportunity of these classes and the people that are around me to grow.
And I see that in the beginning of this instant offense, this current case, you told the police that you didn't have anything to do with any of the victims, that you never touched anybody, never had sex with anybody. Sounds like today you changed that story, correct? You admit?
Yes, sir.
And what was the motivation for that? Why would you do something like that?
I was in a bad state, had a bad mind frame. I was very lonely and depressed. I lost my job. I lost my truck. I lost where I was living. My world was falling apart, and some way I tricked my mind into finding comfort in the foolishness I was in. And it was a very bad decision.
Okay, let me ask, when did you get sentenced?
2016.
2016.
Yes,
And
sir.
what was your sentence?
10 years.
And when is the state of Louisiana going to let you out regardless of our decision today?
Next year.
Next year, right?
Yes, sir.
Okay. Did you plead guilty to the crime, or were you found guilty by a jury?
I was found guilty by a jury.
So you made them go through the process. You didn't admit it until you got. And you're getting out next year anyway.
Yes, sir.
That's all I got. Mr. Tillis, are you prepared to vote?
Yes. Mr. Jeremy, I see the remorse in you. I'm really happy to know that you're really trying to better yourself and following the warden's advice. Due to the victims and their concern, my vote's going to be to deny. But I do hope you continue to improve yourself so that when you do get out, that you will be a better person.
Thank you.
I'm going to concur with Mr. Tillis for the same reasons, and also the fact that you ranked as a moderate risk on a sex offender static 99, which still is a problem.
Okay, thank you. And I'll concur with my colleagues. I'm sorry to tell you, but that your parole request has been denied today. You're getting out next year anyway. We want to commend you on your attitude, on your classes that you've taken, stepping up, doing all that you need to do. I want to tell you, I believe in second chances and all, but I think you need to spend the rest of your term and your sentence. So anyway, that'll conclude this hearing. The time is 9:26. Thank you.
Thank you.
Good morning, Warden. We're back at your facility there at Raymond Hunt, and Raymond Lord. And the time is 9:37. We've already convened as the Committee on Parole. And you can see from our name tags who we are. None of that has changed or anything. The only person that's changed is Mr. Cornell Bush Jr. Mr. Bush, is that you?
Yes, sir.
Okay, tell us what your DOC number is.
It's 419340.
19340. Okay, let me tell you how this thing is going to go. All right, we're going to talk to you in a few minutes and you're going to be able to lead the show. You're going to tell us why you think that you're deserving of being paroled today. And you can tell us anything that you want about how you reformed or not reformed or anything that you want to tell us. It's going to be your floor. And then we're going to go to the wardens and see how you've done at the institution. Then we will move on and we'll talk to a number of people that have signed up. In particular, 3 that will be allowed to speak on your behalf. And then we're going to talk to, looks like 4 that are going to speak in opposition to what your request is. Once we've heard all of that, we're going to turn this thing over, and Mr. Barra is going to lead the interview with you. Explaining the process is probably taking longer than the whole interview is going to be. Okay? But we're going to give you your shot right now to tell us why you think that you are deserving of a parole and shortening your time to serve. Mr. Bush, it's all your show.
Mr. Prayer, just if I may, for the record, Deputy Warden Stephen Bordelon has joined from the Raymond Board staff, just for the record.
Okay, thank you, sir. Appreciate you.
Yes, sir. All right, go ahead.
Make sure I said that. Okay, Mr. Bush, go ahead. Tell us why you're in jail and what you did and all of that.
I'm in prison because I committed a crime that resulted in the murder of a pregnant woman and another man shot. And it was a heinous crime. I was a willing participant. I was there and I was part of it. I fled the scene. I couldn't. It was bigger than what I expected, but I was a willing participant. And as a result, there are families who do not have a daughter, an unborn child. As a result, another family have to suffer their son or their brother that was shot. And I know that was it would leave an impact on their lives. Today, I'm not that person. I'm a genuine person. I made bad choices. I made horrible choices that resulted in a fatality and the hurt of someone else. Today, I seek to be a person that seeks education and rehabilitation. I take classes whenever they're available. I've taken Experiencing God, and this was one of the classes that began to take me out of the dark that overshadowed me. For so long, I beat myself up about the crime that I committed. And this began to impact my life, teaching me that God is always pursuing you. And that helped me to come out of that. Once I come out of that, I kind of leveled up and I began to seek education. I got in Wiley College and I got a degree in business management. I've taken victim impact, and this course, it didn't do what I was expecting, where I was expecting to be condemned and finger pointed at, but it taught me statistics and hearing how people respond to crimes being committed against them. So I developed an empathy, and shortly after my sister, she was pregnant with her first child. She was 7 years old, 8 years old when I first come to prison. And today she's married. She has 2 kids and she's raising a household. But when she came to visit me once in the first pregnancy, it really shook me because I realized what I did, what I was a part of. And when I looked at her, I didn't express it to her or anything. I went along with the visit, but after it was gone, all I could say is, God, have mercy. Look, I know what I did. I can't believe it. And I kept saying to myself, what have I done? Because it reminded me of what I caused. It's a serious matter when you know, any type of violence against anyone resulting in a murder, but this is a pregnant woman, and it was totally wrong and against everything that I believe and stand for. So today I believe I'm worthy of a chance because number one, I've matured. I'm 52 years old. I was 23 when I come to prison. And you know, not saying that age alone matured me, but going through the situations that you go through in prison, if you don't mature, you will go backwards until you grow up. And I've learned to deal with inner things. They call it self-talk and anger management. I did a lot of self-talk. So when I think of the victims of my crime, and I want to say that I'm sorry to I'm sorry to the victims and their families. I want to say that I'm so sorry to them. And you know, another thing they teach you in victim impact is this. When you ask your victim, the victim of your crime, to forgive you, you place an additional burden on them. But to me, saying I'm sorry and asking forgiveness is a twin thing. But I don't want to add a burden, but the desire to ask for that is there. I just want them to know that I am sorry for what I did. I'm sorry for what happened, and I'm sorry for what they've gone through. I know it's been a long struggle for them. I know I've left a scar on their lives, on their families' lives, on their friends, because I know they care for them as well. But and that'd be it.
Okay. Thank you, sir. I appreciate that. That was a good interview. Warden, would you tell us exactly what kind of fellow you've been?
Yeah, yes, sir, Mr. Prater. You know, as always, first and foremost, my sympathies, deepest sympathies to the victims and the families, as always. And I hope they understand that, you know, my job is to talk about Mr. Bush and not the crime. So again, you know, as always, my sympathies to the families and the victims. But you know, Cornell has improved. He's done, you know, his disciplinary history is good. He hasn't had a write-up in over 5 years. Before that, it was 5. So he's had one write-up in the last 10 years, basically. Completed a lot of classes. Since his last hearing, he completed, as he spoke quite a bit on, the victim impact program. And I think he learned quite a bit from that. His last hearing, you know, we had long discussions about that because, you know, he downplayed his role in the crime during that hearing. And we spoke after that, and he has learned. And as you can hear from him, he now accepts responsibility. He understands that, you know, you can't downplay your role in those situations. You were there, you were a willing participant. This is just as much your fault as it is any of the other ones. And I believe he understands. I believe he's learned a lot from those classes. He's achieved trustee status, which I'm proud of him for that. He committed a terrible crime, but he's used his time well while being here, and has learned a lot, I believe. So he's been doing well.
Okay. Thank you, Mr. Warden. I appreciate that. Okay, we'll start out hearing from people that are in favor of this request. We'll start out with Miss Mia Lowy with the first organization, First 72. Mia, are you ready to talk?
Yes, sir, I am.
Okay, would you go ahead and start us out, please, ma'am? And on all the comments, we're going to try to limit everything to about 3 minutes.
Yes, sir.
Thank you.
All right. Well, thank you to the board for giving me the opportunity to speak today in support of Mr. Cornell Bush. My name is Mia Lowy. I'm the Director of Client Services at the First 72 Plus. We are a reentry organization based in New Orleans, and our entire goal and mission is to stop the cycle of incarceration by providing adequate support to those returning home from prison or jail. Mr. Bush sought our organization out. He got in contact with me by writing a letter to our office and was asking for support in his parole board hearings and support once he is eventually released. From my experiences with him, he is very motivated, proactive. He has shown that he can handle responsibility as a trustee and also holds very near and dear to his heart his veteran status. Our organization has secured housing for Mr. Bush once he is released. He will work with our organization to progress with certain milestones or goals that he may set for himself, one of them being employment. So he will work with his assigned case manager to create a resume, connect with job training programs, attend job fairs, and submit job applications with fair chance employers. He has experience in construction and landscaping, which lends itself well to a lot of available jobs in New Orleans. And he's also interested in working offshore, which is a goal that we will work towards with him. He'll work with our economic empowerment team to open a bank account, create a budget, and begin saving to afford an apartment on his own. Our public benefits clinic will assist him with anything he may need regarding documentation or public benefits, so food stamps, Medicaid, same thing with an ID, a birth certificate, a social security card. We will also help him with any of his health goals. So getting him set up with a primary care physician. He has already completed an assessment with the Council on Drug Abuse, also known as CADA. So they have already set him up for once he's released to attend free counseling sessions once he returns home, which will meet both of his mental health and substance abuse needs. We have a couple of social support groups. We have a 9 Steps to Staying Free class, which is a weekly peer mentorship class. It is modeled after a lot of the classes that they take while they're inside. So victim impact, responding versus reacting, things like that. He'll be in our life skills class, which will help him readjust to living in the city, learning rename street names, answering the conviction question during a job interview, setting goals. I've been working with Mr. Bush's family since I believe last September, and I can really sense how much they would love to have him home. He has just an immense amount of familial support, and I believe that the combination of our organization and his family, he will stay on the right path and find a lot of success once released. So thank you so much for your time.
Thank you, ma'am. Appreciate the work that y'all do and appreciate your lending your support. Okay, just for the record, Mr. Cornell Bush Sr. and Cassandra Bush are with us by Zoom, but they will not be speaking. The next one to speak will be Chantel Barista, if I'm saying that right, or Barista, Chantel, who is the sister. Chantel, are you available now?
Yes, sir, I'm here.
Okay, would you tell us what you want to say and limit your remarks, please, ma'am, to 3 minutes or less?
Yes, sir. First off, I just want to say good morning. My name is Chantel. I'm Cornell's sister. I would just like to say thank you for allowing me to speak here today. And I wanted to express my family and I's support for Cornell. I speak with my brother maybe once a week, more so. And personally, I've watched him speak and learn from programs provided in experience. And the experience, it most definitely has helped him, it's helped shape him into and also reflect. And I'm sorry, I'm nervous. What I'm trying to say is basically the programs that he's been doing, I've seen how it has reflected through his life and just the way that he speaks and, become a more responsible person. As his sister, I can attest to the fact that Cornell understands the impact of his past actions, and through the reflection of past conversations we've had, We believe that granting him parole would not only benefit him, but also allow him to give back to the community, as he often speaks about starting various businesses, such as a janitorial business. He continues to take the initiative to educate himself by reading different business books, and it's something I personally see that he's passionate about. And I have no doubt that he will follow through with any goals that he has. Like Miss Mia was saying, working offshore, he's spoken about that a lot as well. Where I just see the motivation, and our family is ready to support Cornell upon given the opportunity for release. There are plans in place, such as housing arrangements, job opportunities, and community support through our local church. Also, reliable transportation. We are committed to being there for him, helping him navigate any challenges he may face. And I'm confident that he will make the most of a second chance based off his attitude, consistent, positive behavior, and also what he has accomplished during his time. My family and I humbly ask that you please grant him release, and thank you for your time and consideration.
Okay, thank you. We appreciate that, Chantel, and thank you for your words. And you sound like a wonderful, supportive sister. We'll hear from Chris Bush now, the brother. Mr. Bush.
Good morning.
Good morning.
Good morning, parole board members, and thank you for the opportunity to speak. So I'm speaking on behalf of my brother for his consideration of parole. The request is not to diminish really of any of the profound loss suffered by the victims and their families, but rather really to present personal transformation, rehabilitation, and readiness to re-enter society as a reformed man. I truly believe Cornell deeply regrets his involvement in the tragic events, fully acknowledging his devastation impact of those actions. The loss of a daughter and a mother, and an unborn child, as well as the pain endured by the surviving victim. I think it's something that he carries with him daily now and fully recognizes. Through a lot of years of introspection and counseling and rehabilitation programs, I think he's really sought to truly understand his past mistakes and has dedicated himself to personal growth. He's obviously completed a lot of programs and counseling. His remorse is genuine. He's used his time, I think, wisely, right, to reflect and improve as a person. And I think just, obviously you could see today he has a very strong support system ready to help him reintegrate into society. So as a family, we stand with him, providing stability and guidance to ensure his success, and making sure he's committed to making a positive contribution and really honoring the lives that were impacted by his mistakes. So we fully respect and understand the deep pain and the trauma experienced by the victims' loved ones and everyone involved. We acknowledge that there's psychological, physical, and emotional wounds that may not ever fully heal. And we deeply regret, right, that irreparable harm that was caused, acknowledge their pain and loss. And so we don't seek to diminish that in any kind of way. But at the same time, we do believe in the power of redemption as a way to not erase the past, but a way for Cornell to honor the lives impacted by his actions through meaningful change and positive contribution. So Cornell is not the same person he was 20 plus years ago at the time of his conviction, at the time of the crime. He's taken full responsibility and taken every possible step to rehabilitate himself and make amends for his past actions. And so with that, we humbly ask for his consideration for parole. And I thank you for your time to let me speak.
Yes, sir. Thank you, Mr. Bush. Thank you for your words. And you also, like your sister, seem to be very supportive and a close family. And we thank you for that. We'll move on to the opposition. First off, we'll hear from three victims, or three relations to the victim. And then we will hear from, finally, we'll wrap up with the St. Bernard Assistant District Attorney Charles Ward will end the opposition. So we'll first hear from Bridget Bartholomew. Bridget, are you available? Okay. Bridget, would you tell us what you want to say? You're still muted, ma'am.
Oh,
Okay, now.
good morning. How y'all doing? And wish everybody well. Well, my opinion, I understand he been rehabilitated and everything, but he don't realize we still don't have her. We don't have her. We don't have the baby. Her son is going through trauma from that. It's a hurting feeling to know, just like his family would love to see him, he's still walking. He's still able to do what he have to do. She can't do that no more. This baby had never experienced a foot on earth. I see no reason for him to be able to come back into society and live like nothing never happened. I'm not for him to get out of that. And
their cross-examination under this proffer is still needs to be in conjunction with your.
One of the first things I wanted to just cover before we start getting into my ruling pertains to the media. And I did look at things, and again, like yesterday, I told you that I wanted to make sure that everybody in the media had looked at my order and that they would abide by it. One of the issues or questions that I keep getting is, can we report contemporaneously or just a 30-minute delay that is in my order? Does that pertain to that? And I thought about it, and I will allow you to report. I don't think I can prevent you from reporting on that. Everything else in the order does stand. I don't think I specifically really addressed that point, but I just wanted to clarify that because I think there's been a lot of questions about that. I am concerned, though, I do not want people coming in and out of flurry. I don't need distractions for the jury. Okay? I think that will be the last time that we address anything pertaining to the media. But again, I'm thankful that you're here, and our courts are open to the media. All right. I've spent a considerable amount of time looking at case law, these excellent briefs that have been presented to me, your oral arguments, and I am going to grant the state's motion, amended motion in limine, and I'm going to exclude any reference to child pornography involving the victim, her juvenile daughter, I think it's AMP, or Bradley Post. So I'm going to be excluding that, and that also includes the cross-examination of Mr. Post. I will get into that in a moment. I know that we've talked with counsel as far as your ability to do a proffer, and he's going to be coming in for a in-camera hearing shortly. I find that it is not relevant under Rule 401 or 2. This evidence has no tendency to make the existence of any fact that is a consequence of this murder more or less likely. It will not assist the jury at arriving at the truth of this murder. The question is, did the defendant commit this murder? And that's the only issue. The child pornography is not relevant, and even if so, I would exclude it under Rule 403 because the probative value is significantly outweighed by, and I know normally we jump to unfair prejudice, and that is part of it, but I would focus on confusion of the issues and misleading the jury. If at some point it does become relevant, then that certainly could be revisited. And again, even if it were found to be relevant, which I don't think it is, it's not coming in pertaining to Post under 608C for bias. I know that y'all, that was your argument. Certainly you're going to be protected in proffering. But Mr. Post, he's going to stand or he's going to have his day in court, and he's going to have to, but he is not, he's not pled, and he's not been tried yet. He's not a co-defendant. He's not an eyewitness to the actual crime. He basically found the body of his girlfriend, fiance, and he's going to be here testifying under subpoena. And it's my understanding he's testifying to finding the body, reporting the murder, which is corroborated by the 911 phone call. And the investigator, the victim was his girlfriend, and he is a victim of harassment. He does have serious charges against him, but these are pending again, and he's innocent until he's proven guilty, and he will have a trial. Also, the Attorney General's office will handle this trial, not the Greenville Solicitor's office. He's not a cooperating witness. He's not providing any type of inculpatory, evidence linking the defendant to the crime. So they're not offering him in any way to like I said, to inculpate the defendant of any type of wrongdoing or indication of guilt. Also looked at the State v. Smith, State v. Mitchell, State v. I can't pronounce this, Beesry or whatever, Pradubsri. And I don't find that the bias issues that were in those cases are in play here. I also reviewed, I think it's Delaware versus something. I think it's Van something, but thank you. Defense can ask Mr. Post if he has any pending charges, but not go into the specific charges. Certainly on the proffer, there will be certain allowance, but I do have the right to impose a limit on the scope of defense counsel's cross-examination and not violate the confrontation clause. And that would be under the another wonderful hard pronunciation, but the Friedrich, F-R-E-I-T-H case. Also, it would be consistent with Rule 611A. Okay. And I don't think I have anything else to add to that. Anything from the state?
Nothing from the state, Your Honor. So your wish now is to allow Bradford's to offer his testimony. And for the record, Your Honor, what is the purpose of his proffering? So to allow the defense a cross-examination?
Yeah, and you're going to,
you just made.
You're going to ask questions that you're going to ask. Even though I know that you've indicated that you did not feel that was necessary, but I think that allows them to have cross-examination on that. Counsel for Mr. Post will be here. I will have to, rule if he does assert the Fifth Amendment, then I'll have to rule at that time under whether or not it's just facially prejudicial to him, or if somehow in a chain of events it could, be something improper to be used. Okay, but they still have the right in proffer to ask it to protect the record. Limited.
Thanks. And that's in conjunction with your ruling, Your Honor?
Huh?
Their cross-examination under this proffer still needs to be in conjunction with your ruling?
Well, the proffer, I'm going to allow them to at least ask what he has been arrested for, but that will not be asked to the jury. They can ask him, obviously, that he's here under arrest. When they do the in-camera, or when we do the in-camera, I'm going to have counsel for Mr. Post. I'm just going to ask them to sit over here. Mr. Marchant, you're here. Okay. You got your other cohorts?
I'm ready to go.
Okay. Anybody else coming?
Mr. Ariel should be here shortly.
Okay. All right. Well, I guess we just need to wait until he's here. Anything else, Solicitor?
No, thank you, Your Honor, for that clarification.
Anything from defense? Did y'all?
Not right now, Your Honor.
Okay.
I think Mr. Marchant said we can proceed without Mr. Ariel, if that's okay with Your Honor.
No, that's perfectly fine. I just wanted to
Looking at the timeline of the jury be here at 10, if we can get through this, hopefully start this trial.
That'd be nice.
Bring up.
Yes, sir.
counsel as I have previously. In the words of Judge Pyle, these are opening statements, not arguments, counsel. Okay, bring them in. With the attorneys in this matter. And again, I just want to thank you for your patience and thank you for your service. Can you please swear the jury?
Please stand and raise your right hand. The correct response to the oath is I will. You shall well and truly try the case 2022 GS 232194, the state versus Zachary David Hughes, indicted for murder and possession of a weapon during the commission of a violent crime. 2024 GS 235425A for burglary first degree, 5412 for harassment, and 5413 for conspiracy, and a true verdict rendered according to the law and the evidence, so help you God. I will. Thank you. Please be seated.
Ladies and gentlemen, you are now the jury in this case, and I'll take a few minutes to tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions on the law, and those instructions will control your deliberations. The criminal case has been brought by the state of South Carolina, and I will sometimes refer to the state as the prosecution. The state is represented in this trial by Solicitor Walter Wilkins and Jay Covert. The defendant is represented by his attorneys, Mark Moyer and Andrew Mormon. The defendant has been charged by the state with murder, possession of a weapon during the commission of a violent crime, burglary first degree, harassment, and conspiracy. The charges against Zachary David Hughes are contained in the respective indictments. The indictment is simply the description of the charges against Zachary David Hughes. It is not evidence of anything. The defendant has pled not guilty to these charges and denies committing the crime. He is presumed innocent and may not be found guilty by you unless all of you unanimously find that the state has proven his guilt beyond a reasonable doubt. South Carolina law makes the jury the finder of facts. You 12 alone are the finders of facts, and it will be your duty to decide from the evidence what the facts are. You will hear the evidence, decide what the facts are, and then apply those facts to the law I give you at the close of this case. That is how you will reach your verdict. In doing so, you must follow that law, whether you agree with it or not. The evidence will consist of the testimony of witnesses, documents, and other items received into evidence as exhibits, and any facts on which the lawyers agree or stipulate. The same law that makes you 12 the finder of the facts makes me the judge of the law, and our rules of evidence control what can be received into evidence. When a lawyer asks a question or offers an exhibit into evidence and a lawyer on the other side thinks it's not permitted by the rules of evidence, that lawyer may object, and that simply means that the lawyer is requesting that I make a decision on a particular rule of evidence. South Carolina law forbids a trial judge from making a comment to a jury about a fact in a case. Therefore, because it may be necessary for me to comment on a fact in applying our rules of evidence, it may be necessary for me to talk with the lawyers out of your hearing by having a bench conference while you are present in the courtroom or by excusing you from the courtroom. The purposes of these conferences is to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. I ask you, be patient during these breaks. Certain things are not in evidence. Statements, arguments, questions, and comments by lawyers representing the parties in the case are not evidence. Objections are not evidence. Lawyers have a duty to their clients to object when they believe something is improper under the rules of evidence. You should not be influenced by the objection. If I sustain an objection, you must ignore the question or exhibit and must not try to guess what the answer might have been or the exhibit might have contained. If I overrule the objection, the evidence will be admitted, but do not give it special attention because of the objection. Testimony that I strike from the record or tell you to disregard is not evidence and must not be considered. Anything you see or hear about this case outside this courtroom is not evidence unless I specifically tell you otherwise during the trial. Finally, some of you may have heard the terms direct evidence and circumstantial evidence. Direct evidence is testimony by a witness about what the witness personally saw, heard, or did. Circumstantial evidence is indirect evidence. That is, it is proof of one or more facts from which one can find or infer another fact. You may consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give to any evidence. In deciding what the facts are, you may have to decide what testimony you believe and what testimony you do not believe. You may believe everything a witness says or only part of it or none of it. In deciding what to believe, you may consider a number of factors, including the following: the witness's ability to see or hear or know the things the witness testifies to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has an interest in the outcome of the case or any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial or by other evidence, and lastly, how reasonable the witness's testimony is when considered in light of other evidence which you believe. It is my responsibility to rule as a matter of law as to whether certain testimony is admissible. But once the testimony is admitted, whether or not you believe it is solely for you to determine. To ensure fairness, you as jurors must not talk among yourselves about this case or about anyone involved with it until the end of the case when you go to the jury room to decide your verdict. Do not talk with anyone else about this case or about anyone who has anything to do with it until the trial is ended and you have been discharged as jurors. Anyone includes members of your family and your friends. You may tell them that you're a juror, but do not tell them anything about the case or discuss it until after you have been discharged as a juror. Do not let anyone talk to you about the case or about anyone who has anything to do with it. If someone should try to talk to you, please report it to me immediately. During the trial, do not talk with or speak to any of the parties, lawyers, or witnesses involved in this case. You should not even pass the time of day with any of them. It is important not only that you do justice in this case, but that you also give the appearance of doing justice. If a person from one side of the case sees you talking to a person from the other side, even if it is simply to pass the time of day, an unwarranted and unnecessary suspicion about your fairness might be aroused. If any lawyer, party, or witness does not speak to you when you pass in the hall, ride, the elevator, or the like, it is because they are not supposed to talk to you or visit with you pursuant to my instructions. Do not read any news stories or articles, watch TV about this case or about anyone involved with it, or listen to any radio or television reports, podcast, anything of the like about this case, any social media, or about anyone involved with it. Do not do any research on the internet about anything in the case or consult blogs or dictionaries or other reference materials, and do not make any investigation about this case on your own. This is your duty as the jurors in this case. Do not make up your mind about what the verdict should be until after you have gone to the jury room to discuss this case with your fellow jurors. Keep an open mind until then. I'm often asked about note-taking. You are not able to take notes during the trial of this case, and the reason is that I want you to pay close attention to each witness as he or she testifies and not be fixated on taking copious notes. The first step in the trial will be the opening statements. The state in its opening statement will tell you about the evidence that it intends to put before you so that you'll have an idea of what the state's case is going to be. Just as the indictment is not evidence, neither is the opening statement evidence. Its purpose is only to help you understand what the evidence will be and what the state will try to prove. And after the state's opening statements, defendant's attorney may, if he chooses, make an opening statement. And at this point in the trial, no evidence has been offered by either side. Next, the state will offer evidence that it says will support the charges against the defendant. The state's evidence in this case will consist of the testimony of witnesses and may include documents and other exhibits. I remind you that the defendant is presumed innocent, and the state must prove the guilt of the defendant beyond a reasonable doubt, and the defendant does not have to prove his innocence. On both sides, the state and the defense will each be given time for their final arguments. I just told you that the opening statement by the lawyers are not evidence, and the same applies to the closing arguments. They are not evidence. In their closing arguments, the lawyers for each side will attempt to summarize and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you're to use in reaching your verdict. After hearing my instructions, you will leave the courtroom together to make your decisions. I will inform you when you can begin deliberating. It is your added duty, Ms. Foreperson, to preside in the jury room and be the jury spokesperson here in court. It will also be your duty to write the verdict, but I will give you further instructions about that at the conclusion of the case. We will now begin the trial. State.
Your Honor, may it please the court. Good morning, ladies and gentlemen. My name is Walt Wilkins, and myself, along with Jake Hoferth, we are the prosecutors in this case. This is Detective Jared Sparkman and Master Deputy Blake Wolf. They're the co-lead investigators in this case. I want to thank you for your service and thank you for giving us the opportunity to present this case to you. The state has the obligation to prove the charges beyond a reasonable doubt. And that's the standard that you're going to hear from the judge, you're going to hear throughout your deliberations and throughout this trial. We have to prove the case beyond a reasonable doubt. And there's a lot of folks in this courtroom right here that you see. So we are the prosecution. We represent the state. We have the honor of representing the state in this particular case. The defendant sits over there. That is Zachary Hughes, along with his attorneys, and they represent him in this particular case. But there's many more other individuals in this case. We have the court reporter. She's very important. She is taking down everything that we're saying, recording, so we can have a record of this entire case at its conclusion. And so that's what she'll be doing, and she'll also be marking exhibits. So if you see her over there writing on things, that's what she's doing. She's marking the exhibits in which we will identify things that we will be presenting to you for your review. This is Madam Clerk. She's involved with a lot of paperwork and handles all the evidence that we submit into the court. So she'll be handling all the exhibits that you will get to review upon your deliberation. And of course, we have the judge up here. And if you'll notice, the judge is a pretty important person. He's got a black robe. He gets to sit a little higher than the rest of us. There's a reason for that, because he's the referee in this case. He's going to be calling balls and strikes. He's going to be telling us what the law is. And when one of the parties has an objection, he's going to say whether you're right or whether you're wrong. And because there are rules in this courtroom, ladies and gentlemen, the rules are officiated by the judge to make sure that we maintain the rules and decorum in this courtroom and the evidence is presented to you in the proper way. But the most important people in this room, ladies and gentlemen, are you. As the judge said, you're the triers of fact. You decide what the facts are. And the great thing about serving as a juror is that you don't leave your common sense at the door. You get to bring it with you in here. And you get to listen to the testimony that'll come right from this chair right here. And you get to look at the evidence that's presented in your deliberations. You can see it along the way of how this case progresses. You'll hear different kinds of evidence. So Judge said, you hear direct evidence and circumstantial evidence. They're both very powerful pieces of evidence. They can be used in any way in which you accept them. Direct evidence is simple. It's something that somebody can see, taste, or smell, something that they see. If you see somebody commit a violent crime, that's direct evidence that they saw that person there. Circumstantial evidence could be just as powerful. For example, if you look outside before you go to bed and you see your lawn nice and green, and you wake up and it's covered in snow and there are footprints walking through the snow, well, you know that somebody walked through your yard from the time you went to bed and the time you woke up. You don't know who it is, but you know somebody did because you can see footprints. You can derive information from that to form a logical conclusion. Another good example of circumstantial evidence is DNA evidence. If you have DNA in a certain location, you can derive that that person was at that location at that particular time, even though no one may be testified that they actually saw him there, but the DNA shows that he was or she was there at a particular time. It's very powerful circumstantial evidence. So, ladies and gentlemen, this case is about the murder of Christina Parcell. And the state intends to prove that Zachary Hughes did, in fact, murder Christina Parcell. You have a number of charges that you're going to be deliberating on. You have harassment charges, you have a burglary first-degree charge, and you have a murder charge. Harassment is basically doing something that would intrude into the personal life of somebody, causing mental anguish. Burglary first degree means you went into somebody's home for the purpose of committing a violent crime. And then, of course, murder is an angry heart. We have to show that Zach Hughes had an angry heart. He was mad. And you can derive that information from any of the testimony, any of the evidence that we have that we present to you. So in this case, ladies and gentlemen, you're going to hear about a number of characters. The main character is Christina Parcell. She was murdered on October 13th, 2021. And she was living in the Canebrake neighborhood with her sister, Tina Parcell, and Christina's daughter, Aida Mello. They were living in that neighborhood in a house in Canebrake. And Christina Parcell had been going through a very tremendous child custody dispute with John Mello since Aida was 3 years old. At the time, Aida was 9. For almost 6 years, they had been battling custody over Aida Mello. And that custody dispute raised to a certain level beginning in October of 2020 when John Mello and Aida Mello went to Italy. And John took Ida Mello to Italy, and Christina fought to get her back. And in April of 2021, Christina obtained Ida's custody. And they came back from Italy, and that's how they ended up living in the Canebrake neighborhood. So the question is, how did Zach Hughes become involved in this case? Well, Zach Hughes had a relationship with John Mello starting in about October of 2020, around the time when he left for Italy. And that relationship grew. And it grew to the point where Zach Hughes began inserting himself into this custody battle at the behest of John Mello. And they began doing things like sending photos of her to the neighbors in an effort to shame her, an effort to show that she's a bad mother. And as the custody dispute it elevated into a situation where custody might not go in John Mello's favor. And at that point, Zach Hughes made the ultimate decision. Ladies and gentlemen, I hold in my hand the indictments from the grand jury charging Zach Hughes with harassment and burglary first and murder. And the grand jury true bill of these cases that came out, and these are the charging documents. And while the defendant at this point in this case is certainly clothed in innocence, once you hear the evidence from that chair, you hear the evidence that's presented to you, you're going to find beyond a reasonable doubt, and the evidence will show that Zach Hughes is a cold-blooded killer. And he committed murder, he committed harassment, and he committed burglary first. Thank you.
Thank you. I'm making the court defense is going to defer opening until our case. Thank you. Which is your right.
Stay. All right, Your Honor. The state calls Sarah Young.
Please place your left hand on the Bible. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. Please state your name for the record.
Sarah Young,
Ms. Young, who are you employed?
the Greenville County Sheriff's Office.
And what do you do for the Greenville County Sheriff's Office?
I'm the 911 tape research analyst.
And what is a 911 tape research analyst?
Essentially, we pull 911 calls for the solicitor's office and the officers.
And so how does 911 operate?
Essentially, when a 911 call comes into dispatch, dispatch determines whether or not which agency the caller is needing. So whether or not they need police, fire, EMS, they'll get information from the caller and they'll transfer them to the proper agency.
And are the calls recorded?
Yes.
And when do they begin recording the call?
Automatically. As soon as someone calls in a 911, it automatically starts recording.
So while it's ringing on, say, the caller's side, it's recording on your side?
Yes, sir.
Is that fair? And do y'all maintain all of those records?
Yes, sir.
Inside the 911 office?
Yes, sir.
And are those records kept in the ordinary course of business?
Yes, sir.
Okay. I'm going to show you. I'm going to show you what's been marked as State's Exhibit number 7 and ask if you recognize that.
Yes, sir, I do.
Are those your initials on there?
Yes, sir.
All right. And what is this?
That is a recording of the 911 call.
All right. I'm recording. This is a recording of a 911 call on October 13th, 2021.
Yes, sir.
And you have your records up there.
Yes, sir.
To help you remember.
Yes, sir.
It was a long time ago, wasn't it?
That was.
So do you know about what time this call came in?
The call came in at 11 a.m.
At 11 a.m.?
Yes, sir.
And do you know what number called it?
Yes, sir.
What number called it?
The number we have recorded is 864-436-2499.
And do you know who was calling? Does it tell you?
The caller did not give his name.
Did not give his name.
No.
And do you know what address that it was calling for?
Yes, sir. The address provided was 122 Canebrake Drive.
Do you know if that's in Greenville County?
Yes, sir.
Your Honor, State moves Exhibit 7 into evidence.
Good, no objection, Your Honor.
Objection, State's number 7 comes into evidence.
Now, the State will have to publish it.
911, what's the address of your emergency?
122 Cambridge Drive.
Thank you, police, fire, EMS.
I'm sorry, I think I might have a death.
Okay, let me connect you.
Walked in my fiance's house, she wouldn't answer my call, there's a very weird smell, I can't get her to come around.
Okay, let me,
Laid all over the floor.
let me connect you to EMS, sir. Hold on just a moment.
All right.
EMS fire, what's the address of the emergency?
122 Cambridge Drive.
122 Cambridge Drive, and what's another street for Cambridge Drive?
Southeast Drive.
Okay, in Greer?
Yes.
All right, the phone number you're calling,
I'm sorry.
the phone number you're calling from?
864-436-2499.
864-436-2499. Has anyone testified this COVID-19 or this COVID-19 positive? No, thank you, assessment.
I just walked in, I can't reach my fiance, I couldn't get back to her, she couldn't go there. I smelled some weird smell, and I just flat out on the floor.
Okay, you smell a weird smell and she's flat on the floor?
Yes.
Okay, just one
I
moment.
went to the finger, my left finger.
Is she breathing?
No.
Okay, then we need to get her, turn her over, make sure she's flat on her back, nothing under her neck. You have something to put over her nose and mouth, and we're gonna start CPR, sir.
Okay, I think she's gone.
You said she's gone?
Yeah.
Okay, and what makes you think she's gone?
What about the thing with the CPR?
I'm sorry.
What else do I do? I don't
Well,
want
we're gonna put flat on her back, and then I'm gonna walk you through the steps to do that. If you think that she's, able to do the CPR, then we can. I have no problem walking you through that.
Looks like it's burning all over. Looks like there's
There's
something
brain matter everywhere?
Looks like it's a thing that's shocking out. I don't know.
Somebody has shot her? Okay, all right. All right, do you picture that she's, not viable?
I don't know.
Okay, so look, so tell me, and tell me why you think she's dead.
So she went to phone,
Eyes are open? Okay, all right,
there's a lot of blood.
and a lot of blood, okay.
Anyway, the phone, something like a tongue here.
Uh-huh,
It's so loud when I thought it was in the hallway.
okay,
But the smell is very,
okay. All right, give me just a moment here, sir, give me just a moment. So it looks like somebody may have broke in and shot her in the head.
me, I don't know.
Okay, I understand. Okay, I'm sorry, say it again. I've got some people coming, sir. Do you see anybody, still nearby, an assailant or anything? No?
No.
All right. The front door was locked? Okay.
After the one I walked on, you were finding my car.
Yes.
So I came over, and then I came down, I smelled this weird smell.
Right.
And I walked in, I could see there's like a red store.
Yes. Okay, I have everybody coming. I'm sending the paramedics to help now. Stay on the line. I'll say exactly what to do next. Make sure to not, move anything, leave everything as it is.
Yeah.
And, if you can, go ahead and step out of the house and that way, wait for the, paramedics and the police at the front of it. Yeah, I would go back out the way you came to, keep the scene as it is. And then if they want to go through the front when they get there, then they'll let you know, but I go back out the same way that you came in. And leave everything as you found it. Yeah, okay, leave it, just however it is right now, just walk out, you can let them know you didn't know if you turned it on or off, but just leave it as it is right this moment.
The something really, really good smell.
Oh, really weird.
Yeah, something like that. Chemical.
Like a gas or a chemical? More like a gas smell?
No, it's more like something with pesticide.
A pesticide scent smell? Okay.
Yeah.
All right, go ahead and get out the door and go to the front and wait for them at the front, of the house. Leave everything as it is. Is there anything else that I can do for you, sir?
No.
All right, I've got them all coming.
Okay.
All right, thank you. Sir, this is the sheriff's office.
Is that the recording you retrieved from 911?
Yes, sir.
Answer any questions, defense counsel may have.
Cross-examination. No questions, Your Honor. Thank you.
All right, John, you stay. No, we asked the witness to be excused. They be excused. You know, the state would call Deputy Chris Robinson.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record.
Chris Robinson,
With whom are you employed?
Greenville County Sheriff's Office,
And what is your current rank?
Master Deputy.
Master Deputy. And what do you do for the Greenville County Sheriff's Office?
Currently on uniform patrol.
And what does that entail?
Answer your day-to-day calls, 911 calls,
How long have you been with the department?
10 years.
I'm going to refer you back to October 13th of 2021. Do you remember getting a call to the Canebrake neighborhood?
I do.
Okay. How did you get that call?
It was just a call for service at the time. Someone called 911 and I responded to that address.
Where were you located when you got that call?
Pelham Road at the QT.
How far away is that to the Canebrake?
A couple miles, maybe.
How long did it take you to get there?
Just a few minutes.
Now, did you go with your blue lights on, or did you
Absolutely. Just for the nature of the call, yeah, we responded, lights and siren.
So what address did you arrive to? Do you remember?
I'm not 100% the
122 Canebrake?
That would be it, yes.
And so what happened when you got there?
So once I arrived on scene, I made contact with the complainant, Mr. Post. He was standing in the driveway. I was kind of briefly spoke to him, trying to figure out kind of what was going on. He told me that he arrived home or arrived to the victim's address when she wasn't answering her phone. So he said he went in the back door, it was unlocked, and that's where he located her. So at that point, another deputy arrived on scene. So we decided to go in there and clear. We went in the back door. He said it was unlocked. They always leave it unlocked. So that's the way we made entry. Went inside immediately. As soon as we got inside, immediately smelled some kind of chemical odor. It was kind of unusual. We weren't 100% sure what it was. I could never figure it out, but we cleared the residence. I located Ms. Parcell in the living room. There was blood all over the floor. Looked like there was drag marks on the floor where she was had been drugged by her feet or drugged somehow. She had multiple lacerations around her upper, her face, her neck area.
All right, I'm going to stop right there. I'm going to take you back a little bit. Now, when you get out of your car, did you walk down the driveway?
Yes, sir.
And what cars were parked there?
There were two cars in the driveway. They were kind of parked on one behind the other. One, I think it was a Mercedes, was the back one. I don't remember which one the first one was.
And where did you encounter Mr. Post?
He was in front of the first car closest to the house.
And then that's where you obtained some information from him about what was going on?
Correct. Like I said, the basic information about, or he came home and he couldn't get her on the phone, so that's why he showed up.
And so your next item to do was to clear the house?
Correct.
And did you do that alone, or do you?
No, Master Deputy Brookshire was there. He went inside with me. We did it together because we didn't know what was inside or who else was inside.
So at that point, you have no idea what you're walking into?
Correct.
Is that standard procedure to have two individuals clear the house?
Yes, sir.
And did y'all in fact go and clear the house in this case?
We did. We cleared the entire house. Didn't find anyone else inside besides Ms. Parcell.
Were you wearing a body camera?
I was.
And was it functioning properly?
Correct.
That day?
It was.
Have you reviewed that body camera?
I have.
Okay. I'm going to show you what's been marked as State's Exhibit A and see if you recognize that.
Yes, sir. That has my body camera on it. I signed it there.
Those your initials right there?
Yes, sir.
Okay. So is this your body camera that you were wearing that day?
Yes, sir.
When you made a call to 122 Canebrake?
Yes, sir.
Your Honor, State moves Exhibit 8 into evidence.
No objection, Your Honor.
Exhibit A comes into evidence.
All right. Master Deputy, I'm going to show you this body camera and we can start and stop it. I want you to kind of walk us through what you're doing and what you see as you're going through and you're clearing the scene with Officer Brookshire.
Yes.
So what is that there?
That's us arriving on scene, or me arriving on scene to 122 Canebrake.
All right, and so is that the first time you saw this location?
Yes, sir.
And are those the two cars right there that you can see the silver one in the front?
Correct. Yes, sir.
And there was a red one behind it, I believe. All right. Is that where you encountered Mr. Post?
Yes, sir, initially.
And what is Mr. Post doing?
He was making a phone call. I'm not sure exactly who he was on the phone with. And we're just I'm getting basic information from him, kind of figured out what was going on, kind of what he saw, and what.
Are you gathering information from Mr. Post?
Yeah, just basic information, try to figure out exactly what we have.
Now, you have audio.
Yo, sorry, I was just checking something on a word on thing. I can't even say. Angela Boswell got arrested. I literally just found that out. I was like, oops. Right, Nightbot might kill me. So after her testified, Angela Boswell was arrested. She's in jail right now. Hang on, 1 second. I need to do something that Nightbot forgot to do. Sorry about that. You probably saw my trousers, but anyway. But yeah, and so it's I don't know why or what was wrong. All I know that she was on probation, right? No, she was on probation. Willows. So it says that because you can see in the inmate roster. So Thursday, February 13, 2025 at 3:50. Wow, how can we be at 3:55 p.m.? I don't know, but it says on the screen. Well, I can share the screen. You guys can see Boswell Angela, record details, and then there's the address, and then all the information. As to the status date, at 13 of the 2, 2025, 11:21 CST, and then the booked date was what? She literally is in jail, guys. She is in probation until 2026 because of smuggling drugs, I think, into jail or into prison, wherever she was. So literally she is. So the thing is, they can be together, mother and daughter can be together in jail. That is so cute. I don't know. It doesn't say why she is in jail, why she was booked, but you guys can see she was booked. She is in jail. That's wild. Sorry, I just had to bring you this breaking news of information that has happened. I guess we go back to the court, where we are speed trial apparently. So yeah, that is wild.
On your body camera, don't you?
Yes, sir.
All right. We're not playing the audio for these purposes.
Okay. So yeah, just basic information, trying to figure out, when was the last time he talked to her, things like that. I could see that he was, dressed nicely. He wasn't, there's nothing on him where there's been a struggle or anything like that too. So he didn't seem like he was in a hurry. So it seemed like she was deceased, just according to his body language, if that makes sense.
And so where are you going down here? The side of the house?
Yes, sir. He pointed us to the back. This is the back door. He said that that was always unlocked, and that's where he made entry. So this is where we decided to go because we knew that this door was more than likely unlocked. We had good access to the house.
So is this your first entry into the house?
Yes, sir.
Now, did Mr. Post tell you which door he entered into the house?
He did. He said he come in the back door because he said they always kept it unlocked. So, and that was the door that we decided to make.
So the door being open right there was not concerning to you?
No, because he already said he was already in it. He had already been through, and that's where he went in. So I'm just talking to Master Deputy Brookshire here. We're just kind of talking back and forth about what we see inside the house, kind of what each other is going to do, kind of your primary job responsibility, and that's all standard.
And in clearing the house, what is the purpose of clearing a house?
One, to secure any kind of evidence, and also make sure there's no one else inside, maybe no other victims or the suspect as well.
So where is Deputy Brookshire?
He's to my right. He's holding on. There's a hallway on the right side of the
And
house.
so where did you just see right there?
Miss Parcells' body.
Okay, so that was the room where you found Christina Parcell?
Correct, in the front living room area.
And y'all continue to search the house for any suspects?
Yes, sir. We're just continuing to clear. I had him hold the hallway, and I kind of just moved up and cleared kind of behind him up to him. And then we started clearing the bedrooms down the hallway. We're just sitting there just kind of talking our way through this, kind of, hey, what do you see?
And are you conscious not to disturb any part of the crime scene as well, as best you can?
Correct. Try not to touch anything. Obviously, opening the doors or whatnot, we kind of have to push them open. But we're not kind of rummaging through anything or opening any drawers, or we're just looking for humans at this point. So the big areas where somebody could hide.
Y'all just continue to clear the house?
Yes, sir. I believe that was the last bedroom that we cleared at that point. I believe I come out, we secure the house so nobody goes in or out.
Now, are you corresponding with other officers outside the house as well about what's going on? Or are you reporting back to anybody?
Talking on the radio, just kind of letting them know what we have at this point, getting a supervisor on the way. They always respond to these kind of incidents.
And is that the front door right there to your right?
Yes, sir.
That's not the door you entered into?
No, sir. That's the front door to the residence that leads into the front living room area that Ms. Parcell was located in. At this point, I'm just checking to make sure there's no signs of life. If we need to render any kind of medical aid. Looking for any kind of weapons to make sure it wouldn't, she did it to harm herself too.
And then now are y'all exiting?
The back door.
The back door? So did you cut your body camera off about that time? Let me ask you this. That's about when you finished clearing the house?
Correct.
All right. Your body camera still continues to operate?
Correct.
Do you remember what you did after you cleared the house?
Went back and talked to Mr. Post, got some basic information, names, kind of the last time he spoke with her, things like that. And just waited on everybody else to show up.
Did y'all begin putting crime scene tape up?
Yes, sir.
Those
Just
kind of things.
Yes, sir. Just locking down the house, making sure nobody goes in or out, just to keep the crime scene preserved best we could.
And as far as Mr. Post is concerned, did he appear to have any blood on him, anything like that?
No, he was dressed pretty nicely that day. In a sports coat, nice slacks.
He'll just answer any questions. Please, Councilman.
All right, cross-examination. Yeah, please report. Just curious, Deputy Robinson, at the time this happened, were you a master deputy?
I was.
You talked a little bit about some of the comments Mr. Post made to you after you arrived on scene. You testified to that in direct examination. I want to talk about some of those comments. Master Deputy Robinson, isn't it true that roughly about a minute, 25 seconds in to your body camera, Mr. Post told you that he was there every day, or practically every day?
Objection, hearsay.
Your Honor, he's moved in the body camera. There was no exception as it relates to audio. The whole video and audio is in.
Overruled.
So, if I remember correctly, yeah, I mean, he says he's there often.
Isn't it true that roughly at about 12 minutes and 45 seconds in, somewhere in there, Mr. Post told you that he did not at that point feel comfortable continuing to talk to you? Do you remember that?
I do when I was asking questions.
And isn't it true that while you were talking to him, he directed you to another deputy, a Deputy Dan Bevel, who might know more about the situation? Is that true? Do you remember that? At about 13 minutes and 35 seconds in, roughly.
I believe that was with a different case.
But while you were there that day, isn't it true that Mr. Post directed you to Deputy Bevel as someone who might know more about this case? Is that true?
Not about this direct case, but I guess he's been involved with the victim before.
At some point, was Mr. Post placed in the back of a patrol car that day?
He was. He was the first one to find her, so standard procedure is to kind of detain him until investigators could arrive and speak with him.
And at the time, isn't it true that strike that. 1 second here. I don't have anything else.
Okay, thank you. You redirect. No redirection.
Thank you.
Your Honor, the state calls Bradley Post. Can counsel approach real quick?
Right. So while they do, or we can skip it. Megan's mom was arrested, but because she has outstanding warrants that was out for her arrest, and now she's in custody. So that is amazing. So now we're gonna go. We are already zooming in through this trial. We have literally in like an hour to go. So there is no news from the Megan side of things. Oh, this person is in jail. Uh-oh.
Place your left hand on the Bible, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record.
Bradley Post.
Good afternoon, Mr. Post. Where do you currently reside?
Greenville County Detention Center.
And have you been charged with a crime?
Yes.
Do you know the victim in this case, Christina Parcell?
Yes.
How do you know her?
We dated and were engaged on and off about 6 years.
And about when did y'all start dating?
2016.
And in 2016, where were y'all living?
I was living at my house in Rivoli Lane. She was living in her house or apartment. I don't remember what she had at the time.
Were you aware of a child custody dispute between Christina Parcell and John Mello?
Yes.
And was this custody dispute ongoing from 2016 up until 2021?
Yes.
And how were you involved in the child custody dispute?
I would listen to her talk. Sometimes I'd assist her to go to an attorney, whatever, but, she'd just tell me about what it was.
Was it contentious?
I'm not sure what you mean.
Was there a lot going on in it?
Yes.
Was John Mello fighting very hard from his perspective?
Yes.
And Christina was fighting as well?
Yes.
Now, do you know where Christina was living on October 13th, 2021?
On Canebrake Drive.
Is that 122 Canebrake?
Yes.
And do you know who was living at that house at that time?
Yes.
Who was living there?
Her sister and her daughter and her.
Okay, what is her sister's name?
Tina.
Tina Parcell?
Yes.
And did you have the occasion to go to that house?
Yes.
And would Christina Parcell go to your house on Rivoli Lane?
Yes, sometimes.
And what kind of car was Christina driving at that time?
Lexus.
And who owned that car?
It was mine.
All right. Did you offer her to be able to drive that car?
Yes.
And did Christina Parcell have a cell phone?
Yes.
And did you assist her with the payments on that cell phone?
She had actually 2 cell phones. She had her own sometimes and mine also. Yes.
Did y'all communicate?
Yes.
Between those 2 phones? Do you know about when Christina moved to Canebrake?
I would have to think about it. I'm thinking maybe April, May, somewhere in that time frame.
And did you have the occasion, as part of the child custody dispute, did Christina Parcell have to go to Italy?
Yes.
And do you know the circumstances surrounding why she would have to go to Italy to get her child? Can you tell the jury what your understanding of those circumstances were?
Mr. Mello kidnapped the daughter and left the country.
And do you know about when that was? If you can't remember, it's not.
It was probably 6 months before April.
Okay.
Whatever that works out to be.
Okay. And as a result of that, what did Christina do? when Aida moved to Italy with John Mello?
She found out where he was located. She contacted her congressman and the State Department and the FBI.
And did she attempt to obtain the return of Aida back to the United States?
Yes,
How did she do that?
through the State Department. I think it was the Hague Agreement.
And did Christina actually fly over to Italy?
Yes,
Do you know how many times?
twice.
And were you assisting her and helping her throughout this process?
What do you mean?
Financially, were you helping her?
Some, but she was receiving contributions and reimbursements from those organizations that help women like that.
Women obtain the return of their children who've been
That's correct.
taken abroad.
Yes,
And so did you emotionally support her? Are you involved? Did she tell you what's going on?
yes.
And so do you remember did Christina ever get the return of her daughter?
Yes.
Do you remember when that was?
April, May timeframe of the year.
Of 2021?
Yes.
I'm going to take you back to October 13th of 2021. Do you remember that day?
I do.
Can you tell us what you did that day starting in the morning?
Well, she had a job interview and
She is Christina Parcells?
yes, Christina Parcell had a job interview. Typically, when she had something critical, I would call and try to make sure she was up. And she was. And then when she was driving to the interview, she called me and we talked for a while. And then she was a couple of minutes from her interview, and so she hung up.
As far as you know, did she go to that interview?
Yes.
And then when she was at that interview, what did you do?
Generic things, common things around the house, had to clean up and do laundry and dishes and things like that.
And then did you ever attempt to contact Christina?
Yes.
About when did you attempt to try and contact her?
I think it's around 11 o'clock, plus or minus somewhere in there.
And so how did you do that?
By phone?
And were you successful?
No.
So as a result of your unsuccessful attempt to contact her, what'd you do?
I thought I should probably go over and see how she's doing.
And did you do that?
I did.
How did you get there?
I drove my car,
What kind of car did you drive?
Mercedes.
Is it red?
Yes.
When you drove over there, where'd you park it?
In their driveway.
And when you arrived to 122 Canebrake, what did you do?
I went to the front door and rang the doorbell.
And were you able to enter?
No, she didn't answer.
So then what did you do?
I walked around the back door because frequently they'd leave the back door unlocked. And I walked into the back door.
This jury just saw the body camera of Chris Robinson. Did you see him go in the house?
See who?
Deputy Chris Robinson, the officer who you spoke to, the first person you spoke to on scene.
I may have, but I don't recall who he was because there were several people
And
there.
the door that he used, was it the door that you used to enter? Do you know what door he used?
I think they went through the front door. No, they might have gone to the back door. That's right.
And is that the door that you used to enter
Yes,
the house?
yes.
So you did enter the house?
Right. Again, I'm not sure whether it was the front door or the back door that they entered.
And so what did you do when you walked inside the house?
It was dark, quiet, and so I walked back to, down the hallway to see if she was in the bathroom or the shower, and it was all dark. And I looked on the floor, and right at the entrance of the living room and off that hallway, there were petals from like a rose. And as I looked into the room, and I saw her on her back.
And when you saw her on her back, was there a lot of blood around the room?
Yes.
What did you do?
I walked over.
Signed by the foreperson dated today. Right, because there's two, on the verdict form for each count, there's two options. So.
Because right here, this one, they did not find the aggravating factors. They can't go this one. This one, on the aggravating factors. Yeah. What was it? What was it?
I'm going to say, if you look at page where I have my signature, where I had to sign the instructions. The very last sentence says, take the case, consider all the evidence fairly and impartially, complete one of the two forms. I'm going to say yes, and then I'm going to say complete one of the two forms for each count.
That's good to me. Okay.
Sound good to you?
Be seated, court still in session.
Go make 2 copies. They need a copy of it, if you don't mind. I forgot to make y'all a copy. He's making it.
Sorry?
I forgot to make you each a copy.
I'm fine.
He went to make it.
Maybe she's been wanting to see.
I don't need a notebook. Well, yeah, I do. I gotta put it in there. All right, we'll have to bring the jury in and I'll read them this supplemental instruction to answer the question. And I have to staple the actual handwritten question to the back of the. All right, we can bring the jury in.
Everyone stand, please. May be seated, thank you.
Okay. Okay, supplemental instruction number 1. Members of the jury, each instruction to you or response by the court to any request from the jury is required to be reduced to writing. You are not to place undue emphasis on this response. This instruction should carefully be considered along with all previous instructions in light of and in harmony with the others. Question 1, quote, is it correct if we only use and sign one sheet per account? Question mark, end quote. Signed for person 2.
And another feed taken down. Hang on, bear with me while we try to find another feed. Yay! This is so awesome. This is crazy. Absolutely crazy. We keep having to jump around for feeds. Sorry, hang on, bear with me. There he is. See if this one. No, they don't have anything on this one. I was literally at just another channel. But I forgot which one it is. 1 second. Well, because I was trying to pay attention to the WLT, I think. No, I had another feed, but I decided, oh no, let's we don't need that one anymore. Ugh. Oh, found it. I found the channel. See if they are live. No. Well, that was fun for a moment. See if they are coming back again. No, and they have removed that one that we were watching. It's gone. So yeah, the question was, I think, was about the statement. That one, the victim impact statement that someone gave, but I was trying to pay attention to it. So I'm keeping a refresher. I'm gonna see if I can find any other feed. Otherwise, sorry guys, I might just give up and move on with our lives. We all know that she's gonna be in prison for a very, very long time, but it's being more difficult than actually is worth to give her this kind of attention and everything, because she had a time. She's serving a thing now. She can spend some time with mom, because her mom is also in jail, so they can all spend some quality family together. So it was just a question, so it's not the sentence yet. I'm gonna keep refreshing and keep watching the two feeds that I know that are possible doing it, but let's carry on with the new trial. If I hear anything, I'm gonna share with you guys. If not, we'll just move on.
Over and yelled at her and then called 911.
And when you called 911, what were you requesting?
I told them who I was and where I was, and we needed, I guess, an ambulance or and the police assistance.
At this time, on October 13th, did you know where John Nola was located?
I assumed he was in Italy.
All right. Mr. Post, I'm going to show you some envelopes. I'm going to refer you sort of back to around June of that same year, 2021. And I'm going to show you some envelopes and ask you if you recognize these envelopes. And I'm going to show you States Exhibits 1, 2, 3, 4, 5, and 6. I'm going to start with Exhibit 1. I want to make sure the jury can hear me, okay?
Yes.
I'm going to stand this way. I'm going to start with Exhibit 1. And do you recognize that document?
Yes.
Okay. Tell this jury about how you came in contact with this document.
It was mailed to me.
Say it again. I think
It was mailed to me.
Okay. And is your name on it?
Yes.
And the return address is a P.O. box. Whose P.O. box is that?
It's also my P.O. box.
And when about was it mailed to you? June 30th?
June 30th.
Okay. Did you receive other envelopes as well?
Yes.
Okay. Tell this jury about how that happened.
Be a little more specific.
So tell this jury you received an envelope. What did you do once you received it? And did you receive other envelopes? Question.
I received the envelope. I opened it because it was very suspicious, with my return address. And I looked at it, and then I called my attorney.
Why did you call your attorney?
Because the contents inside.
Can you describe the contents?
Yes, there were naked pictures of Miss Parcell. And if I remember right, there was a mailing list of which would kind of indicate that they were going to be sent also to those locations.
I'm going to show you States Exhibit 2. Is that a similar envelope as well?
Yes.
And did you open all these envelopes?
No, I did not.
On State's Exhibit 2, what is the address that it was mailed to?
It was mailed to me, but my name was misspelled.
And then I'm going to show you State's Exhibit 3,
Yes.
another envelope.
Yes,
And is it a similar envelope to the other ones that you received?
yes.
And what is the address on that?
I'm 24, it's 25, it was my neighbor's.
So 25 is your neighbor's house.
Yes,
I'm going to show you State's Exhibit 4. You recognize that envelope?
yes.
Where was that envelope?
It was sent to an establishment that I spent a lot of time with.
And what is the return address on there?
It's mine.
How did you obtain this one if it was sent to another establishment?
I had known since the very first one that others may be sent to people. And so since I knew the owner very well, I told him that he may be receiving an envelope with those dimensions. And I said, if he does, I'd appreciate a call back.
And State's Exhibit 5? Is that another envelope?
Yes,
And what is the address there?
my address.
And the return address is?
My P.O. box.
And State's Exhibit 6?
Yes,
What address is that one?
it's 22, which is another neighbor.
So after you received and collected all of these envelopes, what did you do with them?
I talked to my attorney and we set up a meeting.
All right. And after you talked to your attorney and set up a meeting, what did he suggest y'all do?
That we would meet with the county investigator, we did with Mr. Bevel, and also to talk to the post office since they were sent through the mail.
And did you in fact have that meeting with law enforcement?
Yes,
And what was the purpose of that meeting?
was to give them what we call evidence, or the things that we were sent, and ask them what we should do next.
And were you in essence filing a complaint with law enforcement for a potential crime?
I don't understand the question.
Were you going to law enforcement in an effort to give them evidence of a potential crime?
Yes,
And when you're meeting with law enforcement, you say Detective Daniel Bevel
Mhm.
and Mike Nicholson with the Postal Inspector's Office. Did you tell them how you obtained these items?
yes,
And did you discuss who you thought might send them?
yes.
And who did you tell law enforcement that might send these photos or had possession of these photos?
Well, we thought we knew who, of course, was behind them, but we weren't sure who sent them because he was supposedly out of the country.
So who did you tell the detectives had possession of those photos of Christina Parcell without any clothes on?
Mr. Mello?
That's John Mello,
Yes,
and that is who she was engaging in a child custody dispute with over Ida Mello?
yes.
Now, finally, Mr. Post, I'm going to ask you, have you ever met Zachary Hughes?
No,
Have you ever talked to Zachary Hughes?
no,
Have you ever corresponded him with, in any way, shape, or form, through email, social media, or the like?
no.
When was the first time you knew who Zachary Hughes was?
When my attorney,
sentencing in this case for May the 8th.
Judge, that is not good for me. I have a murder trial at Carter County the very next month.
It's not good. May the 16th.
I expect the Carter County murder trial. We've got 2 weeks blocked off.
May the 23rd.
Yes, sir, I'll be here.
Sentencing will be held May 23rd. Pre-sentence report needs to be filed no later than April the 15th.
Judge, you have May the 22nd. Instead of 23rd.
I do.
We'll use that instead.
We can.
Thank you.
That good with the state?
Yes, Judge.
All right, May 22nd. We'll say at 1:30.
Yes.
At 1:30 p.m. Report by the Department of Corrections be filed no later than April the 15th. All right. Anything else we need to take up?
Nothing else to say.
Mr. Horn?
Yes, Judge. I think from this point going forward, since Mr. Scotland's primary counsel in this case, I would make an oral motion to be relieved as co-counsel on behalf of Megan Boswell
All right.
going forward.
You'll be relieved. You were appearing as co-counsel pro bono.
Yes, Your Honor.
The court thanks you for your service.
I appreciate the opportunity. Thank you.
All right. Court will be recessed till Tuesday. We can. This for sentencing hearing.
We'll hear more from Judge Jim Goodwin once the jury is out of the courtroom there. We'll continue to watch and listen back in at this point.
All right. Ms. Boswell, in count one, the jury of your peers having set your punishment, you'll be sentenced to life imprisonment. In count two, you'll be sentenced to life imprisonment. In count three, you'll be sentenced to life imprisonment. We'll have to set this for sentencing hearing where we'll deal with merger, other issues, as well as sentencing in counts 4 through 20. Does she waive the 45 days, Mr. Scott?
She does.
Sentencing in this case for May the 8th.
Judge, that is not good for me. I have a murder trial at Carter County the very next month.
It's not good.
May the 16th.
I expect the Carter County murder trial. We've got 2 weeks blocked off.
May the 23rd.
Yes, sir, I'll be here.
Sentencing will be held May 23rd. Pre-sentence report needs to be filed no later than April the 15th.
Judge, you have May the 22nd. Instead of 23rd.
I do.
We'll use that instead.
We can.
Thank you.
That good with the state?
Yes, Judge.
All right, May 22nd. We'll say at 1:30.
Yes.
At 1:30 p.m. Report by the Department of Corrections be filed no later than April the 15th. All right. Anything else we need to take up?
Nothing else to say.
Mr. Horn?
Yes, Judge.
All right, so guys, now May 23rd, life with, I did not, so, understood that is life without the possibility of parole, but there's going to be a sentencing hearing on May 23rd. We will be there, and that is Megan Boswell done. She's gone. Goodbye, Megan. See you never in life. We're probably gonna hear from her. I am sure that she's gonna appeal her sentence, but that's it. That's case class. And finally, we did get justice for little Evelyn. Evelyn, please rest in peace. And that's the chapter concluded for Megan Boswell. Now, let's carry on with Zachary Hughes. Now, carrying on with this witness, that is the key witness for the prosecution. So it is actually quite interesting, the points that he's making, but we'll go over that later.
Said to me to come see me, and he showed me a picture and said this person was arrested for the murder.
For the murder of Christina Parcell.
That's correct.
And a couple more questions, Mr. Post. You and Christina Parcell were engaged.
Yes,
Did you give her a diamond ring?
I did.
Was she wearing it that day on October 13th, 2021?
Yes.
And on that day, did you provide her or give her any flowers the day before or that day?
No.
Didn't give her any roses or anything like that, did you?
No.
Mr. Post, if you could just answer any questions that the defense counsel asked for you.
Cross-examination.
Thank you.
So, Mr. Post, just first question, you just mentioned that you were engaged and that she was wearing the ring. Do you remember telling law enforcement on the day this happened that she wasn't wearing a ring?
No, I wouldn't say that.
Okay, you don't recall saying that?
No.
You remember, now you're saying you remember seeing her with the ring?
Yes.
Okay. You were also asked if you've been charged with a crime. It's actually 9 charges, is it not?
Correct.
Ask you about some background questions about yourself. So how old are you?
69,
What's your date of birth?
12856,
And where are you from?
Ohio,
When did you move to South Carolina?
July of, I think, 89.
What brought you to South Carolina?
Employment.
Are you married?
Was I married at the
Were you
time?
married?
Yes,
And how many times have you been married?
twice.
Do you have any children?
No.
How are you making a living in October of 2021?
I was retired, so I was from my investments and interest.
And also from selling a business?
Yes.
Okay. And did you make a lot of money from selling the business?
I don't know what your definition of a lot of money is.
What's your definition? I mean, did you have millions of dollars?
It's actually relevant, Your Honor.
All right, so when did you actually meet Christina Parcell?
I met her at her father's cigar shop. Gosh, I can't, 20 years prior.
And you actually dated for a period of time back then?
Again, that's the definition of date. Yes, we went to lunch or dinner, but it was only a couple of weeks and that was it.
And why did you all break up at that time?
It just, wasn't chemistry and we both had other things to do.
All right, and then you reconnected then in about 2016, isn't that right?
That's correct.
And you began dating again at that time?
Soon after.
Had you seen her much in the years between?
No.
Had you seen her at all?
Prior 10 years, no, I hadn't even hear her name.
And then you began dating at this time. Now, Parcell, Ms. Parcell had a daughter at that time, is that right?
That's correct.
You've already testified her name was Aida. Is that right?
That's correct.
And how old was Aida when they began dating?
I don't know if I defined it when I dating, but when I saw her for the first time in 2016, I think she was 3.
Okay. And she gave up custody of Aida shortly after y'all started dating?
I don't know the exact date, but she did change the custody arrangement.
And you at this time did not know Aida's father, John Mellon? Correct?
I knew of him because I was told, but no, prior to coming, no, I didn't.
Okay. Prior to meeting or getting back together with Ms. Parcell, you did not
Correct.
know Mr. Mellon? Okay. And did you break up during the period of time between 2016 and 2021?
Yes.
How many times would you say you broke up?
I really don't know many,
Okay, more than 5?
maybe not. Somewhere I never counted it.
And that was at least in part because of the turbulence that was caused by the custody battle between Ms. Parcell and John Mellon?
It was part of it because it was becoming front and center of her life, so it affected a lot.
Okay, but you would continue to get back together. There's multiple times you broke up.
Eventually, yes.
Yep. And how long had you lived at 24 Rivoli Lane?
7, 8 years.
And you mentioned Ms. Parcell and Aida were living with her sister, Tina, on Canebrake Drive.
That's correct.
Okay, where did they live before that?
There was an apartment off of Woodruff.
Okay, and the 3 lived together there too?
Yes.
And did you live with anyone at Rivoli Lane?
I don't understand the question.
Did anyone live with you
at Rivoli Lane?
No,
Lived there alone. Was it, I guess there was one exception that when Ms. Parcell moved in with you from October 20 until Ida returned?
she didn't really move in. She would stay with me because she always had a house or an apartment that was hers.
When did you and Ms. Parcell get engaged?
Honestly, don't remember.
And did you remember getting engaged at least the second time at the airport, is that right?
That's correct.
And that was when Ms. Parcell returned with Ida?
That's correct.
And there was quite a group around there when you got engaged, right?
That's correct.
Who all was there?
Friends, her parents. Some of the friends I knew, some of the friends I didn't.
Okay, and this was the Greenville-Spartanburg Airport?
That's correct.
Okay, when Ms. Parcell returned from Italy with Ida?
Yes.
You mentioned letting Ms. Parcell use your Lexus. You would help her financially in other ways as well, right?
She used my car when hers was broken, or she needed to get one because she had her own car.
And you would pay her credit card bill sometimes?
Sometimes.
You actually gave her a credit card of your own?
Yes, whenever she was buying for me and buying my groceries, yes.
Okay. Do you recall being able to have power of attorney over her bank account at the bank and travel address?
I don't recall giving power of attorney.
You don't recall having her power of attorney? over
I don't
that account?
recall it.
Okay. Now, you had a clone of her phone as well, correct?
That's correct.
So this phone that you had of hers would keep track of everything that was going on in her phone. In other words, it was an actual clone. You could see her incoming and outgoing emails and texts and all of that. Is that not right?
No, it wasn't an exact clone. There were certain applications that we could see, but it was mainly for her bills and to make sure that she got home at night.
Okay, but you mentioned also you would use an app called Life 360 to keep track of her too, right?
Yes, and that was on my phone.
Okay, so that was on your phone. That wasn't on the, so the clone phone was for keeping track of what she was doing with her.
It might have been, but I don't remember if it was on that one. Just like I said, she had two phones several times, hers and mine.
And what methods did you use to communicate back and forth by texting and that sort of thing?
Call, text, email.
Okay, do you remember what platform you would use to communicate?
At the end, we were using one called Signal, knowing that her future with Mr. Mello, there was something going to happen. And so we used Signal, which we didn't use very long because it was very difficult to use.
And you mentioned that Ms. Parcell gave up custody of Ida a few months after y'all started dating?
Yes,
And she gave up custody to John Mello?
that's correct.
And then at some point, she changed her mind and decided she wanted custody, correct?
Yes.
And around how old was Ida when she did that?
When she turned over the custody,
No, when I think you already told us that Ida was 3 or 4, I think 3 when she gave up custody.
yes,
How old was Ida when she tried to get custody back?
I don't recall.
Was it years, months after she gave up custody?
I don't recall the time. I just remember the instances that caused her to do it.
Okay, and that was because of her contentious relationship with Mr. Mello?
Yes.
Now, when John Mello took Aida to Italy, testified somewhat about that already, but that was around October of 2020, correct?
I think so, but I'm
Does
not
that sound
sure.
right? I'm sorry, I didn't mean to talk over you. Does October 2020 sound right?
Yeah, I'd have to get a calendar and work backwards, but yeah.
And you mentioned that when she finally came back, it was in April
Yes.
of 21.
Yes.
And they were in the Canebrake house at that point?
No, I think they were in the apartment and then moved to the Cambridge house almost immediately.
Okay. Now, you used the term kidnap. You are aware that John Mello was exonerated for that,
Afterwards,
right?
but not when he was there. He was found guilty by Italy, the state of Italy, and had to return her.
Okay, well, maybe we're using distinctions here, but he was found to have to give her over to Christina, but he wasn't found guilty of any crimes.
That I don't know.
He didn't go to jail.
That I don't know.
Okay. But when he came back here, you were aware that he was exonerated for taking Aida to Italy, right?
After Miss Purcell was dead, yes.
Okay, well, that has nothing to do with it. He was
Has
exonerated.
everything to do with it.
He was exonerated for having taken Aida to Italy because he had custody of Aida. Isn't that true?
Ask your question again.
Your Honor, objections outside the scope of his knowledge.
This is what they were asking for. So John Mello had custody of Aida when he took her to Italy.
Yes. But that didn't mean she could be taken out of the country without the mother knowing.
Okay, well, you know, the court's exonerated him for that.
But you know that the Hague Agreement returned her.
Well, I'm talking about in South Carolina. So for him taking Aida to Italy, since he had custody, he was exonerated for having taken her to Italy.
Eventually, yes.
Okay. And when he took her to Italy, you and Ms. Parcell spent some time trying to find where they were by looking at Facebook and Google and things like that. Is that right?
The context of what you're saying, I don't agree with, but yes, it was quickly found where he was.
Okay. Well, you can explain the answer if you need to.
Mr. Mello likes to use Facebook, and he posted a picture of his daughter to kind of show off that he had her in Italy. In the background, there was a poster that showed where he was.
Okay. And then at that point is when Ms. Parcell took all the steps that you talked about trying to get her to go back. Correct?
Correct.
And you did mention that you helped her with that.
When I could.
And you were helping pay her legal bills. And I know you had an agreement where she was going to eventually pay you back, but you were giving her money for attorneys.
Sometimes when she needed it because she was working.
Okay. She made 2 trips to Italy, isn't that right?
That's correct.
And the first time she was gone a couple of weeks,
I don't recall being that long, but it was more than a week.
and Lutina, her sister, went with her the first time.
Yes,
And then the second time she went back by herself,
correct.
and that's when she returned with Aida, and then you proposed to her.
Yes.
Okay, now, I want to ask you a little bit about the packages. So, State's Exhibit number 1 is the one that's dated the 30th of June of 2021. And that's the first one that you received, is that right?
I think so. I just have to look at the dates, but yes, the earliest.
Okay. This was mailed to your house. And there also were some that were mailed to other locations, but intended for you. Is that right?
I don't think it was immediately, no. That was sent like a warning.
Okay. Well, that was sent first, but where was the other one sent that was intended for you?
To my neighbors and to a place that I frequented.
Okay. And that was a cigar bar called Outlands?
Yes.
The contents of that have been described, you described as some photographs of Ms. Parcell.
Yes.
And you said they were naked photographs, right?
Yes.
Do you recall any of the other materials that were in there?
I think there was like a potential mailing list of where else it was being sent, like a threat.
And do you recall one of the pieces of paper that was sent to you being a website purportedly from her?
I don't recall it was there, but I was shown that it was.
Okay. And it's a website labeled Escort Advertising and Discussion?
I don't know.
Did you not look at it at that time?
I don't recall, no.
Okay. Were you aware of all of this about her past when,
What are you referring to past? It was the pictures that Mr. Mello had taken that they were using.
we're talking about the website.
Same thing on the website. I was told it was the same pictures.
That was what you were told.
That's what I was told.
Okay. Well, the website doesn't have pictures associated with it, right?
I don't know.
Okay, did you read the contents of it?
No.
Why did you not read those? Why did you not read the information that was in the package that was sent?
Because I knew it was a threat. He was constantly trying to separate us and get me to not assist her.
One moment, please. I mean, we approach it. Sure.
And we can skip this part. But the thing is, don't forget, guys, tomorrow, I think I'm going to be okay in terms of time because of the new internet that is coming tomorrow. But I'll reiterate at the end of the live stream. But we are going to be catching up anyway, so we can skip breaks and go a bit faster. So we might be able even to finish day 2 tomorrow.
Nothing from the state, Your Honor.
This witness may step down.
May I please record, we just want to have this witness remain under subpoena.
We have a subpoena?
Yes, sir.
No objection.
I did.
Please state your name for the record.
Jocelyn McInnes.
All right, Ms. McInnes, with whom are you employed?
Right now with Fetch Pet Insurance.
And what did you do back in October of 2021?
I was working at Valley Walk Animal Hospital as practice manager.
And what does a practice manager do?
Just manages day-to-day operations, hiring, firings, inventory, stuff like that.
And where is that practice located?
In Greer, South Carolina.
And on October 13th, 2021, did you have the occasion to interview Christina Parcell?
Yes, I did.
Do you know about what time she arrived and you interviewed her?
It was 8:30 that morning.
And how do you know that?
I did watch the video footage, verifying it, but I also had it on my calendar from back then to verify too.
So so the actual interview was interviewed from inside y'all's cameras?
Yes, it was.
And you went back and reviewed that video?
Yes, I did.
And so what time did Christina Parcell arrive to the veterinary clinic?
Right around 8:30
All right. And what was she interviewing for?
For a veterinary technician role.
And what does a vet technician do?
Basically like what a nurse does for a doctor, just draws blood, vaccines, stuff like that.
And about what time did that interview conclude?
She left at 8:47.
That's all I have for this witness.
Anything in cross?
Just very briefly, Ms. McInnes, is that right?
Yes.
Just a couple of questions for you. Was that a full-time position that she was interviewing for?
Yes, it was.
Okay. Were you aware that she was already employed?
Yes, I was at the time.
Okay.
That was one of the questions I asked her.
Okay. Do you know why she was looking for another job?
I didn't ask her that.
Okay. But it was a full-time position that she was looking for.
Yes.
Fine. That's all I have. Thank you, Your Honor, and she can be released from subpoena. Anything else?
No, Your Honor.
We are going to stop and have a lunch break, and I'm going to ask for y'all to return at 2:00. I told you I'm going to be a broken record, but just like I said yesterday, you are prohibited from watching any TV coverage of this trial, doing any kind of investigation, any research of anyone involved in this case by any means. You're not to look at any social media. I told you yesterday, if you've got notifications on your phone, hopefully you've turned those off, but please do so. And I just respectfully ask that. As I told you, I am going to.
Theory, he could run those consecutive and he could stack that.
Reasonable that is. You all get to urge him to do in
We
your
do.
sentencing report?
We do. There'll be a sentencing report and then we'll have a sentencing hearing. That's what's set the end of May, and then we'll go from there. Both sides will have a chance to argue what her sentence should be on those.
Do you know how many years she looks at for those additional charges too?
Yes, the false reports should be looking at 2 to 4 years on those. The tampering charge will be 3 to 6, and I think the abuse of a corpse and the failure to report are both 1 to 2 years on those.
I know that law enforcement, even one of the agents or one of the people who testified said that everyone else was ruled out, including Hunter Wood. But clearly, whether it was in the community or certainly on the defense's strategy, that was an if that they wanted to put out there. How important were those text messages that you guys were able to put up, showing what was going on, what apparently was going on, at least in Hunter Wood's mind, as this child was now known to be missing?
All right, you want to comment?
I think they're very, very important. I don't know how you can overcome that in my mind. When we found those, I don't know there's an explanation, for them.
Was there anything else y'all want us to know? I know it's been a very long, almost 2 weeks.
Well, like I said before, I mean, I think, if the community ever had any doubt about how hard law enforcement works, I hope they had a chance to see that in action in this trial, because like I said, you really could not have asked for any more diligent, exhausting efforts than what we saw from, our local law enforcement here at the Sullivan County Sheriff's Office, TBI, FBI. I mean, it truly was a coordinated effort.
Is this the first time in a while too? I know that the judge mentioned it, but for you all, that a jury has been sequestered?
It was. I don't know that I was part of the last one, but I know it's been about 20 years since the last time we sequestered a jury. So, anything else?
Thank you.
Oh, thank you all.
Thank you so much.
Sorry about that. I just noticed that was playing, and I thought of sharing at least a little bit, but that was the conference from the prosecutors and lead investigator from the Megan Boswell trial, and with that we can put a bow on it and leave it at that. So day one of the Zachary Hughes trial finished abruptly. I don't know what happened with the afternoon session, but I need to investigate and maybe possibly having to ask someone to do it, because we only have the morning part. They went to lunch and there was nothing on there. So I'm gonna have to see if I can get it somewhere else, because otherwise that's going to get slightly annoying because we're not going to see the afternoon part. But I need to reach out to another creator to see if I can use the stream to make sure it is okay. But yeah, so we did not, I don't think we had any counters today, but I think that will be it for today. Like I said, I was going to do a short one, but end up doing a longer version of one. But we did everything, which was good. We did the Megan Boswell verdict and the sentencing phase. And then we did as well the first day, or at least the first half of the first day of the new trial, and then tomorrow we can catch up the rest and go from there. But I thank you every single one of you. Don't forget, tomorrow we might be going live at 9 a.m. Eastern on time. If not, I will text. I will put on a community post on the channel because of the internet situation. But we should be good. We should be fine. But I'm gonna love you and leave you all here. I appreciate. Thank you very much for everything. Have a great day, afternoon, evening, wherever you are, and have an awesome day. And I'll see you tomorrow.